So good morning, everyone. I'm really pleased to have you with us today in the name of the whole organizing team here in Vienna and also in the name of the project. The project that is in charge of organizing this is a EU research project called Virtual Brain Cloud. We will explain and inform about this a little bit later, more in detail. My name is Niklas Forgo. I'm the principal investigator for the University of Vienna in this project. And as always, the PI has all the fun and other people have all the work. So my role in this is simply to say welcome to you and then to learn a lot from the speakers and to listen to you. But the organizational tasks were mainly taken care of by Michael, who is with us at the moment, and Catherine and Emily, who also are with us, and everything that goes in the way expected today is due to them, and everything which goes wrong is due to me. I apologize already now for all the glitches and all the errors that will certainly occur, because as you know, all these new formats are relatively new to most of us, and all of us are in a rather experimental phase so far. I would like to stress some very simple housekeeping rules here and explain a little bit about the format and what exactly we are doing here. So this is a Zoom webinar, meaning that the panelists are visible and can speak freely, whereas the audience can listen and can comment by text. That means that the general audience does not have the microphone and the camera activated, for two reasons. The first one is obviously technical one. There are all kinds of issues when people don't mute their microphones, etc. And the second one is also a legal one. You can listen to this and are not monitored in any way. If you want to speak and want to be visible, that's also possible. We would then authorize you on a person-by-person basis according to the request that you make in the chat. Everyone can comment and can ask questions in the FAQ section and also in the chat. So if you want to be visible and if you want to speak and you are not a panelist, kindly let the organizers know. We will make this possible on a case-by-case basis, obviously. But the main communication channel for everyone not being on the panel is text via chat and FAQs. We are streaming this in this moment on YouTube, but the link of YouTube is not made public. The only reason why we are doing this is that we want to keep the file, keep it recorded, and we record it via YouTube primarily. We will edit this after the conference and make this available. If one of the speakers is not fine with this and has not made us know this so far, this will be the very last moment to let us know in order to avoid the recording, of course, not the making public. And in parallel to this, I'm also storing this on my local hard disk here just to have a backup. Again, if you have an issue with being on this file, kindly let us know. We are only storing the videos and the audio, not the debate by itself. I mean the text-based debate. All this, as I said, is organized by the University of Vienna when it comes to the technical part of this. So if you have any issue and any question about the technical implementation, kindly address those questions to the Vienna team. Apart from this, we have a rather strict agenda, as you might have seen. So I kindly request from all the speakers to stick to the time plan. And I kindly request everyone for your understanding that we really will try to be on time with this whole, because different from a real world conference, people cannot adapt to the situation if they are displaced everywhere in the world, which means that we really need to be strict with the timing. Kindly understand this. Thank you for this. I think this is all from the housekeeping part. I would now, with your permission, hand over to Michael, whom you hopefully also see here. Michael will make the introductory moderation, and as I said, he's the one of those who really need to be praised for making this possible. Thank you, Michael. Please go ahead.
Yeah, thank you, Nicholas. Good morning from Vienna. I'm also very happy to welcome you to the GDPR Impact Conference as part of the VBC research project, the Horizon 2020 funded project. Together with my colleague, Emily Johnson, who is also on the screen, we will be moderating you through today's conference, where we will be moderating 2 sessions each. The Virtual Brain Cloud project is a project which goal is the development of a cloud-based platform for biomedical research and clinical decision-making that helps to improve early patient-specific diagnosis and treatment of neurodegenerative diseases, and has substantial potential for a significant socio-economic impact. Our task in this project is to develop basically robust solutions for legal matters, and together with Alzheimer Europe, also ethical matters, and to make sure in the end that the project is in line with data protection laws. We're also contact point in any legal matter as part of our role. As Nicola said, we were also assigned to host a conference on the impact of the GDPR on such projects. As you can see, or maybe you can see from the agenda, we will cover in this conference a variety of legal, ethical, societal, and scientific aspects, which affect the many dimensions such a research project like the VBC contains. The presentations will also show what issues a collaborative project like the VBC confronts, and will also point out the many legal issues we are always or every day addressing. To mention just a few, this includes privacy, security, discrimination, and self-determination. We will also hear about presentations from non-legal professionals like engineers, scientists, and other academics, for example, from the field of informatics, that highlight once more the need for an interdisciplinary approach when it comes to innovation through digitalization. We will hear about the patient's perspective, the use of digital doctors, machine learning-based medical applications, and the potential of health data being catalysts for innovations. By focusing on the GDPR, we will cover aspects of data protection by design and how this interacts with research progress, cybersecurity requirements, data protection standards when it comes to the use of artificial intelligence, data sharing issues, also in a comparative approach, for example, compared with the eBrain's infrastructure, and transparency obligations. With our other emphasis being artificial intelligence, we will also hear about regulatory, so policy approaches, bias and discrimination, and problems encountered in related research. All of this shows the vast nature of data protection and in the end also the far-reaching applicability of the GDPR. It furthermore reflects some of the everyday tasks that we deal with in these research projects, and depicts also the many questions or the open questions that still require discussion and clarity, both by academia and practice. In this way, it is our job to fill the gaps and foster research whilst protecting personal data. So once again, I would like to give you a warm welcome. And before I begin with the introduction, maybe some more details for Zoom. So the first thing for the speaker is that you will be moved from the audience in a moment to become panelists. Then we commence through your presentations. And once that is done, we'll start the discussion. And once the discussion is over, we will be moving you back to the audience, and then we have a break, and then the new session starts. And for the audience, we would kindly ask you to use the chat for technical issues or any other questions, and the Q&A session that you find on the bottom for questions relating to the discussion and to participate. And the other option for you to participate is to actively speak, where you will be recorded as well. And in order to do that, you need to raise your hands. And time permitting, we will try to make you a panelist. So we move you to become a panelist as long as your specific question is answered, and then we'll move you back to become audience. So once again, if you have any technical question, please use the chat. Okay, thank you. Our first session, and hello and welcome. Our first session deals with the topic privacy, data protection and ethics, the rise of new technologies in the healthcare sector. In the first presentation, we will be hearing from Professor Deepak Kalra. Professor Kalra studied medicine and holds a PhD in health informatics. He is president of the European Institute for Innovation through Health Data, an esteemed expert in this field with a special focus on the development of electronic health records. And he's also part of the Virtual Brain Cloud's Ethics Advisory Board. And he will be speaking about catalyzing innovations through health data. Is GDPR a blunt enough instrument? His presentation will be followed by Sabine Fähringer and Stefan Panic, who will give the second presentation about AI doctor, use of artificial intelligence in medical diagnosis. Ms. Fähringer studied law and economics in Vienna and holds a Master of Law from the London School of Economics. And Mr. Panic studied law in Vienna as well. They are both attorneys at law and admitted to the Vienna bar and work with DLA Piper, a global but also Vienna-based law firm. The third presentation about sharing and publishing human brain data through the eBrains research infrastructure will be given by Professor Jan Bioli. Professor Bioli is professor at the Institute of Basic Medical Sciences, University of Oslo in Norway. He's leader of the neuroinformatics platform of the Human Brain Project, and he's head of the Norwegian node of the International Neuroinformatics Coordinating Facility. He both holds a MD and PhD. The session will be closed by a presentation from Dr. Tanja Sinosic-Martinez about technology governance of the electronic patient record system, ELGA, in Austria, secret and exclusive or transparent and inclusive. Dr. Sinosic-Martinez is a researcher at the Austrian Academy of Sciences Institute of Technology Assessment. She holds a PhD and studied science and technology policy, economics, and environmental policy with academic stations in Sussex, Cambridge, and the LSE. Professor Deepak Kalra, I would kindly ask you for your presentation, and I will try to give you the rights to share the screen.
Okay.
So
tell me when you've done it.
I think it should work now. Maybe we can try it.
Oh, yes.
Yes, perfect.
Are you seeing my desktop?
Yes, it's
perfect.
Correct.
Okay. Well, good morning. Thank you, Michael. Thank you, Nicholas, for inviting me. One benefit of being the first speaker is that I can ask questions, but I might not have to answer them. And so I can maybe leave the rest of the day with some puzzles and difficulties that might be hard to answer. So let me begin by conveying what we're trying to achieve with an illustration. If we take as a disease diabetes and one of its major complications, which is chronic kidney disease, we have a challenge that a number of patients will develop chronic kidney disease. About 10% of patients do, but which 10%? What I'm describing here is a piece of research that was undertaken as a joint collaboration between two giants using a very large record database. I don't know the size of it, but I know they ended up with nearly 500,000 patients who had diabetes. From this, the analysis studied 300 clinical variables in order to help try to identify which of these, in which algorithmic format, could give rise to a predictor of those most likely to develop chronic kidney disease. The key thing to emphasize about this piece of research, which has been published and is going to be made open and exploited openly, is that it wasn't possible to discover this algorithm and validate it without a substantial data volume. And this is just a typical scenario of where we are today in healthcare, in medicine, in making advances. The opportunity space for us to do this is absolutely huge. There is more and more data available on more and more people. We have almost a concept of digital citizens, people who are existing in a digital space and whose data is potentially available for research and analysis. We are also seeing a growing interest in exciting architectures that can enable this without creating a massive central database. This is a slide example from the IMI Eden project, but I'm using it because it's really a typical example of how federated works, where the researcher does not have access to a massive central database of patient data, 500,000, 1 million, etc., but rather they author a research query, and the query is distributed by a central platform to a number of health environments that have made a portion of their data, whatever they're comfortable to have shared, is made available in a data warehouse. And the researcher only gets back the query results, the numeric profiling of patients who meet their criteria. And there is no transfer of massive amounts of data. That's a beneficial architecture, which is gaining ground. In reality, what we have is more of a hybrid model where there are sometimes central databases at some level. And what you have on this screen is a splash of logos, just to give you a taste of how many initiatives are working on building up some hybrid or fully federated model of how data can be combined at scale to take us forward. And maybe it would be cheeky or completely correct to put the virtual brain cloud somewhere in this space, where it's also working to help advance through data our understanding of neurological issues. However, what we have in practice is something of a spectrum of opportunities where we need to reuse data at the individual level as well as at higher levels of aggregation. This is where health systems and where our learning needs to be. At the level of the individual, at the single patient, there is a huge amount we can offer them if we leverage their own data better, possibly when combining it with the data of others. I'm not going to read through this bullet list, but you can scan it and you can see that there are many opportunities, some of which you know we're doing today, some of which you realize we're barely touching today, but they represent things we could now do. COVID-19 has highlighted the importance of reusing data for public health intelligence gathering purposes, but there are a whole series of things here in the middle that are reusing the data to help refine and improve health systems, public health systems. And of course, you probably all know the many areas, these are just illustrative of where we want to use data for research. So we do have some challenges though on this spectrum. And that is gaining public acceptance, because as we move from left to right, there is decreasing public understanding of why we're using the data and how the data are being used. The number of actors and the kind of actors that are involved in touching the data are increasingly unfamiliar to the data subjects. The use of the data and even the results of the data use are further and further away from the individual patient benefit. It takes longer to get those results, so it's harder to get human societal buy-in because it takes so long to prove that using the data is of value. And of course, people feel less and less empowered as these uses are further and further away from them. How do we trust? To give you an illustration of this, if you look at a survey undertaken just, I think, last year, a European survey looking at how people feel about trusting who can use and access their genetic information. I don't want you to study all of the bars, but just look at the dark purple and the light purple bars as you move from me personally knowing about my data through to trusting pharmaceutical companies. The distrust level goes up hugely. So we have quite a battle on our hands if we want society to really buy in to the uses of health data at scale to deliver new and exciting benefits. Now, it is difficult because Europe is not coherent in this area. These different infrastructures I showed you a few slides ago, they use different standards. They may define the data they're using with different languages. That means when they combine, sometimes topics like data minimization are hard to implement because everybody's described their data differently. They've got different uses, different terms, and so on. There are a huge number of public attitude surveys taking place. But unfortunately, when you look at those surveys, they vary hugely in how they word the questions. Sometimes when I look at them, I see really clumsy wording, and it's not surprising. They give you results that are very mixed and confusing. COVID-19 has on one level been an important catalyst for society understanding why we need to use data and learn from data, but people have been very forgiving in the COVID era, and we shouldn't assume that their forgiveness remains now a permanent new standard of societal acceptability. And these are some of the real challenges. When we mix with people across Europe who are trying to conduct research on data, what we find is that they struggle. We have on our side of the equation, if you like, on the data protection side, what appears to us to be very clear. There are a set of principles, and flashing up on screen, you see some interpretations of those principles as rules that you're all probably very familiar with. I'm not going to speak to this slide, but this is the instruction manual we give to researchers and say, please now go ahead. It's crystal clear. The GDPR has been developed through major consultations. All use cases have been taken on board. It's good to go. Please use it. But what we find in reality is that researchers, when they're trying to get permission to use the data, really do hit upon inconsistent views. When they want to use a data set for a different purpose, do they need to get consent again? How precisely can they explain the purpose of data use if they plan to reuse it? How minimal, how can they use, define the data they want if they want to cater for the future? What if they want to have updates? What if they would like to be able to get refreshers, but they really don't want to know who people are? Is there a way of anonymizing the data, including rather difficult to anonymize data, so they can get updates, but still treat the data as anonymous and not pseudonymized? What if there is a pressure for them to make some of their data open? Open data rules when it comes to data sets at individual level are difficult. There are words in GDPR that suggest, if you like, interpretation. How do we standardize across Europe what that means? When researchers are honorable, how can they prove they're honorable? What can we do to help them to really give confidence to the public and others that they are being good citizens when they use data? How can we prove it? And how can we detect when they're not? And then there are issues around the networking environment. The GDPR doesn't seem to cater for a network effect with data and data users. How do we apply it in these more complicated architectures? And the final call that we've been hearing a lot from industry, from public bodies, from patient organizations, is can we help Europe to be a level playing field? Can Europe really be homogeneous so that everybody who wants to make use of data can feel an equal citizen in that opportunity space? Now, the GDPR has a very hard line about whether data is personal or non-personal. If it's not personal, it's sort of out of scope. But we know from research undertaken, this is a photograph of citizens' juries undertaken in the north of England, where there was a deep dive with individuals in the public to help them understand data. Key message coming out of this: if it's anonymized, it's no longer personal. I still care. I still want to know how data are being used. I still care that the data are being used for appropriate, beneficial purposes. Don't think if you've anonymized it, I've lost interest. And that is something we've also seen in an initiative called Data Saves Lives, which is trying to help the public to understand how health data does make a difference. And this is a splash screen of a few example case studies that are online to help the public to see, even when data has been anonymized, that actually it can be used well, it can be used in a responsible way and deliver things that the public would say, yes, I would be happy if this is how data are being used. So this is really the message to give you, that we focus a lot on data protection and making sure that nobody's identified. But actually there is another side to the equation, which is how do we help society to be confident about data being used in the right way? There is no definitive blacklist, but I've worked with a few groups in recent years to try to pull up some examples of things where they say, yes, if there was a set of things that data are being used for that bring societal benefits, that's great. But are there some examples of things that we would all say no to? And this is a list. I'm not going to read you this list, but you can scan it and say, yeah, these are all things that if somebody said, I want to use the data for this purpose, most people would say no, don't do this. This is not acceptable. And we need to maybe consider whether we should be more transparent to the public about reasons why we shouldn't be using data and giving them assurances. These are things where any decision-making body would stop and say, no, you can't use data for these purposes. Is a list like this useful? I don't know. I'm really open-minded. Maybe in the panel discussion, we can debate that. There is no such closed list. There'll be an infinite list, but I wonder if it's useful. So where do we go from here? We've got this challenge that the data protection regulations are really all about the individual. And yet we know that clinical research needs to be using data on populations and delivering back to populations. We know that in general, if you ask the questions in the right way, patients are in favor of their data being used. But actually the GDPR and all of these gray areas have led to, at times, fear. And I was at a conference last week where a patient organization rep was saying that their members are finding that GDPR is breeding more fear in them than it is reassurance. How do we deliver transparency? These are the kind of questions that I feel we need to be exploring. Is there a balance between the individual and society that we need to tease out in more detail? And I would like, if I could, to close with a slide that is really my thought-provoking slide about whether we should be looking for a more balanced approach if we want to scale up how we use data. We do need to bring the public on board even before we start to define the rules. How is data used in ways that really do deliver value? And then from this, work out with them what actually are the elements of trust that would make them be confident and supportive of users, and what are the safeguards that will make them feel that their interests are being protected while society's interests are being advanced. From this, we need to then have ways of assuring our citizens, our patients, that the data have been used appropriately. And that means we need to have transparency in how the data was used, but also transparency in how the data was protected. And this then helps us to communicate benefits. And I just wonder, not sure myself, is this where the GDPR lives within this set of balancing forces? And does that result in us having a rather limited view on this landscape? Maybe we should not be looking at this through the GDPR window, but more broadly and holistically. That's where I close, and thank you very much for allowing me to present.
Thank you, Professor Kalra, for your very interesting and stimulating presentation. Maybe once again, we are having the discussion later on, so please.
Yes, that's fine. I think I need to stop sharing now.
Yes, please. Thank you.
Okay.
And now I would ask maybe Ms. Feringer or Mr. Panic, that one of you, if you want to share your screen.
Yeah, good morning, everybody, and thank you that we we are happy that we can also present our point of view to regarding artificial intelligence doctors and the use of artificial intelligence in the medical diagnosis. We start to present you the technology, what is artificial intelligence, what is state of the art, and any future developments. And afterwards, we are happy to provide you with some legal issues, legal impacts, specifically privacy issues involved, but also regulatory issues and even other questions and deliberations.
Right, so good morning from my side as well. Taking over to just briefly try to sum up first from the technological perspective what we are going to be talking about, and this will of course in no way be exhaustive or final, especially since after our research the results or the situation, the practice has shown that there is no real definition of an AI in this context. Anyway, there are various definitions, some of which you can see on the screen. In practice, what we have assessed for the purpose of this presentation and what we'll be talking about are problem-solving algorithms which use large amounts of data, so the big data applications, but also have the possibility to improve and learn from their own data processing. So these will be roughly the systems we have in mind. As concerns the present situation, our research has resulted in some very interesting results, namely that there are already tools which have been approved, especially in the United States, which can provide some very sophisticated diagnostic assessments and which equate or even outperform medical doctors. I have found, or we have found, multiple entries or reports that, especially in cases of cancer diagnostics, there are systems which already outperform medical doctors. As concerns the future, well, difficult to predict, of course, but I suppose only the sky is the limit. The systems will definitely improve. We have seen that in the past. Possibly we are even looking forward to systems which are completely autonomous, like true artificial intelligence we know from science fiction. In the near future, these will probably be the systems with some limited autonomy, but more robust and more enhanced diagnostic abilities, also including possibly some real-time monitoring systems which collect data from patients in real time and then provide diagnostics. With that, we can go to the core of our presentation, namely the legal issues, and back to Sabine for a brief overview over which we're going to be talking about.
Yeah. In fact, artificial intelligence is at present not really explicitly regulated. That means, so until now, we have just to apply the existing legal system to artificial intelligence and have to work with that. So, and the main issues that arise are, of course, data protection issues, privacy issues, but also very important regulatory issues, like, for example, in Austria, and I assume in many other countries, we have doctors' privilege of doctors to make diagnosis and treatment that cannot be replaced by a machine. But we also have regulatory issues relating to admission of artificial licensing of artificial intelligence systems in Austria, for example, under the Medical Products Act. We have liability issues that are still quite open and unsolved, but also questions: who owns the data, who owns the artificial intelligence? So many things are open, and specifically, we even expect that maybe new legal systems will be introduced, also driven by the specific situation at the moment to the pandemic. So I hand over again to Stefan, who presents the data privacy issues.
Thank you, Sabine. So going to the data protection part, which is, if not the central, then certainly one of the central questions when talking about algorithms and AI, especially in the health sector, and also kind of the topic of the conference. There are various issues arising here, and we will not be going into that much detail, but rather present a kind of bird's eye view on possible issues arising from the GDPR. So first, the obvious topic: how can patients' data be processed lawfully, so collect and process lawfully in the first place? In our experience dealing with the first AI systems we have been confronted with, there are two distinct issues here. On one side, the processing of data for the main purpose of the AI, in this case, collecting and processing for the diagnosis in a specific case. But then also beyond that, the AI lives and breathes on data, and just like humans, it gets better by practice. So in order to air quotes train it, you need a large amount of data for the AI to actually get better. So in this section, there is also a question or an issue: how can this data processing be done in a lawful manner? What are the sources of the data? Can the data from the first use case, namely the diagnosis, be used for the training as well? Under which requirements? Or can the AI even tap in some broader networks, taking larger amounts of data to actually be able to learn? Going to the first issue, the first matter. On a first glance, this is basically same or similar as the situation we have in the present when a patient is diagnosed by a medical doctor. So in that case, the doctor obviously also has to use patient's data as well. But looking more deeply, there are limitations in the GDPR which could limit the diagnosis even on this level by an AI. Both the letter H, which provides a legal basis for use for sensitive data for medical occupation diagnostic purposes, as well as the paragraph 3 of the same provision, limit or apparently limit this use of data actually to occupational medicine, respectively, to use by professionals. So already here we have the question whether the GDPR actually limits the use of data in this respect to use by medical professionals only. We'll be coming to this topic again concerning the regulatory issues. This is a question with which we have been confronted in the practice in other contexts as well. So I dare to say that in this particular respect, the GDPR is probably too restrictive and may need amending as it is anyway, and also for the future developments. Otherwise, there is of course always the possibility of obtaining a patient consent, but as always under the GDPR, a consent is usually very difficult to obtain. There are strict transparency requirements, other requirements, and in practice, it is usually recommendable not to rely on consent if possible, to rely on another legal basis. But going beyond the diagnosis, we actually have the other topic, namely the use of data for training purposes. In this case, the question is raised whether the data of diagnosed patient can be used for training as well. The question whether this change of purpose will be permissible and under which rules, and even if the GDPR provides a possibility for a change of purpose in this respect. A side note, a change of purpose in the GDPR is explicitly regulated in Article 6 for the non-sensitive data, but not in Article 9. Other questions whether the data from other sources can be used. Here in practice, and we have been confronted in other cases with this question already, the go-to solution was definitely to obtain consent. We have never been really able to find another solution which was legally sound and reliable, in the sense that it would be advisable to rely on it. As already mentioned, there are some in the previous presentation. This is a question which also is raised in case of use of data for research purposes. In Austria, for example, there are some legal bases in that respect, but it is very questionable whether training of an AI can be interpreted or classified as research. So again, in this respect, consent would probably be the fallback solution at the moment, at least. Another possible solution could be the anonymization, but in practice, at least, this was always presented with considerable technical difficulties to achieve full anonymization, at least if the GDPR is interpreted strictly in this respect. And then going beyond the lawfulness, just to skim on other two interesting topics, the international data transfers. This is not specific to data use in AI solutions, but it is also an aspect thereof. Whenever we have a big data and machine learning applications, they usually or often involve cloud solutions, which again, usually or often involve data transfers, basically worldwide. This is not a new topic, but its importance has increased severely now in the post-Schrems 2 era. But again, this is not an issue which is specific to AI solutions, and it's a problem which is acute and which is being dealt with by practitioners already. We have also had some legal developments or possible solutions in that respect. So this will be a topic which will be addressed shortly, or is being addressed in the moment anyway. But just to keep in mind also for the AI solutions, could be an issue in the future as well. And then last but not least, just to mention very briefly data security. In this respect, in particular, since the data in question are Article 9 data, air quotes, sensitive data, there will be so the data security requirements will be high. Additional data security requirements may or would likely apply as well. But in this particular respect, I dare to say that the question of the personal data security in particular might be consumed by the broader issue of cybersecurity and system security as well. Because here we do not just have the personal data that could be threatened, but also the entire algorithm. And I dare to say a personal data breach, in particular involving sensitive data, Article 9 data, health-related data, is bad enough. But if a doctor solution, an AI solution, which provides a real-time diagnosis, is hacked and the results are actually influenced by an outside party, this could be even worse. So again, I dare to say that the cybersecurity and the data security considerations here would actually be much broader than just personal data security. And with that, I can finalize my brief overview of the data privacy issue and can give back to Sabine, considering the regulatory questions.
Yeah. The profession of the medical doctors is heavily regulated, specifically in Austria by the Medical Doctors Act, and it basically says that any kind of examination, medical assessment, diagnosis, and treatment is completely reserved to the medical profession, to the doctors. But this also means that treatment, diagnosis cannot be done by a machine, cannot be replaced by a machine. And specifically, there is also a second requirement. The principle of directness and personal examination, which means that the doctors have to have direct contact with the patient, and whenever the physical contact between doctor and patient is necessary, not having this contact is a regulatory infringement of the Doctors Act, and actually this requirement has already been assessed now during the pandemic, as where we saw that it can be interpreted often quite leniently. For example, the meeting of the patient by means of telecommunications was examined as not an infringement of this principle of directness and personal examination. Specifically, it was shown because such meetings of patients were reimbursed by the social insurance systems. But having said that, the medical regulatory profession has to be very, very strict in complying, and specifically the use of algorithms by persons other than doctors has to be considered very strictly. Just maybe kind of assistance services like feeding the system with data, but any kind of evaluation of data is in the strict sphere of the doctors, of the medical profession. Another regulatory issue is the regulated medical products. The artificial intelligence tools are most likely all subject to the Medical Products Act, meaning that they have to be admitted to a specific procedures, and also complying with many obligations, being specific safety requirements, the prior clinical trials, but also the producers and the traders of such systems need a qualified trade license. And it has to be noted when using and applying this artificial intelligence systems, so far they are not subject to any kind of ethical questions. They are not considered in the deliberation to use them. The only area where ethical issues are considered is during the clinical trials, where as the clinical trials have also to be presented to the ethical commission, and where ethical issues are then considered. Well, in the end, other aspects that have to be considered, like black box issues. In reality, we do not really know what are the methods, what are the algorithms behind any systems, because this is usually a trade secret, not disclosed by the developers or producers of artificial intelligence, and thus meaning, on the other hand, it's very difficult to find mistakes, to evaluate mistakes, which leads to the next issue, the liability. Who is liable for mistakes of the system? Is it the programmer, or is it the operator, or are both liable? The issue arises, is this a case of product liability? Is this a case that artificial intelligence as such is a dangerous thing? So issues are still open. And of course, if there are mistakes in the programming, the programmer can be liable, but most probably also the doctor, also the operator can be found liable if he, in his general use of the system and general evaluation, diagnosis, completely relies on the system and does not really consider that there might be obvious mistakes. So in the end, most probably programmer and operator are liable, but very much depending on the situation as such. So here things are still quite open for the future, and also for, on the one hand, maybe legislator, but also open to the court decisions. And last but not least, finally, some considerations is will the use of artificial intelligence be subject to patient's consent or not subject to patient's consent? Will there be an obligatory information of patients, or also do the patients have possibility to object to the use of artificial intelligence? Also still open issues and open for discussions. So last words, many things are still quite open. Thank you very much.
Thank you very much for attention.
Thank you both for your presentation and for your insights in the practice. Professor Pioli, maybe you can start sharing your screen, and if you want, and start with your presentation.
Yes, thank you very much. So let's try the screen sharing.
Perfect.
Okay. So in my talk today, I will talk about trying to find practical solutions in the landscape we have just heard about in the previous talks. I will focus on the sharing and publication of human brain data to a research infrastructure that has been released and that we are continuing to build and expand. So the Human Brain Project is a so-called European Union flagship project with a 10-year funding perspective. We are building eBrains, the European research infrastructure for brain sciences and brain-inspired technologies. This was launched October last year, and we are now expanding it to a full-scale infrastructure, also to continue after 2023. So there are many countries in Europe involved in HPP. There are 7 involved in establishing the eBrains. We have an AOSPL, international non-profit organization based in Brussels, to take over the responsibility for eBrains. And the research infrastructure is found at ebrains.eu, that is the web portal, and it is distributed at various locations in Europe. So AI in HPP and eBrains. Well, taking a starting point in the EU high-level expert group on artificial intelligence, what I take out of it personally is maybe the 5 keywords at the bottom. You start with data, and preferably large amounts of data. There are analysis steps involved leading to interpretations, in turn giving us knowledge which result in action. And the AI are involved in several of these steps. My emphasis in this talk is on the left side here, on the data side, and actually on having data that one can say are less confusing or less mixed and more interpretable. So we find the key requirements the AI application should respect quite useful, and they are shown on the left side from the EU high-level expert group. What we're doing is shown on the right side. We have an HPP Society and Ethics activity in the project. They do a lot of very important things in this area. We have eBrains data governance with working groups and outcomes. eBrain's technical coordination, and data curation, including ethics compliance steps. So the research infrastructure, of course, is about scientific data collections, archives. It's about computing systems and all the tools and software around that, and the equipment and the instruments. We have 6 main categories of services in our infrastructure. One is on data and knowledge, the so-called FAIR, findable, accessible, interoperable, reusable data models. Brain atlases, medical informatics, brain modeling and simulation, closed loop AI and neurobotics, and interactive workflows on high performance computing and neuromorphic computing systems. So this is actually to some extent going from left to right, from the data all the way to the action. And the data part is key in organizing and managing large amounts of data. The atlases are key because they give data a location in the brain, which is as important in neuroscience and brain research as the geographical information systems are in other disciplines. The modeling and simulation, for example, also includes services like the virtual brain. They're also part of this. And when you build virtual or physical robots, which actually perform according to certain models of simulation, you are into the neurobotics. And to support the most advanced analysis and most compute intensive ones, we have different computing systems and even those systems that are actually brain inspired. So I will talk about primarily the data knowledge, FAIR data and models services. When it comes to human data, the personally identifiable data are not taken care of there, but in our medical informatics platform, which is about keeping the data, in this case, at hospitals. We have about 30 in Europe, not taking the data out, allowing researchers to perform analysis on data that they cannot really see themselves, but they get the results out. This is the federated approach, typically. So any personally identifiable data at the moment in our infrastructure is in this medical informatics domain. Then we have the pseudonymized data and the anonymous data. They are going into this data knowledge services, and I will try to explain what we mean by that. So we obviously need to have a framework both to be compatible with GDPR and legislations, and also to send a clear message that we are running a serious service, which meets the expectations of the society. So we have various terms of use, access policies, privacy policies, and not at least in this context, the data use agreement. These are shared, of course, on our web portal. And the data knowledge fair data service is actually, in a way, a kind of a centralized system because it allows researchers in Europe to submit data to not only one, but to a small cluster of HPC centers where the data is stored. There is long-term data storage. We make sure that the data are citable with DOIs, that there are licenses describing how you can use the package with metadata, and that there are metadata and descriptions that make the data findable and interpretable and reusable. Now, we must remember that in science in general, sharing is the new norm. And this is, of course, where we have to develop the solutions that makes it practical. It's important to give credits to the data provider, to greater exposure research, and also access to shared data assets to boost productivity, obviously. So in order to organize all the data, we have a knowledge graph, which takes care of all the different types of metadata and connect the pieces, so to say, in a very flexible way, which is quite different from classical relational databases. And this allows the system to grow and evolve over time. So this curation is a core part. Different clusters, if you like, or collections of data are going into curation, organized in the knowledge graph, connected to brain atlases and locations in the brain, and subject to various types of analysis, including with AI tools. So here are all the steps, starting with the request for curation on the left side, inside our project, but also from the outside, where one of the first steps is ethics, compliance, and permissions, meaning that before we can take any data in, we need to know what the situation is. This applies to all data, but to no focus on human data, obviously related to also the fact that institutions will have to approve that the data can go into this system. Then they're curated and go all the way to the right here, including the publication of the data. So the search engine have different types of access, but the simplest is the graphical user interface, where one can look up what we have in the system and of course do searches and filter and identify collections of data sets. At this point, there is about 1,000 researchers that have delivered various types of data, and some of these data sets are huge with thousands of files, and many of them, most of them are available. Some are embargoed until publication, and some are, as we'll see in the next slide, under review, meaning that we are preparing the solution for pseudonymized human data to be shared in a much stricter way. So in this system, the anonymized data, or sorry, not the anonymized, the anonymous data that cannot be traced back to individuals, they are shared if the permissions are in place to do this. The pseudonymized data will now be shared if they are strongly pseudonymized and the institutions agree to the sharing through the system. That will, what we are implementing now is a login layer where the researchers that have obtained a personal account in our system, they're identified personally. They have to agree to the conditions, which is our data use agreement, before they can have the access. Again, this is for strongly pseudonymized data, not for the lighter ones or those that are more easily identifiable. We're also building other solutions, but they are not yet available. So this allows us to also invite people to publish with data citations included in the publications. So for example, you have Nature scientific data, and you have data descriptors, which is the perfect format for these type of solutions, and in principle any journal. And it means that you can then not only cite other papers or your own papers, but you also cite specifically the data sets. This is the first example we had, which was before eBrains. So the name was Human Brain Project Informatics Platform. And you have a DOI, which actually points you directly to a so-called data card that gives you the metadata, that gives you an explanation of these data, a descriptor, and access to the data. And if these data would be human pseudonymized data, there would be a login, access control, and conditions have to be verified. So that was a little bit on this tour from data all the way to action. And our system is available at ebrains.eu, which is the entry point to a growing collections of tools and services, also from outside our own project. This is very much an externally oriented action. I'm looking very much forward to discussing the interesting aspects around what had been presented in the previous talks together with this, hopefully. Thank you very much.
Thank you, Professor Violi, for your presentation and about eBrains and the Human Brain Project. I guess we will be hearing about this in the discussion later on. Maybe Dr. Sinosic-Martinez, you would like to start sharing your screen, but Professor Violi, I think you have to end if that's possible. Thank you. Yeah, perfect. Thank you. So let's see. The Dr. Sinosic. Yes.
I'm not sure which button to press to share my screen.
Well, you find at the bottom.
Yes.
In the middle, it's this green arrow, or this arrow.
Okay.
Up. Yes. Yes, perfect.
Hello, thank you very much for the opportunity to present at this conference. My presentation is on offers a technology governance perspective on patient data, and I hope it will help understand some of the problems that were addressed in the previous presentations. So there are, as we all know, numerous examples in the digitalization of patient information in healthcare systems. A long time ago, the introduction of computers in doctors' offices, electronic patient ID cards, and digital sharing of diagnostic reports, diagnostic imaging, and telemedicine and telecare. And there are several very old debates on how this impacts the work of doctors and the patient experience, such as, for example, making physicians' work more difficult, increasing the risk of error, and the necessity for human input, which will always be necessary for the contextualization of digital data on patients. Electronic health platforms and systems such as the electronic patient record system, ELGA in Austria, is intended to go far beyond sectoral boundaries of health to social and elderly care, to people's homes via telecare and telemedicine, which connects previously separately financed and managed organizational entities and disconnected regions and federal states, which increases the complexity of the system as well as the uncertainty associated with the technological impacts on society. A really patient-centered system, of course, has the potential to support health and social care. What is perhaps new in the technological developments of the huge leaps in data processing that have occurred in recent decades is the scale of data protection and the increase in algorithmic decision-making, the dynamic expansion in applications and functions, and the increase in connections and thereby interdependencies between previously less connected sectors, services, and regions. However, given these opportunities, still not everything that is technically possible is also used by patients and clinicians. The implementations of these national information system programs is highly resource intensive, and very, very little opportunity is taken for genuinely democratic and responsible technology governance and implementation of these innovations. The debates on technology governance and the relationship between technology and society and societal impacts of technological change is not new, but there have been some recent contributions that have raised this issue again at the EU policy levels. I would like to start with the most famous example of the Collingridge dilemma, which highlights the problem of controlling technology at different stages of implementation. At the beginning, risks are unknown, and as well as the complexity of estimating impacts is not known. But by the time the innovation process has continued, control has been costly and slow because of technological lock-in and path dependencies that have arisen. The responsible innovation framework is one that has been most recently emphasized by von Schomburg and Owen and Stilgo and colleagues, which calls for an responsible process for informing technology governance, which will increase its societal resilience. And this is one of these approaches. Suggestions is through open and inclusive anticipation, reflection, and inclusion processes that increase the responsiveness of the innovation to societal needs and the solution of social problems. There are perhaps three main reasons why public health technology governance and societal impact are misaligned. One is the increasingly large health information systems that affect entire population sectors and regions, such as, for example, the electronic patient record implementation in Austria affects the entire population. All people have social health insurance. However, the decision-making for this process has been highly centralized and linear. The advances in data collection and algorithmic decision-making, again affecting entire populations, are characterized by secrecy, and the expansion of applications in different domains also remains relatively unquestioned, the dominant view being innovation is always good. Specifically for the ELGA case, the inclusion of laypersons and diverse stakeholders and users in the design process was limited to 2 or 3 meetings at the beginning of the implementation, which was perhaps in the first year. And the user interface evaluations were limited to asking users how user-friendly the software is. And these discussions were not planned as a regular part of the implementation process for the future. And one of the people who I interviewed who were central in implementing this system in Austria described these meetings as people were invited and they could ask questions. So it was these user exchanges are sort of framed as describing and informing rather than trying to understand the needs of patients and integrating these needs into the innovation process. A further point I would like to make is the linear way in which these complex technological systems are implemented. One of the actors I interviewed said that the process started with the formation of a committee of key persons, then a working group followed, then a legal entity was formed, and the conversations between these organizations and specialists and ministries were the main sources of dialogue to get okays for every step in the information process. A further interesting view was that in order to push forward this process at the beginning, a cost-benefit analysis was done in which was given a lot of weight, where benefit was considered to be equal to savings potential. So the benefit of the entire system was described as a savings potential. Of course, this is not the only view that was considered, but it was one that was very, very important. A further point I would like to make is that data collection and algorithmic decision-making in this process is the political vision that is used to inform the implementation of this system doesn't reflect the technological innovation, which affects the entire population now and for the future. And there is definitely a reduction in a reduced and narrow perspective of what these kinds of systems actually are and have the potential to be. In one interviewee's views, it is nothing more than the exchange of findings. And of course, it is much, much more than that. A further feature of the secrecy of ELGA implementation is that it was because of the formation of this ELGA company, the legal entity for the electronic patient record system in Austria. The algorithm itself was treated as a business secret. So there was no open discussion about the various decision points that are included in this algorithm or its testing in the broader community, which would have increased security and safety of the system. Finally, the expansion implications of these systems, they are considered to be something that needs to be pushed forward quite quickly, so that the people who are involved in its implementation, there's a difference between what is perhaps in this responsible innovation process relevant, which is the incremental implementation of these innovation systems, where at every stage in the process, questions are asked, dialogues are fostered between societal actors, and evaluations are made about the acceptability and the social benefit for these functions, which is sort of not as important as the need for the speed for the implementation of these systems and their expansion. So for the future, it would be very important to open up opportunities for responsible innovation in public health technology governance, such as integrating social anticipation, reflexivity, inclusion, and responsiveness processes in the implementation process that accompany the implementation process and its expansion at every stage, and that they are considered an integral part of the process, and which would ensure or which would increase the probability that technological change benefits society, and because it will be enabled through open democratic processes. Thank you very, very much for your interest, and I look forward to your questions.
Thank you, Dr. Sinosic-Martinez. Maybe you could, yeah, perfect. Mm-hmm. So I would suggest to open the discussion. I've seen that we have one raised hand, and I will make Professor Christian Stary now a panelist, so he can ask his question. Yeah. So, Professor Stary, you could ask your question now. Okay.
Perhaps, Michael, this was not on purpose, and perhaps you would like to
well, then okay, yeah.
Take the written questions first, perhaps, and Professor Stary has the opportunity to turn on his system if he wants.
Okay.
In the meantime.
Well, yeah, I mean, most of these questions, or actually all of them, have been answered in writing. Would any of you further elaborate on these issues, maybe? Or otherwise, I have a question myself. But if anyone wants to speak.
I don't think that they were answered, Michael. It was just me answering that they would be answered. So if you go into the answered questions section, there are several questions not yet answered. So for example, from Mr. Buotz or from Elizabeth Steindl, do you see them? Or should I read them?
Yeah, if you please go ahead.
So there is one question from Thomas Julius Burz. I read it. Thank you for the interesting presentation. I have one question for Sabine Fehringer and Stefan Panic. You said that only doctors. Oh, I'm sorry. That was already replied. I did not see the reply. My apologies. So that's already answered. I'm sorry. Excuse me, Michael.
No problem. But maybe if then I ask a question, it's probably directed towards Professor Kalra. I think if I understood you correctly in your presentation, you suggested that the willingness to share data for research purposes is there by the people, at least from the patient initiative. But they want to know what happens, and this also goes for anonymized data. So as we delete the connection between the person and its data when we anonymize, what are your thoughts on this? I mean, is this in a way possible, or?
Well, you're absolutely right. It's a challenge. So I don't disagree with you about the challenge, but I don't think that should stop us making a really strong effort. So if you take, for example, a situation where an individual is collecting data on their app and somebody would like to use data off a pool of such patients for a piece of research, there are SMEs out there who have products that allow them to throw a question to the individual and say, this kind of company, maybe not by name, wants to do some research on this topic. Can your data be added to the data set? And the individual knows that that will be handled anonymously. They've previously been assured of that. They touch the yes or the no button, their data gets added to a data set, the research is initiated, and then some trillions of years later, when the results are available, they do or they do not get told, thanks for your data being used. This appears to be the finding. So the big issue that we know with pharma clinical trials right now is that most trial subjects don't get that kind of thank you, don't get that kind of feedback. However, we also need data on controls for many such studies. And so the individual who has a disease is not the only person whose data we need. And I think we need to gradually educate the public away from personalized feedback. Your data was used in this way. What I would love to see, for example, is a newspaper advert, forgive me using a paper metaphor, a newspaper advert saying, thanks, citizens of Berlin. 800,000 data points from you. We don't know which of you it is. We used for this study and we had this great result. We don't know which of you it was, but we thank you all anyway. Wouldn't that be wonderful? And I don't think the public would complain and say, oh, but I don't know if I was in the 800,000. I think if they understood we don't know who you are, that's actually reassuring that the anonymization works. But we don't do enough of that. We don't see an advert in a newspaper in Berlin. And I've only picked Berlin by example, and I've only picked newspaper by example, but we need to do that. We need the public to be treated as really active players in this game, not as people whose data is used in private. That's my feeling.
Yeah, thank you. Thank you very much. Yeah, do we have any other question? Just checking the Q&A.
If I may, in the meantime, Deepak, if I may continue on this, could you perhaps explain a little bit more about the work of the institute you are heading and whether this is working in this way and in how far you see the situation improving in the last month, perhaps due to COVID?
Well, I mean, COVID is interesting, but I mean, our institute is a not-for-profit body. And our role is very much around health data. Our mission is to help all stakeholders to make better use of data in trustworthy ways. So that the topic of my talk and a colleague of mine, Nathan, who will speak later today as examples, we're very involved in this. Our goal is to bring stakeholders together to help understand better what are the needs, what are the opportunities for using data, what are the enablers, what are the barriers, can we do things to help? So for example, how can we promote good practices in better use of data in a number of European projects, but not yours, not the VBC. We're involved in helping those projects to use data well, developing codes of practice and guidelines. But while we do that, we are uncovering the difficult topics, some of the ones I mentioned in my slide, the things where we hear that somebody is being blocked from being able to use data in what seems to be a very sensible way. And it may be a data protection officer who is feeling nervous and scared because, you know, the penalties are now so high for a breach or for misconduct that they, you know, the safer thing to do is to say no. And this is a real problem we have, you know, out there. The safest thing to do if you are in charge of making a decision about data use is to say no, because you absolutely guarantee no risk to your organization, no liability, no fine, no 2% of your turnover. And what does it matter anyway? You keep out of trouble. And what we need is the public to say, hey, actually it does matter because there's a really valuable result we are not going to get. There's valuable learning we're not going to have. There's a disease whose treatment is going to be delayed because everybody says no. And I would love to see a bit more bashing of heads. That's why I'm not convinced GDPR precision of compliance is like the Holy Grail. But it may be not necessarily the only thing we should be trying to achieve. I'm not saying let's break the rules, but let's try to balance this precision of perfect GDPR compliance with societal good. And are there better ways we can assure societal good? There was a really interesting question thrown in my direction by Elizabeth. I tried to give an answer with a few typos in it. But, you know, how do we encourage a more open, purpose, benefit-driven approach? I mean, I'd love to hear the other panelists' view too. I mean, there's a lot of anxiety about AI. I was quite surprised at the limited level of societal engagement about ELGAR. I didn't realize that. That was a very eye-opening presentation to me. The other panelists may have views on this as well.
May I give a comment to this? It's certainly a very important comment. We in eBrains and the Human Brain Project, we feel kind of in the middle between the fair data initiatives today, and they are really very strong, and we of course completely agree with that perspective, and the fact that for the human data we have a number of challenges in how to make the data fair. And our daily life is exactly what you are summarizing. It is about finding solutions and somehow being, well, maybe being bold is not the right expression, but somehow developing solutions where, to the best of our understanding, with our people from law and from ethics and from the research and from being close to the patients, if that is the case, or research subjects, trying to develop solutions that are completely transparent and exposed all the way, so you know what there is and how it's working, and then go forwards. And we are in the middle of taking some steps now, which will at least, let's say, expose these challenges, but maybe primarily to those who don't do it. And that's for the future to see what happens there. But we're trying to find these solutions, and it's an exciting experience, a very timely conference.
Thank you very much. We have one raised hand from Dr. Molnar-Gabor. Maybe you would like to ask your question. Thank you.
Thank you so much. It's probably a mixture of a comment and a question, and it goes to Deepak about transparency and winning the public to contribute more data to certain kind of scientific research projects related to health. And so there are quite a lot of discussions about the GDPR, of course, and whether it is enough, as you also mentioned, to make an ethical standing point valid also in order to provide more legitimacy in this regard for research. And I was wondering what your opinion is about two possible tools that are being now discussed to add more transparency and more ethical legitimacy to scientific research using health data. And the first is thinking about secondary usage possibilities. where of course the GDPR does not really differentiate between industrial or public research, but where you could add, in order to use as legitimate basis, scientific research, transparency obligations for pharma, for industry. And I think you already brought up quite a good example how this could work related to, hello, people in Berlin, we used your data this and that way. And the other tool that is currently being discussed are codes of conduct, which are a certain kind of, middle measure between very high level principles and concretizing those in a sector specific way. And I think they are quite promising because they give the possibility to add ethical obligations and to draw them up in an interdisciplinary manner. So I was wondering if you have some thoughts on both tools, probably on the second one more, as you already mentioned the first. Thank you very much.
Thank you. It's really interesting. I mean, code of conduct has come up a little bit more recently as a bigger topic. And I've got colleagues of mine, people that Nicholas knows quite well, who may be involved with the European Commission on producing a formal code of conduct, because the GDPR does create the opportunity for a sector to have a code of conduct. However, that's a kind of what I would call a legal code of conduct. It's something that is recognized in law. I'm not an expert on the articles that refer to this. My worry about that is twofold. Firstly, it's going to take ages to get consensus across 27, sadly, member states about what is acceptable, and it's going to be very high level and so on. One of the problems with code of conduct is that if they are just an elaboration of principles and they focus on things you must not do, which they sometimes are, they're not very helpful to the person on the ground. What I've been very keen on is writing codes of conduct that may not have a capital C for code and a capital C for conduct, but they are more operational. They are things that they tell you what you should do. So for example, when a member of staff leaves the department, let's take pharma, because I do a lot of work with pharma. Let's pretend somebody's working in science, in a scientific department, and they change to another department. You know, what you want is that the administrator who is in charge has a policy that says how many days or weeks after that person departs do you revoke their access rights to a data set. Now, that's not a kind of high level principle. That's saying you need to have a number of days, an integer needs to be defined, and then you need to operate that integer and actually revoke rights. It may not be at the millisecond they leave. They may have to help a friend out to hand over queries and things. There can be a transitional period, but you know, that's a really precise spec. That's the kind of thing people actually need. They don't need to be told you should make sure that the right people can access the data. You know, that's pretty vague, that's pretty woolly. How do you define it? How do you measure it? How do you assess it? What sanctions do you apply? So we need to help transition. And when you talk about codes of conduct, that's the kind of thing I'm keen to get close to, because it helps people in practical ways to be good citizens. Is that the spirit that you had in mind?
Yeah, I think that's quite important. If I may just give a short additional comment on that, because we have the regulatory approach in the GDPR. Basically, data processing is banned, especially health data and sensitive data, and there are specific permissions. But the way you describe a code could function is more like providing positive rules. What can you do with the data? And to then, in a second step, say, okay, this is forbidden, or there is the ban. So it's more about something promoting data sharing, of course, in a responsible way, where you need those ethical stances and yardsticks. So yeah, I think that's quite a good approach. Thank you.
Mm-hmm. I would like to just make one point that that has come to me from what I know from the literature that addresses these issues. One is this possibility for shifting from this approach of treating patients and people as customers who just need to consent. They just need to give their consent. They need to be assured that it's anonymous, and that is sort of enough to solve this problem. One of the issues that has been repeatedly written about in the literature on this is that it's not just the problem about anonymity, it's also what happens with this data. It's the structure of processing this data, that if you have a lot of data that is anonymous, it still doesn't ensure that biases might not be replicated and scaled up. So people may consent to the anonymous use of their data, but this does not this reduces the potential uncertainty that is involved, that we might also not know about. And I think it's important to openly debate about these uncertainty elements in the collection and the use of patient data.
I mean, that's really important. And I know that we've had some of the other speakers in this group have been speaking about AI development, and I noticed that all of them refer to the importance of bias and non-discrimination. So that would be perhaps an example, Tanya, of what you had in mind, that if somebody is developing AI, I mean, I was at a conference about a year and a half ago, which was a global event, although held in Paris, thankfully for me, easy to get to. And one of the concerns from some of the countries that are not part of what we would naturally call the sort of leading edge, so African countries and Asian countries, was AI would be developed with a particular population profile in the US or somewhere, and then would be parachuted into their country or their city or region and expected to be just treated as perfect because it's been developed and validated elsewhere. But you know, the prevalences, the risks, the capabilities for different populations to respond to different health issues is different in different economic environments, geographical, ethnic environments. You know, if you developed it in, you know, Los Angeles, please don't think it'll work really well in Uganda, or at least make sure you've tested it first. And I don't know, AI family in the panel, this appears to be stuff you're actually really caring about. That's what I felt. Are you?
Okay. Well, does anyone want to contribute here? Or otherwise, I would ask one. We have 5 minutes left. I would ask maybe Sabine Fehringer. Thomas Buhr asked the question about using AI tools. So completely, let's hypothetically say they're completely autonomous, and a doctor would use it, but more or less there would be no influence by the doctor. And you drew a line between laymen using this or pharmacists, but he was further questioning, where do you draw the line between AI assistance and the replacement under the doctor's law? Maybe you can comment on this.
Yes, I can comment on this. Actually, artificial intelligence, at least under our systems, may not develop as a self-runner. So just the system is a doctor. So as long as the doctor is using the system, the results of the system, and doing his diagnosis, evaluating the outcome of the system, and also applying it to the patient, it's in line with doctor's privilege. But if the doctor is just repeating what the system is saying without considering the entire surrounding, also the social surrounding of the patient, his personal knowledge about the history, the patient's history. So this can be a misuse of the system. Or if only the nurse is or the assistant of the doctor is using the system and doing the diagnosis instead of the doctor. So this is somehow the line, or the example we had, that in a pharmacy there was an IE system to measure the pressure of blood, and if the results are used by the pharmacy just to provide medication for the client, for the customer, then the pharmacy is infringing the doctor's privilege of treatment of his patient. So to summarize it, the artificial intelligence systems are still must stay a tool for the doctor for doing his work, for treatment, for diagnosis, but it should not replace the doctor.
Okay, thank you. I think that's also a good connecting point for the next session, and maybe also in light of Article 22 of the GDPR, and if a doctor uses this in medical diagnosis, which my colleague Katarina Polikonopoulos will be speaking about. But well, we're almost to the end, so if you have any closing remarks, please feel free to give them. Otherwise, I would say we can start around 10-minute break.
Introduction of each of the speakers, and then I will let them proceed and share their screen. So I'd like to welcome everyone back to the conference, and we are now in session 2, GDPR and Artificial Intelligence related challenges in healthcare and research projects. So our first speaker will be Heidi Benson. So just to give a little bit of background, Heidi works at the Center of Medical Ethics and Faculty of Medicine at the Norwegian Research Center for Computers and Law at the Faculty of Law, both of which are at the University of Oslo. She collaborates with the Norwegian Cancer Genomics Consortium and is an academic affiliate for the Center of Health, Law and Emerging Technologies at the University of Oxford. And she's also a member of the UN Special Rapporteur on the Right to Privacy Task Force and Privacy and Data Protection in Health. Our next speaker will be Gauthier Chassang, who is a lawyer at the EU International Law at INSERM, the French National Institute of Health and Medical Research, with specializations in research in law, bioethics, genetic and genomic research ethics, and bioethics and governance. Our third presentation will be given by Katerina Polikonopoulos, who is a research associate here with myself and the rest of the Department of Innovation and Digitization in Law at the University of Vienna. Katerina is a lawyer from the US, holding a Juris Doctorate from the University of Illinois, and her current work focuses on data protection, platform regulation, and the application of legal and legal implications of large-scale medical research in medical and healthcare projects. And finally, we will have Professor Edgar Weipel, who is a professor of security and privacy at the University of Vienna. Professor Weipel is a research director of SBA research and head of the CD laboratory for the improvement of safety and quality in production systems. And his main research interests are in fundamental and applied research on blockchain and distributed ledger technologies and the security of production systems. So thank you all for attending. Thank you all for your time. So Heidi, if I may ask you to share your screen and please start with your presentation.
Thank you so much, Emily. So I will talk about bias and discrimination, misuse, and ethics versus law as a way to regulate AI. I will use a case study to do this, and the case study will be AI technology to identify genetic diseases by looking at someone's face. It's something that has received a lot of media attention. AI tools for assistance with medical diagnosis can be remarkably efficient. This paper shown here and its sister paper made a big splash in the genetics community because it represents a huge advance medically speaking. So children it would take years to diagnose can now be diagnosed rapidly. It is so efficient that it can actually reveal information that cannot be picked up by experienced health personnel, and it can even detect carrier status. So by a combination of exome data, clinical features, and portrait images, you get a 99% top 10 accuracy in this paper in a cohort comprising 679 individuals with 105 different monogenic disorders. So seeing as I'm a co-author on this paper, I will use it as an example of an incredibly useful medical AI tool that also raises difficult questions in terms of bias and misuse potential. The sister article explains the algorithm. So it works in this way that a new input image is pre-processed to achieve face detection, landmark detection, and alignment. After pre-processing, the input image is cropped into facial regions, and each region is fed into a deep convolutional neural network to obtain a softmax vector that indicates its correspondence to each syndrome in the model. Then the output vector of all regional DCNNs are aggregated and sorted to obtain the final ranked list of genetic syndromes. So the histogram you see on the right side represents the output syndromes sorted by the aggregated similarity score. Now let's have a quick look at transparency before we move on to these other issues, because this is a 10-layer deep convolutional neural network, and neural networks are, as you all know, notorious for being difficult to explain. However, we found that it is actually not as hard to fulfill the transparency requirements as many will have you believe. So we achieved this by a 3-layered explanation, one very easy explanation about how the model works, a more detailed explanation with photos and examples of transmitted data, as you see in this slide. And finally, for those particularly interested in the details, a link to the Nature Medicine paper explaining the algorithm, and prior to the publication of that article, to the preprint. Now, I want to ask you all a question, and that is, one of the first authors on the paper ran this model on himself, and it came back suggesting that he had an intellectual disability. Now, this guy is an incredibly bright clinician scientist. So how could this happen? I'm not sure if anyone has any suggestions for this, but I can tell you what did happen. What happened was that this was in an early phase, and this software that can get thrown off. And so when this guy uploaded a photo of himself, the tool may have been stumbled by the facial features that related to his ethnic background, which is a combination of European and African, because the algorithm was at that point mainly trained on people with European ancestry. Also, suggestions will also always be made. And so this brings us to the point that personal data should be processed fairly in relation to the data subject. And if there is a bias in the training data, this can give rise to a corresponding bias in the algorithm. Of course, bias can also come from the biases of the people who build the algorithm, which was not the case here, but maybe the case in other instances. We therefore included a sentence about this, or two actually, in the paper to make it very transparent that this might be an issue. So we said, well, we include and strive to include a wide variety of ethnicities, but European backgrounds are currently best represented, leading to best performance for this population. As the data set expands further, the algorithm will improve for currently underrepresented ethnicities. And this is a difficulty that may be faced, for instance, in the medical field. And here, in particular, related to genetics, because this is a tool to be used in combination with exome sequencing. Now, exome sequencing machines are incredibly expensive and require stable electricity output. So there are some of these machines also in Africa, but there are not that many. And so it takes longer to obtain the same amount of data that is required for rare genetic disorders in Africa than it does in, for instance, Europe. As this was a tool that was so powerful, it was necessary to also come with a warning publicly. And this was then done to say that actually the same type of algorithm can be used, for instance, so that people can scan Facebook photos to discriminate against employees with genetic diseases. And in general, AI tools can be applied outside its intended context for other purposes. Can be applied for law enforcement and misused for discriminatory purposes by employers as here, or insurance agencies, or others. Also, although this relates to social media, that's not the only place your image is often available. This is my own profile page at the University of Oslo, and my employer posts photos of all the researchers at the university, open for anyone. So how ought we regulate AI? A British report showed that the British media coverage of AI is industry-led and thus agenda-driven. The report shows that less legal regulation is often encouraged, combined with threats that other parts of the world will get the upper hand and one's own country will miss out. So this creates this constant need for urgency in this field. And I therefore also wanted to just tell you that we at the Norwegian Research Center for Computers and Law have been working on AI and law since 1970, where the now late Professor Jon Bing started a project on AI and law. I also took a walk into our library, and I'm here showing you some publications from the 1980s and 90s related to AI. And there's a poster that was hanging outside my office from the 1990s, also related to AI and law. So we've basically been doing research on this for the past 50 years, and we're still doing it, keeping up with the technological development. There was a piece in The Guardian some time ago, and it said, well, AI's progress is unstoppable, so don't worry your silly little heads fretting about it, because we take ethics very seriously. This was then seen from an industry perspective. And they said, well, another plank in the industry's strategy is to pretend that all the important issues about AI are about ethics, and accordingly, the companies have banded together to finance numerous initiatives to study ethical issues in the hope of earning brownie points from gullible politicians and potential regulators. And we've seen several media stories like this, also showing the ethics centers of several of the large tech companies and how they finance research centers also in Europe. There is a concern, therefore, that ethics washing is going on. So by pointing to ethics boards and charters, companies can state that they are doing something, thereby avoiding criticism. But because the ethics boards often lack veto power, the companies are not forced to follow their advice. Do we have legal regulation in this field? Yes, of course we do. So we have the GDPR, and a member of the European Parliament sent a letter to the EDPB asking if this is considered sufficient. And the EDPB answered yes, specific legislation related to AI would be premature at this time, but we may come with some guidelines. Well, the EU itself has also published a couple of reports, as I'm sure you all know these, with both ethical principles and more legal principles. At the research stage, a lot can happen. IBM's Watson for Oncology received a lot of media attention when internal documents were leaked, showing that Watson had suggested unsafe or wrong medications that may have killed the patient. So what media was not always very good at expressing was that these so-called patients were simulated. So basically they were just dolls. So no harm has happened when you're almost killing a doll while testing a solution internally. But if you implement the solution into healthcare, the situation is clearly very different. So we rely on evidence-based medicine, and there cannot be exceptions for AI in terms of evidence. Eric Topol published a brilliant and very thorough AI review article in Nature Medicine stating that, quote, "The field is certainly high on promise and relatively low on data and proof. There cannot be exceptionalisms for AI in medicine. It requires rigorous studies, publication of the results in peer-reviewed journals, and clinical validation in a real-world environment before rollout and implementation in patient care." So how do we solve the regulatory challenge? Well, one possibility may be to primarily rely on existing data protection and non-discrimination legislation and just add a few elements of sector-specific legislation where needed. The United Nations Special Rapporteur on the Right to Privacy, Joseph Kanatachi, has issued a recommendation on the protection and use of health-related data globally. And many of the people contributing in today's conference are part of the Special Rapporteur's Health Data Task Force and played a role in the drafting of the recommendation. Amongst these, our chair here today, Nikolaus, who also chair said task force. So the Special Rapporteur's recommendation is an instrument in harmony with all main data protection instruments, and it also includes specific provisions on health-related AI, which may serve as a model for those seeking to develop legislation in this sector-specific area. The rules do, for instance, relate to evidence and bias. In terms of evidence, it says that health standards will not be lowered to facilitate deployment of data processing technology. Forms of processing that have not yet transparently proved their efficacy shall be subject to the scientific research provisions. And in terms of bias, it says that bias must be identified, it must be disclosed, and it must be taken into consideration when using the tool. Thank you.
Great, thank you so much, Heidi. That was a really fascinating presentation. So may I please ask Gautier to share your screen and commence with your presentation?
Yes, I'm doing this. Thank you very much to the first speaker. Okay. Now can you see my screen?
Yes.
Is it working? Yes?
Yeah.
Okay, good. So hello, everybody. In this presentation, we will tackle some of the issues related to the transparent development and use of AI systems, both programs and devices designed for health, And we will make a focus on some provisions of the GDPR which support transparency in research and healthcare using personal data. So first of all, it is important to remind that the rationale of AI transparency requirements stems in the fact that more and more human activities tend to be assisted and replaced by AI-based devices and programs. And all the sectors are concerned, including critical and sensitive areas such as health, both in care and in scientific research. Artificial intelligence and machine learning is very promising, but technologically complex, very disruptive, and has proven to be potentially dangerous, discriminatory, and very intrusive with regard to the concerned persons. And now it is obvious that there is a general lack of transparency in the domain and a need to work specifically on this topic. According to the recent EU strategy for AI, the respect of European values shall be enshrined into AI systems. This includes the respect of fundamental rights, including privacy protection, personal data protection, and non-discrimination, but also public health protection, environmental protection, consumer protection, respect the rules of fair competition, and includes aspects related to the professional ethics. In this perspective, transparency requirement is essential to demonstrate that AI innovations, in particular in critical areas, are appropriately considered and integrated in the design of AI products and services. The main objectives of AI transparency are to foster fairness and public control or debates over AI-based program devices, development and use, to allow responsible and appropriate use of AI systems, to empower users and persons affected by AI use, which will not be users per se, to make free decisions and eventually contest the outcomes of the processing, to avoid or mitigate risk of illegal, unethical, hidden practices or development trajectories, and to build and maintain trust of end users and society in AI systems. So as it has been said, AI transparency is part of the 7 essential principles of trustworthy artificial intelligence, whatever the AI type and related products, services, and categories. AI transparency is intertwined with other fundamental principles, in particular the principle of accountability, and it includes traceability, explainability, and communication aspects related to AI functioning, machine learning, functionalities, and attached governance mechanisms. AI transparency necessitates technological and organizational measures to be developed by design and by default, and regularly reassessed throughout the AI system life cycle. It includes specific challenges and probably trade-offs to be further explored by considering, for example, the transparency paradox, on which we could come back in the discussion. But in any way, this principle of transparency is reinforced by medical ethics and various relevant frameworks, legal frameworks applicable to AI stakeholders. So of course, transparency includes privacy and data governance aspects, and we will focus on this. In health, AI systems are developed in order to base or make decisions that will impact directly or indirectly the health of individuals, patients or not, but also populations, if we consider the use of AI-based systems for public health policies, for example. AI systems are developed and can be used by health professionals for medical purposes in the so-called algorithmic medicine, for improving the detection, diagnosis, and treatment of diseases, for organizing the precision treatment, or in medical robotics, for example. But they can also be used by health establishments as logistical tools, but also by insurers. AI a wide range of various devices of different quality, from medical devices, potentially implantable, to e-health tools used for well-being purposes. But in any case, the lacks in transparency can lead to unreproducible or biased research results, hiding potential misconception in the AI technologies, what question research integrity principle, and to premature deployment of risky AI-based tools. It can lead to the misuse of AI, infringing human rights and freedoms, and potentially involving life-threatening practices or events. It can lead to material, immaterial damages to the individuals, and engagement of the responsibility of the health professional, health establishment, product manufacturer, and probably other persons. By the end, it will diminish the quality of care and patient-doctor or participant-researcher relationships. So there is a constant need to demonstrate AI-based medical tools added values for evidence-based healthcare and research practices. Ensuring transparency throughout the development will empower health professionals, users to meet their ethical duties and respect individual rights before and after the medical acts. In healthcare and research, personal data processing are crucial for the proper functioning of AI systems and for their development. They are key to develop reliable and accurate programs or devices. Personal data are used as input. They are processed through the AI system that will correlate them with training datasets, eventually through profiling activities intended to evaluate certain personal aspects related to the individual, in particular to analyze or predict aspects concerning the health status of that individual, his behavior, his movements, etc., in order to deliver an output which most of the time qualify as inferred personal data of various nature with an informational or decisional value depending on the context of use. All these activities raise privacy and data protection concerns, which are more or less addressed, I have to admit, through the GDPR. Indeed, AI developments and uses relying on the processing of personal data from Europe must comply with the principle of the GDPR. Machine learning processes are implicitly covered by the legal definition of processing. Transparency of data processing is a key principle of GDPR, wanting that personal data should be processed lawfully, fairly, and in a transparent manner in relation to the data subject. Therefore, data controllers must take care of transparency as an element of privacy by design and by default requirement, and must demonstrate compliance. By doing so, they shall adopt a risk-based approach, and this is particularly helped by the obligation to perform a data protection impact assessment for high-risk processing, and a lot of processing in our domain will qualify for such an exercise. Finally, it is helpful also to say that the GDPR does not fully harmonize the rules in health and research, and that EU member state law could fix actually more specific rules. In the GDPR, transparency obligations is concerning several actors in the processing of personal data by AI. It concerns data controller and data processors with between themselves. They have to be transparent, and they have to be also transparent in relation to the data subject and eventually to third. In our presentation, we will focus on the relationship between the professionals and the data subject, patient or research participant. So let's take back the three main elements of AI transparency identified by the guidelines on trustworthy AI adopted at European level, and to see what kind of elements in the law are related, are supporting these transparency aspects. And the very first one is the right to information. The right to information forms an obligation of the data controller to be satisfied before the processing of personal data and throughout the personal data processing. So GDPR is fixing modalities for informing the persons. It is fixing content of the information and specific rules related to the profiling and automated decision making. And we'll come back on these aspects now. Regarding modalities, the GDPR obliges data controller and processors to provide concise, intelligible information using clear and plain language adapted to the data subject, in particular when there are vulnerable people like children. The information must be easily accessible and free of charge. It can be provided by written or orally when it is authorized by applicable EU or national laws. And they must think about the capacity to reinform the data subject in case of changes in information provided, or plans adequate safeguards to minimize the risks regarding such changes. These requirements open several opportunities in the field, such as, for example, to develop texts and icons or other informational tools of high quality that will meet legal proofs requirements in order to ensure legal security. But it is also including challenges. The challenges are related to the difficulties in the field to summarize, to vulgarize, and to tailor the information to the audience. Multi-layered approaches could be used, but can be maybe less transparent for the data subject who is supposed to be active in the search for legal information and could be subject to click fatigue. And finally, diminish the transparency of the communication process. The multi-layered approaches can also be explored in order to lead to a dynamic e-consent, but this will only be authorized if it is planned to be valid in the EU and national laws applicable to the activity. Regarding the content, the GDPR is fixing a list of elements to inform, very important elements like the data controller and data protection officer identity and contact, the purpose of the processing and its legal basis, the recipients of the data or categories of them, the intention to transfer personal data outside the EU, and of much interest in our topic, the existence of automated decision-making, including profiling. This requirements open also opportunities in the field to work by design on what must necessarily be communicated in order to satisfy the fairness requirements toward data subjects. It necessitates sectoral practical guidelines that will help the controllers and professional users to meet their informational requirements. And there is an opportunity here also to involve samples of independent users and concerned persons in the design of communication tools and the information content. Challenges in our domain are to make explicit the use of AI-based decision-making system and profiling activities, particularly when a lot of information have to be legally provided to the individuals. This type of very important information could be hidden by others. Difficulties also to envisage fully the reuses of the data collected or generated for other purposes and the related legal bases and tools for the exercise of data subjects' rights. To identify the responsibilities prior to the deployment phases. This necessitates a clear data management plan, and in such an approach, the data protection impact assessment should help to organize accordingly. And where consent is used as a legal basis, there is a need to show that the data subjects understand exactly what they are consenting to in terms of envisaged use of AI system and consequences on their rights and freedoms. There are specific provisions regarding the AI-based decision-making system and profiling. There is a specific right not to be subject to decision-making solely based on automated personal data processing, including profiling, which produce legal effects or similarly affects data subjects. Some exceptions are planned also to this right when it is authorized by national or EU laws, when the processing is necessary to enter into or to implement a contract, or where the data subject explicitly consent to that use. Challenges are related to the ability to be aware of applicable legislations making such processing lawful and proportionate. And challenges are also related to the respect of complementary measures ensuring consent validity and lawful automated decision making. Because indeed, when we are in an exception, in the two last exceptions, we have to respect additional rights for the data subject. In particular, a right to explanation, and we will come back on it in a minute, and the right to obtain human intervention. Both additional rights in this context are raising specific challenges in artificial intelligence. First, there is a risk to overload in the right to explanation the data subjects with technical information and to practice finally unfair disclaimers. There are difficulties to elaborate informative elements in some context where we are dealing with black boxes, and it is difficult also to build in relevant explanation mechanisms into the artificial intelligence, but some research are ongoing on the topic. Regarding the right to obtain human intervention, there are challenges in artificial intelligence to involve, regarding the involvement of health professionals and the design of the intervention that is needed here. And there are also concerns that such a measure prohibits autonomous decisional AI system per se. Just to focus on some challenges related to black box AI decision-making systems compared to the requirement of explainability. In some cases, we have technical hurdles to explain the reasoning of the machine that will lead to a specific outcome. It is particularly true when we are using deep learning and artificial neural networks. Explainability also face legal hurdles that are not specific to black box systems, but are general to all AI systems, because explaining in detail the elements of the artificial intelligence can lead to IP rights infringements, to problems regarding digital security, to privacy risks, and finally to impossibility to meet the GDPR informational requirements. Regarding the right to explanations, the GDPR, I have to say, nicely requires that the data subjects receive at least meaningful information about the logic involved, as well as the significance and the envisaged consequences of such processing for the data subject. So it is a requirement a minima, but it is quite reasonable and quite possible to achieve, I would say. But good practices are needed here. I just wanted to signal that there is an entire new field of research that is explainable AI that is ongoing and develop a potential solution to overcome the challenge of black boxes and explainability in particular. The GDPR also plans some exceptions to the obligation to inform data subjects. This concerns situations where the data subjects already have the information and where the data have not been collected with the data subject, when it proves impossible to inform the data subject, or if it would involve a disproportionate effort, or if it would make the achievement of the objectives of the processing impossible or seriously impair them. And in particular, in the processing for archiving purposes in the public interest, in scientific research, or statistical processing. This is subject to specific safeguards mentioned in Article 89. Each time a data controller or processor is based on an exception to a right, he has to justify actually his position and to plan adequate governance measures to diminish the risks regarding personal data protection. And there is a compliance duty as soon as the exception's rationality disappears. So an exception is not for life. So as soon as the situation arranged, they must comply. The third and last elements identified by the guidelines are traceability. And so here there is no explicit requirement under the GDPR to practice traceability. Traceability of what? Traceability of the computing processes and data, not of the individual. It is about the ability to trace and trace back the computing processes that led to an outcome. It is facilitating accountable management and explainability of AI-based operations. It is facilitating human oversights of artificial intelligence. It is facilitating the implementation of data subject rights and should be embedded within the AI technology by using blockchain, for example. So even if it is not required by the GDPR, we could see it as an enabler of other data subjects rights that are supporting transparency, in particular the right to access, to object or to restrict the processing, the right to obtain rectification or erasure of the data, the right to data portability that is applied on the personal data provided directly by the data subject, but also on the outputs data, so the inferred personal data, and also as an enabler to perform notification of personal data breach. The challenges in AI are related to the transparency paradox. Indeed, the implementation of these rights should not adversely affect the rights and freedoms of others, including trade secrets or intellectual property, and in particular, the copyright protecting the software. There are limitations specifically provided with regard to research and archiving processing, and AI stakeholders could also face technical hurdles to satisfy these rights. But for the notification of personal data breach, there are automated detection of breaches and notifications systems that are currently researched, currently developed. So this was just a focus. Of course, there are other GDPR principles that are challenged by artificial intelligence, and we could discuss about them later. About challenges regarding data minimization. This is due to the need of performing profiling of individuals. Challenges regarding data accuracy and the validity, finally, of the decision. Challenges regarding data integrity and confidentiality, in particular regarding the respect of, regarding the anonymization and the maintenance of anonymized data when using artificial intelligence, and challenges regarding purpose limitations and further uses of the data for other purposes, and regarding storage limitation, even if here there are specific provisions in the GDPR for scientific research and public interest purposes. So to conclude quickly, the transparency is key to the GDPR and contributes to preserve human agency, the freedom and autonomy of individuals in AI-based personal data processing, and finally diminishes risks of misuses or abuses. Generally, the GDPR is not incompatible with AI developments, but it includes a number of open prescriptions which ask for specific works, sectoral guidance, innovations which are challenging for AI stakeholders. So the GDPR alone is not sufficient, conversely to what has been said by the European Data Protection Board. It's not sufficient to reach the transparency level necessary to open public debates, to improve AI literacy, and finally to trigger full adhesion from concerned populations. And an important question that is not answered by the GDPR relates to the broader ethical acceptability of AI technologies that need also to be particularly addressed. So thank you very much for your attention, and I hope that I not be too long.
Thank you very much. Thank you very much for such an interesting presentation. I would kindly like to ask you to stop sharing your screen and to ask our next speaker, Katerina, to share her screen.
Yes.
Thank you.
Okay, can everybody see my screen now?
Yes, we can.
Wonderful, thank you. Thanks, Emily. Thank you, Dr. Chassaing. Okay, so I'll be covering a little bit of a broader topic today. So I wanted to talk today a little bit about the regulation of artificial intelligence in the context of research versus when it's used for diagnosis. So basically the question I'm interested in is, should there be different regulatory standards when algorithms are employed for research purposes? And if so, who can and should verify that they're being employed in a rigorous way versus when algorithms are directly used to diagnose or treat? So as in the case of radiology algorithms, as we'll see. And when I'm talking about regulatory schemes, there are many different ways, obviously, that we can regulate artificial intelligence, as we've seen in other speakers' presentations. But I'm going to mostly talk about regulation in two different contexts. So the first one is privacy, as Dr. Chassaing talked about a lot of the automatic decision-making in GDPR, and then two, responsibility and liability when and if something goes wrong. So,
Katerina, sorry, if I may, your
yeah.
screen sharing is not the full screen of the PowerPoint. We are currently just seeing your first slide.
I see.
I don't know if that's intentional.
I'm not entirely sure how to fix that. Let me see if I can. Sorry, Emily, I'm not entirely sure if I can, is it legible? Is the screen legible or is it?
Yes, so we can just see your first slide right now, but also
Okay.
the rest of the PowerPoint.
Okay.
I'm sending technical assistance your way as we speak.
Okay, thank you.
That's all right. Should be, there we are.
Okay.
Yes, perfect. That's great.
Great. Give me 1 second so that I can actually see my notes at the same time, maybe. Okay, it looks like I'm not able to see my notes at the same time, unfortunately, as when I'm in presentation mode. So if it's okay with you, can you still see the screen?
We can see the first slide, yeah.
The first slide, okay. If it's okay with you, I think maybe it might be easiest for me to proceed this way, just
Sure.
because then I
Whatever
can.
works best for you.
Okay, sorry for that, apologies.
It's all right.
Okay, so we were talking about the two different regulatory contexts that we want to examine. So let's begin by trying to outline what we mean by artificial intelligence. So there are many different definitions, of course, but we're mostly interested in the medical context. So those that don't work in the field or haven't really had much exposure to programming might have in mind these sort of large robots completely autonomously performing surgeries, but that's not really how AI is being implemented in medicine. All right, really AI is just a program that's capable of learning. And you may have heard machine learning as a synonym that's been used to describe artificial intelligence. And deep learning is another term. It's a sort of subcategory of machine learning. So how does the program learn, one may ask? So essentially, and as other speakers also have referred to, it's by going through countless iterations of data or inputs and then being trained to recognize patterns or learn answers. At bottom, what these algorithms are just really, really sophisticated pattern recognizers. These systems are currently based on artificial neural networks. That's the kind of state of the art. And they're basically flexible mathematical models using multiple algorithms to identify complex nonlinear relationships within large data sets. And by large, we mean very, very large, not something you could run on a personal computer at home, right? So another obvious question is whether this technology is really new. And the answer is both yes and no. So programmers have been able to make algorithms learn for quite a long time. And the term learn is, of course, subject to interpretation, but these programs have become progressively more sophisticated. But really the big change is in computing power and the availability of extremely large data sets on which to train such algorithms. So in the past, we haven't been able to process the amount of information that's needed for a program to learn and to be able to recognize patterns the way that we are seeing AI being able to do today. So these huge volumes of digitally stored data have permitted the programs to become quite powerful. And we'll see some examples of those. So a good example in medicine are, and you can see some headlines here, are programs that learn to recognize the presence of certain problems like cancers, stroke lesions, ligament injuries, etc. on radiology images. Some of the German speakers might know radiology images as Röntgenbilder. So each algorithm, of course, varies in its complexity and the precise mechanisms by which it is coded to learn. Each algorithm also will be trained on different data sets. So this example, right, these examples, radiology images need to be fed into the algorithm, which helps it to begin to recognize which images show problems or diseases and which images don't. So eventually this program gets really, really good. And as you can see by these headlines, even better than a human at being able to look at, or a doctor specifically, at being able to look at radiology images and detect that there might be a problem, let's say cancer, for example. Of course, now the worry is that we have a program that doctors generally know is statistically better than they are at identifying a cancer, which means that doctors might defer to the machine even though they don't see a problem on a radiology image, or even though there might be a problem just because the program says there isn't one. So this kind of decision would then, even though there is a doctor kind of supervising the robot, would kind of be considered an automated decision, right? Because it's not really honestly being reviewed by a human. The human is deferring to the machine. So what do we do now when the machine makes a mistake? So this is the classic diagnosis problem. This is not the research one. So we're talking about the first category here. So who do we hold responsible if something like this happens? Do we hold the person or the entity that provided the data set to the program that it was trained on? Do we hold the programmer himself or herself responsible? Do we hold the doctor that relied on the program's result without correcting it responsible? Do we apply a quasi kind of tort liability scheme, a product liability one? Do we follow liability schemes that apply to medical devices? So all these questions, we don't really have a great answer for them. Some academics have suggested that we might want to build a sort of insurance fund that all these members or the users of this kind of artificial intelligence could contribute to. And then if something goes wrong, we have a source of money that we can compensate the individual harmed by the AI with, without really having to identify what the precise source of the error was. And again, as other speakers have discussed extensively, oftentimes we won't even be able to identify what the source is, because even the programmers themselves don't really, it's sort of a black box, don't really understand how the AI learned to arrive at the result that it did. So the answers to these questions, as we talked about, haven't really been decided by most countries yet. The other question is, when AI is used for medical diagnosis, is whether and how, so in Europe we have the GDPR, affects when it's used. And the answer is that, of course, it does. So Dr. Chassaing went over Article 2 of the GDPR pretty extensively, which of course gives the data subject the right to be free from automated processing. So in order for either consent needs to occur here, which is one of those exceptions, or we need to have a human reviewing the output of the program. So in the US, on the other hand, the practice of medicine is really regulated generally on a state-by-state basis. So also in the US, we don't really have a consolidated binding law that applies to artificial intelligence or the use of artificial intelligence in medicine. So on the federal level, you do have HIPAA, which is the Health Insurance Portability and Accountability Act of 1996. And that regulates data privacy and ownership of medical records. And then you have the Food and Drug Administration, that's a federal agency, and it regulates medical devices, among a variety of other things. So anytime a drug or a medical device becomes available to consumers, first the FDA must approve that drug or device. So the FDA has, and we'll talk about this a little bit later, but the FDA has issued guidelines for the use of AI and not yet binding law. The US also doesn't have any laws explicitly addressing the increased use of AI in clinical operations. But again, so we have only one discussion paper from the FDA on this topic so far. The US does have laws that are on the books that address product and professional liability and malpractice, and these will generally apply to artificial intelligence and to AI devices, but they don't specifically or explicitly call out AI they don't address it explicitly, right? So how do we answer these questions though if we're actually using AI for research? And when might actually AI be used for research? So a good example that's actually relevant to a European project I'm also working on, Biomap, is the use of AI to sift through large data sets that might include genetic data or symptoms and various other clinical indicators to see whether a correlation might exist between those systems and disease progression or outcomes using genomic data to predict protein structures. So companies like 23andMe, which is a commercial company that allows you to send in saliva samples and receive a report about your health. So specifically the likelihood that you'll develop various diseases and your genetic heritage, has actually already used its massive database precisely for this purpose. So for example, just this year, 23andMe has used its database to uncover new genetic insights into Parkinson's disease and to discover a genetic relationship between endometriosis and migraine. And it's also used its huge database to identify genetic associations for heart failure. And that's just in 2020, I think. As briefly noted, the US doesn't have an overarching or explicit policy on AI regulation. And this allows 23andMe to do research like this, other than in connection with narrow subjects. So there are exceptions, but not relevant to what we're interested in today. So there are exceptions like autonomous vehicles. The use of artificial intelligence in autonomous vehicles or autonomous weapons does exist, but we don't care about that right now. What the US has done is to issue national and state level national plans, guidelines, or codes, which often highlight essential principles for developing ethical AI. And we talked about that they're not substantive law. So for example, early this year, the White House, specifically the Office of Management and Budget, issued a draft memo where they said this about the use of the regulation of AI in research. Quote, access to data and metadata can facilitate the innovation, design, development, deployment, and operation of specific AI applications. Executive Order 135859, entitled Maintaining American Leadership in Artificial Intelligence, which was signed by Trump in February 2019, calls on agencies to increase public access to government data and models where appropriate. Similarly, California, as early as 2018, unanimously adopted Assembly Concurrent Resolution 215, and that resolution expresses legislative support for using the 23 Asilomar principles as the guiding values for developing AI and of related public policy. So the principles were developed in connection with a 2017 conference in Asilomar, California, where experts from various disciplines met and established the core principles for managing responsible development of AI. As of November 2019, they've been endorsed via Solomar principles by the world's leading AI researchers and leaders like Stephen Hawking and Elon Musk. So this is a very difficult question, right? Should different standards apply to AI when it's used in research versus AI when it's used in a clinical setting or to diagnose? And even when it's used in a clinical setting, you know, it can be used for various different implementations. So it can be used alone, or it can be used with oversight by a doctor. So my personal opinion is that there should be significant differences in the regulation of AI when it's used for research and when it's used for diagnosis. So, for example, a relaxation of the precision with which consent need be given if the data is being reused from a different research project for a new research project could provide AI developers with access to the large data sets that they need to make their algorithms reliable. As we've seen, the larger the data set, the more interesting insights an algorithm could discover potentially. And it's a fundamental step towards making AI work properly in the first instance, right? You need to have the freedom to train it on a variety of different data sets and very large data sets and a variety of different contexts. But the tricky thing will probably be how to define what research really constitutes when we're talking about AI, because you might end up running into, for specific research or specific clinical implementations, a chicken and an egg problem, because the resulting products that you get from trying to train AI will ultimately be themselves used to diagnose. And the FDA has an interesting policy that it's developing that actually kind of may be an interesting guideline in this regard. So the FDA doesn't currently consider all AI programs as medical devices. So programs that analyze large amounts of data to develop knowledge about a disease or condition that are, rather than to decide on a treatment option for an individual patient, may not necessarily be considered as having a medical purpose. And so they may fall under an exception to the definition of medical device by the FDA. So a difference would be, for example, if you're using a lab test, right? That kind of test would be very clearly a medical device. Whereas if you're using something like a radiology image, that might assist in developing knowledge about a disease or condition, but not necessarily be classified ultimately as a medical device, because you always will have that human element, the human oversight. So that's the question I wanted to discuss today, and I'm happy to hear any opinions that the audience might have. Thank you.
Great, thank you so much, Katerina. I think we'll have a discussion session at the end of all of the presentations. So if I may kindly ask you to stop sharing your screen and ask our next speaker, Professor Edgar Weipel, to take the floor. Thank you. Yeah, so please start sharing your screen.
Yes, I think you should see my screen now.
I do. Great.
Okay. Yes. So we had some nice, interesting presentations before, and I'll come back to some of the points mentioned in the presentations before. But so my background is computer science, and in particular security and privacy. So I have usually a very technical perspective on things, and not so much a background in law. But it's interesting to see how the different mindsets, what we see as important. So there are two main challenges that we see. Those main challenges are privacy. Obviously, GDPR is somehow connected to privacy, and we always see attacks. So we see attacks on AI systems, attacks on machine learning, and this may also impact the privacy that people expect of having even if they contribute data that is, for instance, used as training data in AI. So one important thing is that attacks over time only get better. So basically, the situation always gets worse because attacks get better, and you always have to think long term into the future of even if there are attacks that you did not anticipate that would be possible, and we've seen this in the past many times. So whenever you release data, or you think that data does not contain personally identifiable information, this might not be true in future if someone finds better attacks. And in particular, if you look at AI systems, it was mentioned in the third presentation by Katarina's, that developers don't really understand, or even the developers don't really understand once a model has been trained how it works. And this is certainly true. One important research direction is obviously explainable AI, but since even the technical people don't in the end understand how everything works, it's much harder to detect attacks, and also much harder to detect unintentional information disclosure, or simply just to quantify this. So if we talk about the privacy aspect, one question that, at least for technical people, comes naturally is how much personal data is actually included in such a model. Can we quantify this? So if then through GDPR regulations, someone might say, please delete my data, and one could argue your data is not really included in the final machine learning model. Obviously, it's not included as a easy to read data set, but somehow it's still included, and quantifying how much of your data is included, or how easy it would be to identify you because you contributed to this model, is at least technically an interesting question. Whether it does have a real world impact on legal cases, I don't know, but technically it's a nice question. So if we look at AI, there are different high-level definitions, such as we build systems that think like humans, so that the process of thinking is somewhat similar to how humans think, or simply they act like humans, no matter how the internal processes work, as long as it looks like a human is acting, that could also be considered AI. Or what we usually see in machine learning algorithms classifications is that we think that those systems behave or act rationally, which obviously humans in many cases don't. So there are two ways of seeing this. And one of them, you can implement AI systems in different ways. You can have rule-based systems, but today, obviously, machine learning and one specific sub-area of machine learning, deep learning, is currently obviously the hype algorithms that we talk about in computer science. Generally, there are supervised learning and unsupervised learning approaches where you have samples with kind of the correct answer, for instance, a classification answer, or unsupervised learning where you basically just automatically find some clusters. So that's a very high-level overview of what machine learning does. And now if we kind of try to have the context to GDPR, we talk about you're usually not allowed to use PII unless there's some exceptions. All of the audience with a legal background have much more knowledge about this than we do. But one interesting question is then, is data that is being used in a model to create a model, and once you have this model, or once you create synthetic data with a model, also a very modern approach, is this still PII, and can be quantified? How much personal identifiable information is there actually? There's no answer to this, but this is ongoing research. So this is a question: how much PII is actually contained in machine learning models? And obviously, one could say, well, this is transformed. You use original data, and then you build a model, and then from this model you create synthetic data. And this synthetic data is, as the name suggests, not real data. So there's no information pertaining to individuals contained anymore. But this is, as I said, this is hard because if the set of your input data is too small, then obviously there's a lot of intuitively there's a lot of information about one individual included. As the size grows, the influence of one individual shrinks, but then maybe if it's an outlier case that is somehow important and thus receives in the training phase more weight, intuitively again, this information would be more of this person would be included in the final thing. And and we've seen in the past that when data that was presumed to not contain personally identifiable information, this was simply wrong. I mean, the best known case, and Latanya Sweeney basically built her career, and she's now she's been professor at very good universities in the US for quite some time. She basically built her PhD and her entire career on that. It was almost 25 years ago. She used quasi-identifiers that were thought to be anonymous enough that data could be published. So the medical data with the zip code, birth date, and sex was published. As I said, it's 25 years ago. Today, everyone knows this. This is an introductory example of every privacy, computer science privacy textbook. And those quasi-identifiers, if you put it together with other information, can identify people. Other big information disclosures from information that were thought to be anonymous is at America Online. Some of you might actually still remember this. It was in 2006. The research department released data search queries of more than 500,000 users over a 3-month period, and they obviously removed the direct information about the individuals who performed those searches, but they allowed to link different searches together. And as always, attacks get better over time. So people use this data set, and if they said it's an anonymous data, you can't identify the users. Obviously, researchers try to identify people, and they were able to identify a couple of individuals from this data set. And this research head who published this data lost his job. Yeah? Another example is the Netflix, again published, it was in 2009, what it thought to be anonymous data on about 500,000 customers' ratings on about 20,000 movies was published. And the idea was to have a competition to improve the recommendation system. So they said the researchers who, with this test data, can improve our Netflix, our recommendation system, they'll get $1 million. And obviously what researchers, at least those with a security background, always tries to attack the system. And if someone says this is anonymous data, well, then let's try to find out if we can identify people. Again, what people did is use another data source. In this case, it was an incomplete data source that did not contain as many, not all the ratings that were contained in the Netflix data, but that were made public. It was on IMDb. And the idea was that people rate movies similarly, both on Netflix and IMDb. So if I give 2 ratings of the same movie, they're probably quite similar. So I'm not a kind of person that lies to one of those sources. So putting those data sets together, again, many people could be identified. So what was thought to be anonymous data was not anonymous. And this was without just input data from basically machine learning processes to improve recommendation systems. So whenever you publish data and you think it's anonymous, it's probably not. And there's this huge incentive problem that people who publish data, in many cases, don't get real rewards for publishing this data. So that's why there's an inherent incentive not to publish data for research purposes. At least in computer security, we deal with this problem. So if we look at machine learning and with a background in with a background in security, we always try to break systems. So whatever system we talk about, in this case, it would be machine learning. We try to find some attacks on it. And then there are different phases, the feature selection phase, so which variables or features do we think are important for a model? So which of the features from the original data do we use? Which learning model do we use? Then there's the training phase, and then there's the phase where we actually use the machine learning, usually to do some prediction. And in all those phases, you can try to attack the system and basically systematically finding ways to break a system and to, for instance, disclose personal information is what people in information security do. So what are the attack classes that we have in machine learning? So that's we can try to influence things. So we can, if we have control over the training data, we can insert certain additional or modify existing training data so that the system then behaves differently, so that certain classifications later on won't work properly, or that we know certain attack patterns once we present them to the model, that it will behave in a way that we want it to behave, and that the people who own the system don't expect it to behave. Or we can try to find input data when it's used the system, not during the training, that again behaves in a different way. So famous examples are small modifications on traffic signs, so putting a couple of stickers on a stop sign, and then the machine learning model that recognizes the traffic signs, for instance, thinks it's not a stop sign, but classifies it as a speed limit, something that humans would never misclassify. And again, the reason is that we do not understand that once the model has been learned, we don't understand how it works, and therefore this explainable AI approach would actually solve such a problem. Security violations, so we can try to create false negatives that violates then the integrity of the system, or we can basically try to flood the system with many false positives. So we create samples that are classified as positives and are false positives, and then you get too many alerts or too many cases where you have to actually manually do something. So this is an attack on availability. And in terms of privacy, you can try to obtain information about the original data set. So you can put in specific samples and try to learn and see, and research can work on quantifying how much can you learn of the original data by specifically asking the network questions. And then again, if we go back to GDPR and some of the rights that a data subject has is, for instance, the right to say, well, this data is incorrect, please correct it, or please delete my data. And getting this data kind of out of a learned model, or saying, well, your data is not really included, that's just a minimally included, and we can actually quantify this, would be a nice thing. So research projects that work on trying to improve the privacy in terms of machine learning is, for instance, one EU project, TVB-Cloud. So here the idea is that different hospitals or universities have patient data, and that this central feature cloud organization uses this data without obtaining the data, basically training the models locally at the universities, and then having one large model that others, without having full access to the models, so other companies, hospitals, then can access these models and run them, use them as they would like to, but not having the entire model. But even this feature cloud central place that has this entire model never has the individual data. So things, architecture, design concepts that are used there as privacy by architecture and privacy design. And so basically the idea is that you have those raw data hospitals that contribute not the data, but that the models are learned locally and for each hospital, and then you combine those models without having access to the data, and then you have this the same model or a very similar model to what you would have if you would have had all data and trained the model with all data. This obviously seems like a good idea for privacy. And again, open research questions are here. How different is this central model? Can you quantify the impact of individual hospitals, how much they contributed, and even in more detail, how much an individual data point contributed to the model? Another interesting research direction is creating synthetic data. So once we have a model, we can create individual data sets, data points that are realistic and that fit to the model, but that are not actual patients. And the idea is, well, if we generate the synthetic data, it's not a real person, so we don't have any GDPR issues. But somehow it's also what is in the second talk Gautier said, kind of creating new data in this output. You had the slide where on the output side, he talked about creating new data. But again, here it's hard, or from an attacker perspective, we would like to know, if we want to defend against this, we'd like to know how to quantify how similar a synthetic data point is to an actual data point, or if we can learn about something about individuals here. And the obviously ongoing research, and something that everyone in AI is talking about, is explainable AI. And once we understand how a model works, it will address many issues, such as biases will be made explicit, because if there's an explanation and we see that, we can then directly see that this is a bias that we don't want to have, or that we have to be careful about. But in terms of security and attacking systems and getting personal data out of what seems to be a system or a data set that does not contain personal data, but indeed it does, also explainability will potentially help. So once those things improve, we think things should be better. Be happy to answer any questions that you have. And whenever you're interested in security, attacking a system, attacking machine learning, just let me know. We're happy to do many research projects in this area.
Great, thank you so much, Professor Weipel. That was a really insightful kind of technical perspective. Really great. So we're now going to open the floor for questions. I see we have 3 questions in the Q&A, and we have a raised hand. So if we start with maybe one in the Q&A, if there's anyone who's asked a question in the Q&A and would like the opportunity to ask the question in person, please raise your hand, otherwise I will read the question out. So our first question, which is directed to Heidi, which I will read out directly, says, with the system at the start of your presentation, which used only European data in its training and so struggled with a non-European subject, it was a bias in the data, but not a bias in the team that created the system. Is the fact that only training data on European, that they only trained on European data and did not consider the impact it might have on outputs indicative of bias?
So thank you so much for the question. Yes, European backgrounds were at that early stage best represented in the data set. So the bias did relate to the training data. This was transparently communicated in the publication. But the training set by no means only contains data on individuals with European backgrounds. However, it was challenging to obtain a sufficient number of portrait photos of individuals with confirmed molecular diagnosis of rare genetic disorders of all ethnic backgrounds. So the researchers were well aware of this, and they actively tried to build a representative data set from around the world to combat any bias. And the bias is gradually reduced as more data on individuals of other ethnic backgrounds are added, which is continually the case. And then for the exome data that they also used, multiple exomes of different ethnic backgrounds were simulated, also to reduce bias.
Okay, great, thank you. So if I take another question, if there's no further discussion on that point, perhaps we can take one someone who would like to ask a question in person. So we have Catherine Collin. I'm just going to promote you to a panelist temporarily. Okay.
Hi, can you hear me?
Yes, we can.
Hi, thank you for a very interesting presentation. I was pleased to be able to jump in. I had a previous meeting, so forgive me if I have missed something you said, but I thought it was really interesting that you were talking about explainability. And in terms of models, of course, there are a lot of validation and verification standards, especially when they get to the stage where they're used as medical devices. What do you think there should be of standards and guidelines in terms of explainability? Should we go to the point where model evaluation and model testing should include standards for explainability in models to improve our the reliability of explainability in AI models?
Well, if this works, this would be definitely the best case. The more that we can explain, and the question is also, what does explainability actually mean? In particular, does it mean that it's that well explained that the domain expert, not someone who in detail understands machine learning, understands the decision? Or is a very technical description and saying we have 15% of this input and 20% of this input in the case that this is used, and kind of basically just a representation of how it works without really translating it back to the language of the domain expert, whether this is explainability. So this is one ongoing discussion. And at least what you have to do in every, at least my point of view, in every system that you use in a productive environment is to actively test it against all known attacks. Yeah? Obviously, there are new attacks that you haven't thought of, and this will always be the case, but kind of ignoring the existing attack vectors that you have in machine learning systems. And mostly we've seen it in visual systems that classify stop signs, or in autonomous driving, and because those are kind of the impressive examples that you have, is what you should definitely include is something that in other systems you would call penetration testing. So you basically try to break the system with all known, or at least as limited, we usually say time-boxed pen testing. So you test it as long as you have money, and kind of to an economic, because you could always test for many years, and at some point it just becomes too expensive, and the reward is too low. But that what makes economically sense that you test for this. So.
Thank you.
Great. Is there anyone else who would like to contribute there from the panel? If not, we have more questions in the Q&A. Thank you very much for your question. I'm going to move you now back to an attendee, if that's all right. Just give me a moment. Okay, so I'll go to another question in the Q&A. So I think this was written at the time of our second presentation, but the floor is open. So even if it's only remotely connected to GDPR, maybe this could be an interesting topic for discussion. Regarding the nature of the paper on AI identifying genetic disorders in photos, if authors were so aware of the obvious possibilities of misusing this research, given the various examples, wouldn't it have been simply better not to publish it? This is something I have asked myself in various papers in recent time. For example, the Pulse paper and upscaling photos, which was famously upscaled Barack Obama to a white person and caused an uproar on social media about bias and machine learning, including questionable reactions by luminary experts such as Jan LeCun. How come the conclusion that the advantages would outweigh the risk of misuse? How come this was the conclusion, sorry? Is publish or perish maybe clouding our judgment? So actually, I think that was possibly to Katarina's presentation, but if anyone has any thoughts here, most welcome.
I think perhaps it was to my presentation.
Oh, also maybe, yeah, sorry. Go ahead.
I would be happy to answer it, then Katarina and others can also answer.
Please.
The question is, should the paper not have been published given the fact that a similar type of algorithm could be misused outside the medical setting? And I think that is a great question, which applies generally to all research with a misuse potential. So here it was considered that the very significant medical advance this represented by aiding in what is extremely challenging diagnosis of rare genetic disorders justified publication. So it clearly represents a huge relief to both individuals in question and their families. This is something that often takes many years to diagnose. And many doctors will not have seen the syndrome in question before. So the app I mentioned is only available to relevant medical personnel. But of course, others outside the medical field may build similar systems and use those for less admirable purposes. And so hence that was my focus in the last part of my presentation on ethics versus law as a way to regulate AI, as ethics is not sufficient to hinder misuse. So I think we need law for that aspect.
Okay, great, thank you.
I'd also have a kind of a short input on that. Our research in security is always about breaking systems and misusing systems. So anything that is published, if it's a technical system with some computers or software or algorithms in the background, we try to break it. So I would be skeptical of not publishing something because it could be misused. Then you wouldn't be able to publish anything because we basically try to break everything. And this helps then to improve the systems. So over time.
Yeah, I think I agree with everybody else. It's always a balancing act regulatorily, right? I mean, you can see this in an example. For example, the FDA has lower standards when you're talking about very rare diseases for clinical trials. So for any kind of pharmaceutical that's being developed, if it's a very rare and fatal disease, it has to meet lower standards actually for the drug to ultimately be put on the market than something that would be much more widespread, like let's say a COVID vaccine. And that just reflects a balancing of values that need to be taken into account whenever you're making a new law.
Yeah, and just I have to add to the points that were already raised, particularly the one just mentioned by Professor Weipel, is that there seems to be this kind of balancing act, right? So in the development of the software, you sometimes have outputs that come as a detriment to possibly data protection. So for example, in the presentation by Heidi, I was thinking about kind of the early phases of the technology. The software is innately inaccurate because you're developing the software, but how does that then respond to requirements of fairness and Article 5 of the GDPR, particularly when there's bias outputs? Do we just kind of accept that as a necessary output of the development of the tool? Or do we say there should be more protections in place?
I think this is then a decision where you want to use it and how many checks you apply to it. Do you use it as a fully automatic system? This, as far as I know, is also problematic in terms of GDPR if there's no human involved. But at first you can develop the system, and then I don't know. You see that credit or loan applications. There seems to be a bias on where you live, and connected with this, it's to which ethnic group you belong, and then there's you obviously, if you look at it, easily see the bias. It doesn't mean that you shouldn't develop the system, because, well, once you recognize the biases, you can do something about it. So that's an improvement that you do. What you have to think about is that maybe the system is not ready to use, or autonomous driving. You can easily and still easily manipulate many cars. So maybe it's not a good idea to not pay attention to driving or while the car drives on its own. So this is then something that with the legal system has to regulate of what is acceptable risk or not. I think there's a Q&A question somewhat related to this. about if there's an ongoing discussion on regulating artificial intelligence development and whether it's dangerous. Many dangerous technologies, in particular in computer science. I mean, computer science has a very strong military background. If you remember, the first computers were mainly built to calculate and improve the trajectories of missiles. Yeah, so basically, computer science started optimizing killing people. And there's been a long history of that the military invests a lot in this. Then it's hard. I think there's so much good that we can gain from that. But obviously, once you employ your employee, that's where other disciplines shouldn't have to contribute. So what's acceptable use for it?
Yeah, thank you very much. I think we have, I would say, 2 more questions now. Take one more from the Q&A. This is a question directed at Katerina from Anne de Moise, who said, "Thank you for the interesting presentation. Could you please elaborate on the AI bond you mentioned? Is it a project under development? Who pushes it? This initiative could raise a risk of decreasing responsibility towards human victims during treatment and decrease the need to implement controls around the use of AI tools in a medical context." So what are your thoughts?
So I may have just misspoken, and maybe Mr. Moise can also clarify her question. So I think probably it was just me mispronouncing the name of the European project, which is BioMap. So no, that project doesn't really have anything to do with regulation, or in fact doesn't really use machine learning much at all. That project was an example that I was using of something that could benefit from the use of big data and big data sets. So that project is aimed at essentially being able to better understand atopic dermatitis and psoriasis, so skin diseases, and see if we can identify underlying markers, whether they be genetic or other clinical indicators that might tell us something about how those diseases progress or the outcomes of those diseases. So we're using in that project, we're looking at different data sets from several different academic institutions mostly, and seeing if you can run some regression analyses and to basically see if there's any kind of link or to recognize any kind of pattern between those different cohorts. But no extensive use of AI there, though I think it would be really interesting to do something like that on such large data sets. So,
yeah, thank you very much, Katerina. I think we have one last question from a member of the audience who I will make into an attendee, and then after that we will head to lunch. So hold on, this will take just a second. A little slow loading. So should be connected now.
Yes, thanks a lot. This question goes to Professor Weipel. Thank you for the interesting talk. And the whole time during you were talking, I was wondering whether the different understanding of privacy has a relevance for AI, because I have the impression, I'm not a technology person, but when we talk about technological sense privacy, it is something different than the legal one, of course. I'm not only thinking about there is no real anonymous data, etc., but I'm thinking about this role of threshold of re-identifiability, which is quite set in a binary way in the GDPR and most national legislations. But that seems, to my understanding with a legal mind, something very different in information technology. And maybe you could say 2-3 sentences about that? Thank you.
Yeah, let's see, I'm unmuted. We always consider an anonymity set. So you're indistinguishable from how many other people. So we might not know exactly who you are, but it's you're either this person or the other person. Then you'd have a set of 2. So and this set size is obviously important. So even if you cannot identify an individual, maybe you can shrink it down to a small set. So this is one aspect. And the other aspect is that even if you're not within a specific data set contained, simply by analyzing the data and knowing something about this group of people might also disclose some information about you. So for instance, if you have this model that classifies images to some genetic characteristics, even if you're not part of the study and your data is not included, you somehow lose some of your privacy if then this algorithm is applied to you. So even if you don't take part, because the study is done, you might lose some privacy. So this yeah, I mean, the textbook example that is given, even if you do not take part in a study looking at which music you listen to and which age you are, the textbook is a bit older that uses these examples. But so even if you don't answer the question, if we know that you're 15 years old and female, we know that you probably like Justin Bieber. That's kind of the textbook example given here. So even if you're not part of the study, you lose some privacy. So this makes it really hard. Yeah.
All right, thank you very much. Thank you for your wonderful presentations, all been very fascinating. And thank you everyone for all of your questions. If there's nothing more to add, I'd like to close this session for lunch, where we will return at 1:35. So thank you all again. Before we start with your presentation, I'd like to officially open session 3 of today's conference, which is on data security and artificial intelligence in healthcare. And I would just like to introduce each of the speakers briefly. So we have 5 speakers of today's session. The first presentation starts with Professor Cecilia Magnusson Sjöberg, who is a professor of law and head of informatics at the University of Stockholm. Her research covers areas of personal integrity and technical systems such as cloud services, digital methods for information retrieval, decision making, document management, and kind of legal and security issues related to electronic signing and archiving. We will then have Dr. Athena Burka, who is a data protection officer at the European Union Agency for Cybersecurity, ENISA, who has a detailed background in IT, security and privacy, and a PhD in electrical and computer engineering from the University of Athens. Our third presentation will be from Dr. Dara Hallinan from Fitzcarraldo. Dr. Hallinan studied law in the UK and Germany and has since 2011 been a researcher at Fraunhofer. And the focus of his work is on the interaction of law, new technologies, particularly in the context of ICT and biotechnologies in society. And he wrote his doctoral thesis on feeding biobanks with genetic data and the role of the General Data Protection Regulation in the protection of genetic privacy and research in biobanking in the European Union. Our fourth presentation will be by Jan Schallenburg, who is a lawyer at I-Rights Law. He studied law specializing in European international law at Marburg and in Berlin before joining I-Rights Law. He was also employed with the Data Protection Authority in the federal state of Schleswig-Holstein before being tasked with working at various European research projects with a number of big tech firms and other universities such as University of Oxford, Leuven and Frankfurt. And then our final presentation for session 3 will be from Dr. Frutzina Molnar-Gabor, who is a junior research group leader at Heidelberg Academy of Sciences. Her research focuses on medical and data protection law, international and European law, and comparative public law. and she received her PhD from Heidelberg University for a thesis on international control of biotechnology. So we have quite a range of speakers and kind of interdisciplinary speakers. So I would like to give the floor to you, Professor Magnusson. Thank you.
Thank you very much. And thank you very much for inviting me to take part in this very topical conference. It's been truly interesting to listen to the previous presentations. Lots of thoughts for reflections. What I would like to do right now is to share with you some reflections that I titled a structured approach to AI-based health research, seldom asked questions. Maybe I should rather say a contextual approach to AI-based health research, because that I would like to make a kind of a holistic presentation of the kind of legal issues that one as a legal researcher, legal practitioner comes across. When I say seldom asked question, that is not a conclusion based on a statistical investigation, public inquiry, but rather experiences from having worked within the field of law and IT for quite some time. And I'll of course come to the kind of questions I'd like to pinpoint. I would right from the beginning say that there is no expression of some kind of a relevance listing, but rather points that I find relevant. This session is oriented towards data security and AI in the health care environment. I will take the liberty of understanding that data security in a broad sense has implications with regard to legal safety, the rule of law, and also the role of law. And I will apply a legal professional perspective to some points. And well, why seldom asked questions? Well, that's really up to the audience to reflect upon in terms, maybe the questions are too simple. That will be good then from a legal safety point of view. Maybe some of the questions are rather a bit delicate, or may they even be boring. In terms of seldom asked questions, I will have a focus of projects. We are all, I take it, more or less engaged in different kinds of projects, and there are loads of initiatives in the public sector, in the private sector, in the cross-border sectors. But the mindset in this brief presentation is a project in its generic character. And one thing that strikes me is that, I mean, AI, artificial intelligence, machine learning, etc. How do we, within a project, how do we conceive of AI as a method, as a technology, as a question mark? And from a legal point of view, working quite a lot within the legal domain, one experience is that lawyers, judges, for instance, don't really relate AI to the modern kind of technology, ICT, that I mean, people that are doing professional work within the field would do, but rather, shall I say, misinterpret the AI-based orientation towards research and development as any kind of automation. I mean, there is so much hype creating AI, so much hype associated with AI that in spite of the challenge, or possibly no possibility to actually define AI, the first reflection is that it might be more important than one might think to try to achieve some common understanding of AI in relation to traditional information communication technologies. So some kind of reflections of AI is, I would argue, important, and not least from the point of view of the non-tech people that need to understand that AI not necessarily that there are different kinds of, for instance, automatic decision making. A second point I would say is we quite often talk about research and development, and as if it was clear-cut what is meant by research on the one hand and development on the other. And sometimes it's wise to try to distinguish between the different kinds of tasks, activities, not least from a legal point of view, as for instance, in Sweden, there are certain legal frameworks applicable to research, of course, not only in Sweden, but broadly speaking, but also with regard to ethical vetting, ethical analysis. And it might be different activities within our European Union project, for instance, within the health data area, could very well have a mix of development activities and truly more research oriented. So that's one distinction to keep track of. And I'm not saying that is easy, but sometimes we talk about research and development as if it was more clear-cut than it actually is from a legal point of view. Yes, and a third point I'd like to make is the fact that although there's lots of funding into the area of AI's potential, both from the point of view of means for decision making and the means for decision making, and also the kind of types of data that can be processed. But what about the legacy data, the heritage, the digital heritage in terms of old kinds of algorithms and conventional applications that are quite far away from AI? And it's not as if those kind of applications are the most attractive ones, but if we are going to move forward in terms of research and developments, someone needs to care about legacy, both legacy data and legacy applications, bridging the back to what we actually have to a very large extent as a fundamental infrastructures in our digital society as of today. Information security. Well, what is the impact of information security? Of course, I dare say, it's absolutely crucial to comply with information security in the context of AI, and of course, so in many ways. And here we need to bridge the gap between conventional law, conventional legal assessments, and, if I may say so, not being a security, not being a techie, but anyway, having to work with information security. I find quite often that there are different cultures, academic cultures, commercial cultures, and what we need to do is to bridge the gap between information security, broadening into cybersecurity, and other kinds of that direction. And what one can't see then is the fact that the GDPR, General Data Protection Regulation, is very modern, if I say so, or open to information security by way of including such security aspects as confidentiality, integrity, availability, accountability, explicitly included in GDPR. But also we have questions concerning other information security, the way in which there are requests for both technical and organizational measures, and also the way in which the GDPR allows for very challenging, but anyway, a kind of a toolbox of anonymization, pseudonymization, de-identification, encryptions. I mean, there is a whole new security perspective included in the GDPR, which opens up, I would argue, for a kind of strategic approach to GDPR. And how can you talk about strategic approaches to a legal framework? Well, I think, I mean, legal compliance is one thing, but there are quite a lot of potential when it comes to personal data protection for research purposes, including AI-based or approaches. However, as previous speakers have illuminated in a very interesting way, there are fundamental challenges, not least with regard to rights of access, explainability, etc., and the black box problem. To add on the list of important factors, the seldom asked questions, and on the top of this slide, here is one example. Well, what about the morale among the researchers? And not least from a legal point of view, do we always apply trustworthy, reliable solutions when processing sensitive health data, for instance? How do we honestly deal with requests for information about ongoing processing of sensitive health data? How do we really comply with security requirements? How do we, from a security point of view, use different kinds of platforms for collaboration? And there are several on the market. So I would argue that ethical issues is not only getting a permission from from a particular public authority, but also how do we deal with sensitive health data in a broad sense at our home office, which definitely could be in the digital environment. Furthermore, reflecting a bit about the lawyer's role in this kind of application environment, and I think it's worthwhile reflecting a bit about the kind of legal skills that are required and expected in different AI-based health data in a broad sense initiatives. There are quite often, mostly there are different advisory groups, internal, external, focusing on legal and ethical issues, ethical and legal, legal and ethical. But what kind of legal skills do we really need in those kind of advisory groups, but also as active partners in these not least European Union projects? One kind of legal work is very much oriented towards substantive IT law issues, how to interpret and apply legal rules in digital settings. But there are also most probably, very relevant and interesting is furthermore the legal track in terms of legal system management. How do you assess, how do you adjust your system design, including AI-based approaches? How do you, what kind of legal skills do you know more precisely? And it boils down, I would argue, that, well, if the question is posed in terms of must a lawyer know about machine learning, depending on the application area, I would say that some kind of understanding is quite often, possibly more than one would think, for lawyers working in the area of law and IT to actually understand a bit more about also the kind of algorithms associated with different AI-based approaches. Conventionally, we have, when it comes to legal automation using traditional IT, we have we have applied primarily static algorithms, deterministic algorithms, as opposed to the more dynamic ones applied in the context of machine learning, of course. And from the point of view of the rule of law, there are very different implications in terms of foreseeability. That might be too much in the conventional ICT environment, but too little of when it comes to machine learning and self-adjusting algorithms. And I'm not arguing that lawyers included in different kinds of AI-based approaches should start learning how to code, but to understand the transformation, the way in which data sets can be controlled, different kinds of how you model, and the implications of black box issues, that on the one hand, black box issues challenge transparency, but if it is black box that we are dealing with using, then that might also be privacy enhancing, because the individual data subjects are not monitored in the same way. And then something that was very much topical a couple of decades ago. It was interesting listening to Heidi in the previous session and the work in Oslo. I say we have a sister institute in Stockholm, also working with, at the time, knowledge-based systems, expert system at the time, the midst of the 1980s. And at that time, there was a huge distinction. I was conditions for designing at that time AI-based solutions, the old school AI-based solutions. And so because in the Anglo-Saxon world, the decided court cases were the major base for AI-based or knowledge-based systems. Well, in comparison with the civil law system that we to a great extent apply here in Europe. But that kind of very strict different conditions for system design, I would argue, is not that visible. And I think it anymore. I think there is a merger, theoretically, model-wise, when it comes to the common law system, simply put, and the civil law system oriented towards rules and regulations. But this is, well, given that you can accept this as in a very broad sense, different characteristics as a basis for the legal approach to AI-based systems, there is also, I put it on the slide in terms of a risk, but I think there is a need of awareness that if you get together a group of legal professionals, the approaches to how to transform legal sources into code for a computer to execute later on, it's still the approaches might very well differ, whether you've placed an emphasis on court cases or rules and regulations. However, that is not as distinct as it used to be. But still, we do have different. Lawyers are not easily to define, and we have all different approaches to also what is research, what is not research, what seems to be, what is acceptable, what is not. So sometimes I would argue that it is important to also reflect upon the legal profession and how it can play a relevant role. And my final conclusion is that there is no doubt that the interplay between law and IT will be continued, and that it's still worth emphasizing that letting law play a proactive role in addition to the conventional reactive one when as a kind of conflict solving mechanism is still valid indeed. I think I'll stop here and thank you for your attention.
Thank you so much. So many insightful questions brought up, thought-provoking questions. Thank you so much. Also ask the next speaker, Dara Hallinan, to take the floor, or take the screen, should I say, and proceed with your presentation.
Can you now see my screen?
Yes, I can.
Okay, perfect. There we go. Okay. So thank you first up for the invitation, and thank you for the 2 prior presentations, which were really great. So I want to talk about the relationship between information self-determination provisions and data security in relation to health research. Often discussions of informational self-determination provisions in data protection law applicable to research are accompanied by supplemental discussions as to what the implementation of data security measures, rather broadly understood, can do in terms of modulating the scope and applicability of these provisions. These discussions take a number of different forms and they rest on a number of different presuppositions. They're probably familiar to most of the audience. One example is the discussion as to the degree to which the implementation of data security, in this case anonymity measures, can function as a withdrawal to, or as a response to the withdrawal of consent by a data subject or a research subject. Another example is the discussion concerning the degree to which the implementation of data security measures can serve as a safeguard legitimating the relaxation of normally applicable conditions to obtain specific informed consent under certain circumstances outlined in Recital 33 of the GDPR. So these supplemental discussions on data security, however, tend to proceed without clarifying the contours of the relationship between, on the one hand, informational self-determination provisions, and on the other hand, data security. It may well be that the discussants feel that the structure and basic tenets of this relationship are already clear and in need of no further explanation. I'm not sure this is the case, and with this in mind, this presentation is an aim to provide a sketch of a structure through which we might understand this relationship and to point out certain key features in this relationship. So the first thing you recognize when you look at this relationship between informational self-determination provisions and data security measures is that the relationship is complex, it's multifaceted, and it's tendentially quite confusing. So in order to address this melee of issues and complexity, we need a structure through which to present the analysis or through which to conduct an analysis. I think one way we might think about doing this is to break down the function of informational self-determination provisions as they apply to research into 3 different layers. So look essentially at these provisions from 3 different perspectives. First perspective is the fundamental perspective. What is it that these provisions are essentially trying to do? The second perspective is the contextual perspective. What other kinds of legal and social prerequisites do these provisions exist alongside, and how do these other prerequisites or other legal obligations restrain the function of informational self-determination provisions? And finally, the third layer is the technical layer. So what conditions do informational self-determination provisions place on securing legitimate informational self-determination? And in relation to then each of these perspectives, we might consider how how data security measures and the implementation of data security measures might then serve to adapt or modulate the applicability of informational self-determination provisions. So against this background of structure, we'll jump into the first perspective of analysis, which is the fundamental perspective. So the applicability of any informational self-determination provision in data protection relevant to research essentially reflects a political choice to give control over some aspect of personal data in relation to some proposed or ongoing research process to a research subject or a data subject. And in this perspective, essentially the research subject, the data subject, is put in the position to freely make their own evaluation as to whether the processing proposed or ongoing is desirable in their eyes. And you can consider this evaluation process itself from two different perspectives. The first is the risk-based perspective. This is the perspective that is really overwhelmingly considered in data protection discussions and has been in data protection discussions up to now, both in academia, I think, and also in jurisprudence. And under this perspective, the data subject, the research subject, is essentially conceived to be considering whether the risks implicated by the proposed research processing are of an acceptably minimal level that they're willing to take those risks on. The second perspective, however, is the normative perspective. And under this perspective, the data subject is essentially considered as engaging in an evaluation as to whether they feel the processing proposed or ongoing is normatively desirable. Do they feel that it's a good thing and something that they wish to support through the medium of donation or allowing the continued use of their personal data? So what does this consideration of the fundamental perspective of informational self-determination provisions tell us about the interaction between informational self-determination and data security measures? Essentially, it tells us, I think, that data security measures can't function as a substitute for informational self-determination when informational self-determination's provisions would otherwise be applicable. And second, it tells us that data security measures can't function as a holistic response to the exercise of informational self-determination. And the reason for this is, whilst it's true that data security measures can interface with the factors of processing definitive of the risk-based perspective, they'll tendentially do very little in relation to the normative perspective. Addition of supplemental data security measures isn't going to make a research or a type of research activity normatively more legitimate in any way. So with that, we move on to the contextual perspective. So informational self-determination provisions in data protection applicable to research exist within a broader legal context. So they exist alongside a whole series of other legal provisions regulating precisely the same processing applicable at precisely the same time. And this means that informational self-determination provisions, while they in principle confer choice onto an individual, they don't confer unfettered choice. Now, these other principles are found, or these other provisions are found in other areas of law, not data protection, but they're also found in data protection itself. And one of the provisions found in data protection is that the researcher or the research institution is obliged to secure a baseline level of data security in relation to all their processing activities. Now, what does that tell us about the relationship between informational self-determination provisions and data security measures? Well, it essentially tells us that informational self-determination measures can't remove the obligation to ensure a baseline level of data security in all processing contexts. That's a rather terse conclusion and relatively self-explanatory, but I think it bears repeating. And the idea of a baseline level of security applicable in all contexts further feeds into the analysis of the technical perspective, which we jump into now. So essentially, in the technical perspective, informational self-determination provisions outline conditions limiting what constitutes legitimate informational self-determination. And these provisions are dotted around the GDPR, for example, in Article 7, Article 413. They're commonly known that, for example, that consent must be informed, that consent must be freely given, etc., etc. Now, in normal processing contexts, these considerations or these conditions are elaborated quite extensively in law and jurisprudence. And what does that tell us? Well, it tells us that, or what does that tell us about the relationship between informational self-determination provisions and data security measures? Well, it tells us that data security measures above the mandated baseline are likely to play little role in influencing the applicability or the compliance with these conditions. And this is true for two reasons. The first is that the conditions are already relatively well elaborated in law and jurisprudence and don't leave particularly much space for the modulation via supplemental safeguarding measures such as data security. And the second reason is that the conditions tend to relate to the substance of the relationship between the research subject and the research institute or the researcher, and the substance of the communication that happens within this relationship. And this is not the substance, this is not the kind of phenomenon that traditional data security measures actually interface well with or adapt well to. Now, that's in a normal research processing context. There are, however, special contexts in EU data protection law where the conditions of legitimate self-determination can be relaxed subsequent to the presence of certain types of safeguards. Of course, I'm speaking very specifically about the possibility under Recital 33 that consent obtained by a researcher or a research institute need not necessarily be specific informed consent, provided that this isn't possible in light of the research proposed, and provided that certain safeguards are in place such that data subjects' rights are protected. What does that tell us about the relationship between informational self-determination provisions and the implementation of data security measures? Well, it itself doesn't actually tell us very much, but there is, however, guidance that confirms that the implementation of data security measures can constitute relevant safeguards which serve to legitimate a relaxation of conditions following from Recital 33. Guidance is available from the European Data Protection Board and now also from certain national DPAs, including the German Datenschutzkonferenz in their opinion on broad consent. Now, up to now, this guidance has tended to be a little bit scattershot in just talking about data security or talking about data security and listing some general types of data security. I think there's a caveat which can logically be added to this guidance, and that it's this: only data security measures which actually serve to ameliorate the risk raised by the loosening of the specific informed condition should serve as safeguards which legitimate the use of Recital 33. It doesn't really make much sense. Let's put it this way. Under Recital 33, there are certain raised risks for the research subject, the data subject, and these relate to transparency. It's that the data subject doesn't know what's going to happen to their personal data because that information isn't available at the time that, say, consent is given. There are lots of different types of informational or data security measures, many of which don't have any relation to this risk at all. So it's hard to see, for example, why a raised level of above the baseline, which would be mandated anyway, a raised level of security concerning illegitimate third-party access should serve as a safeguard which can legitimate the use of Recital 33. Now, there's a really legitimate question you might ask in relation to that, which is why not simply require a higher security standard across the board in a condition or in a state where certain otherwise applicable protections are relaxed? Surely this would be a good thing and secure better data subject, research subject protection. It's completely true. However, more security will naturally come at a cost to other interests in the research process. Security, a higher level of security will require diversion of resources which would otherwise be spent on other activities supporting research. Now, there is already a baseline level of security which should required from researchers, research institutes. And this should already reflect a balance between the rights and interests in research. Now, this balance should only necessarily be disrupted if there's a specific reason for that disruption. Simply generally requiring a high level of security doesn't reflect a specific reason, and therefore I don't think is particularly justified. So with that in mind, I draw certain general conclusions and wind up. Informational self-determination and data protection applicable to research is often discussed sort of in the same breath as data security. And despite the relationship between these concepts actually being quite complex and multifaceted, the basics of this relationship, the structure, the key principles that should regulate this relationship actually seem to be seldom considered. So this presentation sought to provide an overview and some conceptual clarity as to aspects of this, the structure of the relationship, and as to its key defining principles. And I hope, with that in mind, this can be useful for further discussion of the topic. Thank you.
Thank you so much. That was an incredibly interesting presentation. I would like to now hand over to Jan.
Yes, hi. Give me a second to share my screen here. Thank you very much for the kind invitation, which is very much appreciated. And it's always been and always will be, I suppose, a pleasure to participate in workshops organized with Professor Forgo. And I've had so many interesting discussions in different occasions. And I've already been inspired by the talks that I've seen today. Let me give you a bit of introduction. I'm a lawyer working for and consulting with a number of research projects in an AI and other areas. I've been involved with the DPA for a number of years, and from that stems also my activity in international standardization. I'm a chair of the PC 317 Committee on Privacy by Design for Consumer Goods and Services, and also have been involved with more than 10 years in SC27, which is the Committee on IT Security and Privacy in ISO-IEC. And that group has had a meeting this week, which kept me very busy, which is why I also want to express my apologies. This didn't give me quite enough time to deeply prepare for this presentation. So I'll guess I'll just keep it very brief, also for the sake of time for discussion. Overall, I titled this short impulse, Corona versus electronic media files in Germany, a tale of two different approaches. And I'll just use that as a brief example to maybe give some surprising analysis with regards rather to the shortcomings of the GDPR, and take a different perspective to maybe from some of what the previous panelists have mentioned, which mostly I have to say I agree with their analysis. It's more that I guess that we need to extend further. Let's dive in. If we look into electronic media files, that's been a long and rough history. Early work started in 2004 when first legal regulations were passed in Germany, which allowed for filing of medical services with insurance companies. Then in 2015, speed increased, and I remember back from my DPA times that we were heavily involved with preparing that and doing first test runs on establishing a telematic infrastructure, as they're called it, quite sophisticated system on how data might be exchanged. That never got us anywhere, as I believe, in really improving a lot in that system. And now, recently, the German Ministry of Health proposed the draft legislation for patient data protection. And effectively, that law allows access to that data for research purposes. And of course, these sets of data are very promising. As we've heard from other talks today, there is a lot of potential there in such records for improving research in health and avoiding effectively deaths in large numbers. However, what happened in 2020 is that the German Federal Commissioner for Data Protection and Freedom of Expression expressed his concerns against the law and these access clauses, and even went as far as announcing that he would use all his might to stop the law from being implemented. because he thinks it violates European law. And while I do agree with Ulrich, from whom I stole the idea actually of making that little comparison, and I think pointing out to these shortcomings is a very good thing. I think it also shows the complexity of the issue to some extent. Overall, the whole idea in electronic media files is still that the individual is concerned with what data is shared, but then that principle finds an end when it comes to medical research. The other example I have is the recent COVID-19 app. It didn't start in 2005. It started in December 2019 when COVID-19 first appeared in Wuhan, China, as we all know. In March, the RKI in Germany proposed a centralized approach for COVID tracking. During that time, I was on a session in my Privacy by Design committee, and I watched all these efforts, and it became very clear that it might be a viable approach to improve tracking with applications. So though I still have serious doubts whether that will be very effective, even despite recent research from Oxford University. But it was also very clear that if that should prove effective, we need a high adoption rate. And therefore I contacted a colleague at Google and said, hey, how about you implement something, because you and Apple together share some 90% of the smartphone market. So if you have something implemented, then that's going to be the only chance that we'll reach adoption rates by any means. Also, I proposed to him that they would go down on a decentralized approach, because that was my assumption that the only way that people would consent to using such an app would be possible. Funnily enough, and I don't know whether that's connected to my intervention, in May 2020, that's exactly what Google and Apple then proposed to the public. As everybody in this group probably knows, the German administration then switched tracks after huge discussion and interventions from concerned academics and civil society. And in 2020, a decentralized app was published, including the source code. And it had a huge success in numbers with 18 million downloads. If you compare that to Friends numbers, that is much better. We don't know the exact numbers. I don't actually have recent numbers, but the uptake has been reported in France as slow. Bear in mind though, the French implementation, which was centralized, was acknowledged to be compliant with the GDPR. And so both solutions seem not to violate European data protection law. So what does that show us? Well, if you implement privacy by design, augmented with open source possibly, you may get improved acceptance of applications and people might rather consent. On the other hand, legal compliance doesn't necessarily seems to imply acceptance, as the French examples show. Another thing that I would that I'd like to express, and that goes beyond a bit of what this simple tale shows, is that anonymization is not a one-size-fits-all solution in the context of AI. Then, because the result of AI research may expose impact far beyond the individual whose data is gathered. So, and that seems to be what I consider the problem that we have with GDPR-based approaches. They just don't cover a lot of the cases that we should be focusing on. And in that way, it may have been a distracting force in the discussion, because the concern that a lot of people probably also share is that the concentration of huge amounts of data with one or two key players is more at the core of the problem than the fact that I, as an individual, will have to give away data to a player. It's more the problem that from the research on the data, my life can be impacted, but it's not about the data that I give away, but it's rather the data that's accumulated. And in this regard, the GDPR approach generally falls short because it takes this individualistic approach of saying you have to decide on your own what to do with the data, but not much safeguards are in place as soon as the data is anonymized, and not many safeguards are in place, or none of them are in place when it comes to using that data and applying it to other people. And for that matter, I came up for the sake of discussion for today just with two simple propositions that we might want to consider that goes beyond GDPR-based approaches. And they pretty much relate to the same idea, is that, and it also relates back to some of what Cecilia mentioned. Research is not doesn't equal research. There's different kinds of research, and I strongly believe that we should move forward when we're talking about AI-based research, at least, that results of such research, as a general rule, should be made publicly available. It should not stem from the fact that there's exclusive use of such knowledge. And as an enabler for that and a precautious measure, even research that's not published but just started should already be recorded and put into a public accessible record. It's a kind of pity that in Germany we got rid of the public documentation obligations. I sometimes think it's interesting to see that we now have large records centralized of medical data, while at the same time there is no centralized record of the research conducted on such sets of data. So with that, I'll leave you, and I'm looking forward to the discussion.
Great, thank you so much for your presentation. Very fascinating. And now I would like to ask our last speaker, Frutzina Molnar-Gabo, to share her screen. Thank you very much.
So, do you now see the presentation?
Yes.
Okay, great. So thank you very much for the invitation. And I know some people have already mentioned this, but you cannot really mention it enough. It's a pity we're not in Vienna, but we cannot change this. So today I will be talking about concretizing provisions for data processing and security for machine learning-based medical applications. Why machine learning? I think we don't need to explain that. I just wanted to specify more the challenges around medical applications related to AI. And then to introduce a certain kind of approach on a meta level we are using in two of our projects. One on defining guidelines that could be adopted possibly from the World Health Organization for AI medical applications. And the other one is funding by the Volkswagen Foundation for defining data protection by design and default standards for medical AI applications. So actually data protection by design and default will be my point that I will introduce to you as a method of concretizing those rules, which will then need to regard AI specificity regarding what is the need for protection exactly and GDPR conformity in the sense of what is the effect of introduced different protection measures. So just very shortly, I'm showing you this non-closed list of challenges for machine learning-based applications. I'm not going to read these out. I think you're all familiar with them. And if we look into them, I think at first glance, it's obvious that they are all normative, legal and ethical and technical. So that leads to me to the point how to concretize any kind of rules in dealing with defining data protection by design and default for such applications, where I think data protection by design and default is good to connect protection and security. We heard this in this session, differences in how they relate. And I do think it is the best way to manifest compliance with the data protection principles, where we also have protection and security also integrated. And it is, of course, a mindset. It is a habit introduced, overlapping functional, commercial, or any other kind of thinking, which I do think is reflected already in the European Data Protection Board's guidelines. Those were the number 4, 2019, on data protection by design and default, which I do think introduced this mindset, but I do think UDPB could have done more and introduced this, actually articulating it as a method of translating the principles at the middle level. Why middle level? The concrete articulation, how to do this, must be derived, used from GDPR compliance, and it must be induced bottom-up approach from the specific context we are using these technologies in. So top-down, GDPR compliance, how will you go about this if you want to define rules for designing such systems? I would like to focus on one element of data protection by design and default, and these are the TOMs, the technical and organizational measures that play a crucial, significant role in the GDPR and are very often attached to so-called undefined legal terms and concepts. I did not list the articles, but you can read Article 25, which is prominently the default and design rule, or Article 89, even for the member states, and so on. Article 32 also related to security measures. So it's all about defining appropriate technical and organizational measures, and how you go about appropriateness could be the following route. Appropriateness, of course, could be determined in a legal way from the legislative, from EU or member state legislation, in the sense that there are concrete technical standards for a concrete application context that you can use. For instance, if there is an ISO standard defined for a certain kind of application. Of course, legislation might give the route for weighing and define a certain scope of weighting, which then would be steered by legislation and the legislative, but will be decided throughout the application, which can of course be informed by supervisory authorities' guidance, previously ex ante, or by drawing on case law knowledge ex post. So this way, you can actually derive a certain catalog of TOMs. To give you an example, it's squeezed on the slide, I know, but this is section 22, the Federal Data Protection Law in Germany. You don't have to read the whole. It's about those appropriate specific measures that are defined in national law, and they include these 10 points in particular. So it's not a closed list, where you can have these catalog of TOMs listed here. So actually, once you have those typicalized from the legislation and informed the way I've described, you can promote a certain kind of typecasting of the protective effect of various TOMs. Of course, you cannot do this without knowing the context that you're going to apply those TOMs. So after that, I suggest as a method to take the bottom-up approach and look into the AI specific by design and by default rules that might be used for such medical applications. And of course, the context will be decisive for weighing the affected rights and interests, which I think is already in the medical context. If it is about diagnosis and treatment, or even research, it is quite well outlined. As a sub-method, I suggest to do a certain kind of case study typecasting, where I have identified 4 crucial points, which I think will inform the AI specificity of certain kind of applications. And these are which period of the doctor-patient relationship is affected. It is of decisive interest to know whether we are in the anamnesis, in the clinical findings part of this relationship, or we are already in the part where we select the therapy. Why is this important? Because the level of the subjective well-being of the patient will inform certain kind of steps and sections of this relationship in a different manner. When it comes to the therapy, it's obvious that it will come to the fore in a much stronger way. it's important to know in which role machine learning involved will relate to data processing. So what is the exact role and step that is being conducted by this machine learning element? And of course, how far is it automated? Is there human control? Is there oversight? What role the doctor still plays or other human actors? And of course, the capability of patient consent to consent, not just in the absolute way, consciousness or age, but also relative capabilities where you can decide about using broad or dynamic consent that might be adapted and might be a better way to move forward. I think those are the 4 very specific elements that will define and inform the weighing of affected rights and interests on this meta level. Of course, this can also be informed by supervisory authorities' guidance and by case law, as I have mentioned before, for the top-down approach. But from this analysis, we might have then a typecasting of the need of the protection of patients in a more generalized manner, specified for our specific AI context. So we did this actually. I don't want to go through all the slides in the interest of time. We're a bit behind, but we did this section-wise for the different periods of doctor-patient relationship, for issues around information and consent and anamnesis, clinical findings, standard diagnosis, issues around therapy, and of course, documentation, and in all these rules. Now, if we look into the federal data protection law in Germany, again, the same section I have showed you before, section 22 and paragraph 2, we have other factual and legal workability yardsticks that will influence our top-down and bottom-up approach. Because once we identified what is the need for protection in a certain situation of the patient and what kind of protective effect different measures might have, we still need to take into account these factors such as the state of the art, the cost of implementation, nature, scope, and context and purposes of the processing, as well as the risks. And it's obvious that they are not just factual workability measures and yardsticks, such as the cost of implementation, but also legally influenced factors, such as the purposes of the processing. So in a very, very schematic way, you might want to introduce the way of thinking, how to define data protection by design and default rules for machine learning-based medical implementations by typecasting bottom-up approach protective effective measures in the light of typecasted need for protection of patients, which of course is strongly attached to the legal balancing and weighing of rights and interests, influenced by case law, by supervisory authorities' guidelines in different manners, and of course, the external factors, external, I mean, in a sense that they are not inherently related to the bottom-up and top-down approach, the slide that I have showed you before. I think that this kind of method is crucial to integrate technical and legal interoperability. We always talk about either one or the other, but we do not really merge them, which I think is important. And of course, on the mid-level, this would provide a different kind of flexibility for making room for ethical decision-making. And maybe the last point is that the GDPR itself defines certain kind of regulatory tools, such as code of conduct, that might be able to introduce certain kind of mid-level rules defined for specific applications and sector-specific contexts. And so these could be informed regarding content, probably based on such kind of meta-level analysis. In the interest of time, I will stop here and I'm happy to discuss. Thank you.
Thank you so much for the presentation. Another very insightful presentation. We now have a chance for some discussion. So if you'd like to speak in terms of attendees, please raise your hand and we can transfer you across to become a panelist and you can speak and ask questions. Otherwise, please present your questions in the Q&A if you prefer to type them out. And for panelists, if you have any questions or discussion points you would like to discuss, please go ahead.
I have one question. Sorry, go ahead.
Okay, thank you. I just want to share with you the information that we've had the first, to my understanding, court case when a private individual requested to get access to the algorithms being based within the public dental system. The request was not made with regard to Article 15 GDPR or the information duties in GDPR, but rather to national confidentiality secrecy legislation. The request was denied with reference to information security. It's not the Supreme Court case, but it is case law anyway, and it illustrates the interplay between transparency, security, and in the long run, also privacy. Thank you.
That's very interesting. Do you have this decision in English?
No, but I can send you, well, I'll...
Please do so.
Yep.
If nobody else has a question, I actually have a question regarding your presentation. If I may put this, it's on your slide, you mentioned the strategic approach of the GDPR and questioned this, and I did not really understand how you mean it. Could you say 1-2 sentences about that? Thank you.
What I say in general terms, are you still? Am I still online? Wait. Hello?
Yes, you are. We can hear you.
Okay. I mean, one approach to GDPR is naturally compliance. In practical work, I come across technicians that actually conceive of GDPR as a security regulation, and then we have the more privacy approach, and I can also see that different uses and different applications, it's not quite clear in beforehand how the different provisions in the GDPR honestly will be considered, and to what extent, under what conditions. So I think it was my very generalized way of saying that the GDPR in itself can be very dynamic, and I was myself very surprised when at the conference, and there was a speaker saying that now let's look at GDPR from the point of view of lawyers, and as a lawyer, I think quite a few of us would conceive of GDPR as a legal framework. So that was just a rough way of shedding light on that tension.
Sorry, I was muted. Thank you very much. I see we have one question in the Q&A, which I'll read out from Catherine Altabelli. It says, concerning the last presentation, in paragraph 22, section 2 of the German law, if I'm not mistaken, it mentions the likelihood and severity of other rights of data subjects, which should also be taken into account. How should this exercise be carried out, and what rights does the law point towards here? So this is aimed towards Fritzina, I think, in the last presentation.
Yes, I think so. Thank you. I think the word risk is missing. Can that be in the question? Because it should be about the severity, the likelihood and severity of risks of other rights of data subject. Yes, so of course, the fundamental right to data protection is a fundamental right, and you can interpret this section, I think, 2 ways. Either you are thinking about the other fundamental rights that are related to certain kind of contexts and can be affected by certain kind of data processing, or you think about the other rights in the sense of the many individual subjective rights that are actually derived from the fundamental right to data protection that the data subject has. But I think that it's basically the first. So this is actually a technical exercise, if I understand it correctly, to approach what kind of risk do we have to affect those rights, which is actually in the second step. So it's not the risk, which is also a technical approach to identify, okay, can I re-identify according to the data, which is also then the question, can I do the processing, but in the course of the processing? So I understand this as a very technological approach. Hope this answers the question.
That's great, thank you. I don't see any other questions from attendees, so I'm going to make the most of that and ask my own question. This one I think is for Jan, but also maybe it connects to Dara's presentation as well. So you suggested that kind of in the context of stating that the GDPR, or alluding to the GDPR being too individualistic, that you said that AI-based research is only permissible if results are published in the open or to the general public. Were you referring to results that could contain personal data? Because if so, I wondered if this would affect the informational self-determination and individualistic aspect of the GDPR, because there seems to be a slight kind of competition and interplay between the two things. On the one hand, the protection of individual rights, and then also the regulation of outputs of large-scale data processing. I wondered if you had any thoughts on that.
No, actually, I want to encourage looking beyond the informational self-determination. I highlighted that concept in a talk that I gave yesterday, actually, because I thought it is still a very valid term, especially in these days where we're now rather talking about digital sovereignty, which as sovereignty is more concept concerned with nations. But no, I think we need to think beyond this informational self-determination approach. Whenever you're revealing information about yourself, you're also revealing information about others. And that maybe relate back to some aspects of the 1983 court decision on the Volkszählung, because that already highlighted that we're social human beings, so it's not a property right by itself. But nevertheless, I came to acknowledge that just reducing it to this individualistic notion where everybody can determine, well, you can do with my data whatever you want, doesn't cover everything, doesn't cover all the risks that are associated with modern IT systems, including AI, and especially AI, actually. So whenever you are sending out data, you might expose risks to the individuals, to their rights, to their freedoms, but also to society as a whole. If we're looking at, for example, Facebook, now that spans beyond health data, of course, and is a bit beyond scope. But if you look at things like Facebook and other social networks having these huge data sets that could potentially, and maybe already do, influence how democracy works, then we are going beyond individual rights. Granted, we have in the Charter, we have democracy as an individual right.
That's great, thank you. I don't know if you have any thoughts on that, Dara, from the different perspective, or?
I feel like I'm about to fudge an answer, so my apologies for that. But maybe just to add a little bit to what Jan said, I feel like we often play pigeonholing exercises with the GDPR and data protection, that it is individualistic, or it can't do that, or it can't do that. Look back over the history of data protection law, we don't know yet what it can and can't do. And at this stage of development, it's shown itself to be phenomenally versatile, and now its versatility has already been sort of baked into the pudding, so to speak. You have everything in the GDPR you need to do more or less anything you want.
But that's a problem. I mean, that's a huge problem, actually. That's more something of a banana republic in that regard. Right?
Okay, well, we can talk about what degree that's a problem or not, but we could also respect that it's a truism. I think you have different perspectives on what law should and shouldn't do, and what we can do currently in light of the information revolution that can paint the GDPR in good and bad respects in terms of its flexibility. But to move on a little bit, you have, for example, the data protection impact assessment obligation, which actually refers to the obligation to assess risks to rights and freedoms of all natural persons, for example. You also have supervisory authority jurisprudence that goes back in time, clarifying that the GDPR can be applied to multiple persons in relation to the same type of personal data. So for example, you have guarantee decisions which have extended dual data subject rights in relation to a single individual's genetic data. So it has a phenomenal degree of flexibility. So I would just highlight that when we say that it's an individualistic framework or not, it is, but it has capacity to be something more. But, and then this, I think, is where maybe I come back a little bit to what you said, Jan. I wonder if there is a question as to how far we really want to extend this flexibility in a second order piece of legislation, because there is a degree to which if it does everything, it also does nothing. And I wonder if we don't maybe need other forms of legislation to jump in and also play a role in relation to the regulation of power structures in information, in relation to ethical uses of information, et cetera, et cetera. I don't actually pass a normative judgment and say we definitely do or don't, but we do tend to throw all problems the direction of the GDPR, and I'm not sure this is always the correct course of action. So I hope I didn't fudge too much, and that was.
Thank you.
If I may directly answer, now, don't get me wrong, I'm not generally opposed to the GDPR, as some of my colleagues are, and probably wouldn't have never joined a data protection authority if I were generally opposed to that approach. I'm just saying it may not successfully address all of the problems, and I'm also a little bit concerned about the broadness and unclarity in the regulation right now, because it exposes a number of serious problems. And with that regard, I think we're perfectly aligned there, that we need secondary or different mechanisms to supply what is actually needed to tackle a number of problems. And one thing I want to highlight, and that's maybe also interesting for the further direction, is the mechanisms of self-regulation in the GDPR. We could certainly start using codes of conduct, although I remember in earlier talk today that there were some concerns with the regulatory approach, but it's really actually geared, and that's also what we see when we're consulting with codes of conduct and developing them. They're really geared to solve very concrete problems and giving concrete actionable implementation guidance for certain areas. And such codes of conduct could address a number of concrete problems that we're facing, including, but not limited to, several of the problems that were voiced today.
That's great. Thank you so much for your input. Yeah, sure.
Is there still time for a slightly different comment that came into my mind as you originally posed a question about right to self-determination from the informational perspective, because there is an emerging discussion foremost related to brain data nowadays, and we had some presentations on that and are still going to have about introducing an understanding of informational self-determination for groups. I know this is a slightly hotly debated topic in different constitutional law perspectives, and I don't want to enter into any, can you derive a group informational self-determination according to, I don't know, the German constitutional law interpretation. But I do think it worthwhile to stop and have a look, does this make sense by certain kind of data processings? And I just want to inform my own thinking with your views, if you have any on this kind of approach. I know it is very short time and a very huge constitutional law topic to reflect, but I just wanted to throw it in due to the brain data presentations that are going to emerge still. Thanks.
I'll again be happy to weigh in, but I don't want to steal time from others. That's a very interesting approach. I myself did in my own PhD research look into I haven't thought about group informational self-determination as a term back in 2007 or something, really, but trying to address that problem. And maybe that's a term that can work, but it's really it's really finding the right terms that click with people, and whether that's something that will make it into a broader discussion, I'm not so sure about, but certainly an interesting thought exercise. And sometimes these exercises are just the enablers to then come up with the right leverage to foster a good discussion. So I think very good idea, why not?
I wonder if I might also chime in, but not if anybody else wants to speak first.
Please go ahead.
So there are sort of templates, template ethical instruments which already push some kind of group self-determination rights. I think the Declaration of Helsinki does something very similar, but tendentially these have functioned in other jurisdictions with other social models and haven't been exactly transferred over to Europe. I also don't want to jump into the discussions about whether this is constitutionally possible under the different models and so forth. I would say, though, that there are some serious problems about integrating this into our current legal structures. We don't really have a good way to balance how one informational self-determination should be, in principle, balanced against another. So if you have group rights to determine what happens to group information, does that then mean that the individual has no rights over their information? And if not, well, what does that mean for group self-determination? Does that mean actually it's not self-determination, but some kind of consultation on a very general level? And moving more specifically to current data protection law, which is what I would imagine this would fit in the current legal framework as a principle of protection, you have to come up with a way to define which groups are going to have self-determination rights. And this has been a really big discussion in terms of genetics for a while. You have groups embedded within groups, embedded within groups. And I'm not sure if that's exactly the same in relation to brain data, but I'm venture that it probably is, to the point where it's very difficult to say which groups you want to actually give a right to and which you don't. And we're going to need that definition if we would like to go that direction. We could work on some kind of impact-based definition. And on top of that, you're going to need to define a group as a completely different form of data subject to current data subjects, because the GDPR treats all data subjects the same. And you can't give two data subjects exactly the same set of all rights in personal data. It's chaos. The GDPR doesn't provide a structure for the resolution of that kind of conflict between coexisting data subjects, potentially multiple coexisting data subjects. I wonder if maybe before jumping to giving groups self-determination rights, which is quite a heavy approach, I feel, we might think of extending some of the protections implied by the GDPR or under the GDPR or in relation to that exists otherwise in relation to information to groups, but which don't impact on the protections already applied to individuals. So for example, data security measures. The UNESCO Declaration on the Human Genome actually did this back in like 2005, and then the idea disappeared out of fashion. We could also imply that groups should be taken into account explicitly in data protection impact assessments, and perhaps should play a role in the consultation process prior to the start of a processing operation, so that at least their perspectives were implemented. And all of this would not particularly strongly impact, I think, the balance of interests which already exists between data subjects and data controllers, such that we could introduce it into the legal system without causing all manner of chaos.
Yeah, or exactly, or define it from the other way around, because to most of the individual subjective rights in the GDPR, you have the corresponding obligations. And you can, of course, think about complying and fulfilling those obligations in the sense of a group manner approach regarding, for instance, information obligations and so on. Yeah, thanks.
Great, thank you so much. I'm going to have to call this session to a close now, but it's some really great discussion. I'm sensing new laws on the horizon and lots of competing interests, so I'm sure we'll have lots of work to do. So it's a 10-minute break now, and then we'll return for session 4 at 3:30. So thank you all very much, speakers. Thank you for questions and discussion, and I'll see you in 10 minutes.
Welcome back, everyone. I welcome you now to the last session, our final session. It's called Artificial Intelligence and the Applied Law, TVB-Cloud Project on Prevention, Detection and Treatment of Neurodegenerative Diseases, Technical, Legal and Ethical Challenges. And this session is specifically and especially dedicated to issues concerned with the virtual brain cloud. I will now introduce the speakers. So this session will be opened by Professor Petra Ritter. She both holds a MD and PhD. She is head of the section Brain Simulation at the Department of Neurology with Experimental Neurology of the Berlin Charité Hospital, and also Berlin Institute of Health Johanna Quandt Professor for Brain Simulation. There she leads the Ritter Lab. Professor Ritter is also the project coordinator of the Virtual Brain Cloud, and she will be speaking about, no surprise, the Virtual Brain Cloud, building a reference cloud architecture for integrating health data. This presentation will be followed by the presentation of Dr. Nathan Lee about I'd Like a Second Opinion, how do we regulate digital doctors? Dr. Lee is a senior research associate at the University College London, Institute of Health Informatics. He's working on projects in clinical care and research. He does research, or his research focus is on the role of information systems in supporting healthcare delivery and empowering patients. His presentation will be followed by André Gemünd, who will be presenting on TVB-Cloud secure infrastructure from theory to practice. He's a trained computer scientist and head of data center IT, as well as researcher at Fraunhofer Institute for Algorithms and Scientific Computing. In his work, he focuses on on high performance computing, data center technology, cloud infrastructures, and the implementation of security requirements. And the session will be closed by Dr. Angela Bradshaw about TVB-Cloud, ethics, and patient perspective. Dr. Bradshaw works with Alzheimer Europe, and together with us, the University of Vienna, makes sure that the project fulfills its ethical obligations. She received her PhD from the University of Cambridge and was a postdoctoral fellow at the University of Glasgow, where she did research on cardiovascular topics and gene therapy. Professor Ritter, I would like to ask you to please begin. You should be able to share the screen.
Okay, can you see the full presentation?
No, it's still the one we had where it's half, the presenter notes.
Better now?
Yeah, now it's perfect. Thank you.
Okay, wonderful. So thank you very much, Michael, for the introduction, and thank you to the entire Vienna team for organizing this really important and timely conference. As mentioned, I will be talking about the Virtual Brain Cloud project, and I would like to start to give you a short introduction to the virtual brain. The virtual brain is a simulation tool that merges human imaging data with mathematical models to enable personalized brain simulation. So we reconstruct a brain model from a person's brain imaging data set. And here you can see the process of shaping a virtual brain model using different modalities of brain imaging data. For this, we have automated pipelines available. The virtual brain simulator then generates activity, the same type of signals that we can measure in the real brains. And as you have heard in the introduction by Jan Bjarle earlier today about the Human Brain Project, the European flagship project, we built an infrastructure there, eBrains, to enable simulations also of the virtual brain at a larger scale. That means at high resolution and for large patient cohorts. I will now give you a short overview of what we have achieved in terms of simulating virtual brains in the Human Brain Project.
The Virtual Brain Tool Suite is a large open source ecosystem with an end-to-end workflow for creating personalized brain network models and simulating them. It is now available on the European Brain Research Infrastructures, or eBrains Cloud. The Virtual Brain on eBrains, or TVB on eBrains, allows users to construct, simulate, and analyze personalized brain network models. Its powerful features can be used from your local computer, making computationally expensive neurological research possible from the comfort of your web browser. The virtual brain integration in eBrains allows users to have an end-to-end experience of personalized brain model creation and multi-scale brain simulation using high-performance computing in the cloud. This makes it possible to process large cohort databases, which in turn makes it possible to produce generalized results. This is a precondition for being able to use these results to develop potential medical treatments, therapies, or diagnostic procedures. The Virtual Brain on eBrains ecosystem software is open source. The software is distributed in the form of execution-ready Docker containers that can be pulled from Docker Hub. The containers can be executed on supercomputers using secure container environments like Saris or Shifter. Jupyter Notebooks enable users to operate the containers on supercomputers directly from their web browser. TVB on eBrains includes a variety of simulation tools, pipelines, and data sets, which we will introduce in the course of this video. The Virtual Brain ecosystem on eBrains contains the Virtual Brain Simulator that can be used in the cloud with a supercomputing backend, ready-to-use pipelines to build personalized brains that enable users to process their own imaging data or share data with large cohorts, TVB-ready imaging datasets of patients and healthy controls discoverable via eBrains, the TVB multi-scale co-simulation web application, which enables co-simulating some brain regions at a finer scale using the NEST simulator, fast and parallelizable hardware-near implementations of TVB models, containerized for direct use on eBrains via Colab notebooks. The INCF training space, with a dedicated area for the virtual brain, where a rich multitude of didactic use cases are available with video tutorials, Jupyter Notebooks, and example datasets. All software and datasets in the Virtual Brain ecosystem are registered and annotated in the knowledge graph to make them easier to locate and use. The tools are functional and ready to use, and you can be the next user.
So the challenge with this kind of complex biomedical data is that anonymization is not possible. Typical data anonymization strategies like removing metadata, releasing only subsets of data, or deleting facial features from MRI data are insufficient to protect the identity of the person, the data subject, as it was shown that the re-identification is possible with just 40 functional connections or 15 demographic attributes. So complex biomedical data cannot be anonymized. Precisely the information that characterizes the biomedical state of a person and is therefore useful for biomedical research is typically a very unique feature of that person that can be used to identify them. If the privacy is breached, the individuals from which these data were collected face a number of potential harms with respect to their societal reputation or economic circumstances. Several large-scale initiatives are collecting thousands of features from millions of people, but infrastructure with appropriate technical and organizational measures for managing and processing sensitive data is missing. So the data protection by design and by default, Article 25, requires to take into account the risk for the data subject and to implement appropriate technical and organizational measures to protect the rights of the data subject. Article 42 certification encourages the establishment of data protection certification mechanisms for the purpose of demonstrating compliance with GDPR. And this may result in the European Data Protection Seal. According to Article 43, certification bodies will be formed for this purpose. The problem is that presently they are not yet in place and there is no real certification on an EU level possible. So here I'm showing a list of initiatives in which I'm personally involved that work on the development of infrastructure for processing of sensitive data across different scales, from the European level via the national level down to the local hospital level. And I want to share with you some of my experience with respect to building those infrastructures. So let me start with the European Open Science Cloud. I recently joined the architecture working group. The EOSC, European Open Science Cloud, aims to accelerate the deployment and consolidation of an open, trusted, virtual federated environment in Europe to store, share, and reuse research data across borders and scientific disciplines. And for this purpose, the EOSC works with many different stakeholders, with research institutions, with research funders, with policy makers, and also with the operators of the infrastructures and the computation resources. Another European level project is the Human Brain Project, and you have heard the nice overview by Professor Biale earlier today. I also have shown you the small overview video about the workflows that we have established there for the virtual brain. The eBrain's infrastructure of the Human Brain Project is based on 5 supercomputing centers across Europe, the so-called Phoenix infrastructure that tries to integrate data repositories with scalable supercomputing systems. And an initial version of this infrastructure is currently being realized through the Interactive Computing E-Infrastructure ICEI project, which is part of the Human Brain Project. Another local development that I'm leading in collaboration with the local computer science department and the non-for-profit company INDOC, a Canadian-based organization, is the virtual research environment for the Charité and the Berlin Institute of Health. And I would like to play another short video to explain you the idea of this virtual research environment.
What is the virtual research environment? We have many pools of medical research and clinical data worldwide, with information from patients and healthy individuals flowing into them. But it can be hard for scientists to locate and process different data from different pools. The goal of the Charité Health Data Platform and the virtual research environment is to make medical data secure, findable, and usable for research purposes. We follow the FAIR guiding principles for scientific data management: findability, accessibility, interoperability, reusability. Our aim is to provide user-friendly tools that help researchers to be able to access and use data securely without intensive specialized training. Imagine dashboards that let researchers easily see information about all the available data, and workbenches that allow them to easily read, write, and share the results. What is the Charité Health Data Platform, or the HDP? The HDP is responsible for ingesting patient data from the Charité Hospital and making it available for use in research. It is still a work in progress. The Health Data Platform is made up of many different components, including a data lake, a clinical data zone, and a research data zone. Here you see the cluster's many parts and its repertoire of functionalities. The HDP's underlying technology is an Apache Hadoop cluster. It is an entire ecosystem of frameworks, tools, and software built for scalable and reliable storage and distributed processing of data. The Virtual Research Environment, or the VRE, integrates with the Charité Health Data Platform systems and extends its functionalities. The goal of the VRE is to make it easier for researchers to find and securely access data and use it in innovative ways. What are the virtual research environment's most important features? The VRE will provide support for new kinds of data. The Health Data Platform already includes systems for ingesting and processing some kinds of data, such as lab testing results or electronic patient records. The VRE will develop solutions for additional types of data, such as functional test protocols and radiological imaging. The virtual research environment will also provide a model for data annotation. The VRE will develop concepts for metadata, data catalogs, and data models so that data can be fully annotated. This makes it possible to search for and find data using search terms and keywords. The VRE will provide a portal that is open also for external users who do not belong to the Charité. This will allow external data to be ingested from other sources and external collaborators to access the health data platform's data. Security and privacy is also a key concern for the virtual research environment. Each data set in the VRE will have a responsible data controller. This might be, for example, the lead researcher of a study, or in the case of a clinical routine data, a board. They are responsible for providing proof of consent from the patient and granting other researchers access to the data. Legal regulations must be strictly followed to protect the data privacy of all patients and make sure consent has been given for the way the data is used. The VRE will provide digital tools and services for using data, such as simulators, analysis, and machine learning tools, and processing pipelines. New tools can be added, or existing tools can be extended by you, the user. These tools are available in a secure environment and accessed on the workbench. Encrypted data can be accessed and processed remotely on high-performance computer clusters. This prevents sensitive patient data from being leaked, with the added bonus of avoiding long and error-prone data transfer times. If you have the permissions, data can also be securely transferred to your own or another computer. In addition to helping doctors share medical data, the VRE provides access to the pre-computed results of previous research projects. This means alongside research papers, you can also find the data sets, notebooks, and tools used to produce those results. This will help validate results by making the research transparent and repeatable, and increase collaboration between researchers of different disciplines. The VRE doesn't just work with the Charité Health Data Platform. It will also be interoperable with other international open health data initiatives, such as the Virtual Brain Cloud, or the Human Brain Project, or the European Open Science Cloud. So, in summary, the virtual research environment will extend the health data platform by providing workflows for radiologic imaging data, a model for cataloging data and making it easier to find, workbenches for modeling, simulating, and analyzing data, a portal that is open also for external users who do not belong to the Charité, interoperability with international data commons like those developed under the European Open Science Cloud, for example, the Virtual Brain Cloud or the Human Brain Project. We want to ensure that this development is open and accessible to all clinicians and scientists of the Charité and BIH so we can solve today's pressing medical challenges together.
So unlike the eBrain's cloud infrastructure, the virtual research environment infrastructure is deployed on dedicated machines located within the secure hospital premises. And in the context of the Virtual Brain Cloud, we develop a solution that is portable outside of such safe hospital environment and open for external user groups. And here you see some of the safeguards that we are implementing for the Virtual Brain Cloud and also the virtual research environment. Oops. So the Virtual Brain Cloud is a European project with 17 partners and another Canadian partner who does the technical coordination. And our goal is to enable exploitation of health data through simulation on a large scale to support clinical decision making. André Gemünd from Fraunhofer Sky will present the details of the implementation. In the Virtual Brain Cloud, we are developing infrastructure for sensitive data processing and compliance with EU regulations, protecting subject rights and complying with the GDPR principles. We develop blueprints and recommendations with respect to derogations for scientific research purposes. And you can find the information and reports, webinars, and recordings of conferences on our website. So the key message here is that also with GDPR, it is possible to share and to process health data on a larger scale. And we are developing solutions in the Virtual Brain Cloud and treat GDPR as an enabler for personal data processing. And with this, I would like to end my presentation. Thank you for your attention.
Thank you so much, Peter, for this fascinating presentation about the virtual brain cloud. Maybe we can just continue with Dr. Lee, and you can start sharing your screen if you are ready.
Of course. Is it me next, or was it one of the other speakers? I just wanted to double check. It is me next. Okay. Yeah. Give me 1 second and I'll share the screen.
Thank you.
Okay. Let's make sure we get this right. Great. Can we see it?
Yes, we can see it. Snow, it's moving.
Excellent. Good stuff. I think we're there. Well, good afternoon, everyone. I'm very grateful for the opportunity to be able to speak to you this afternoon. Of course, even more so given the pandemic situation. But like others, I'm heartbroken we can't all be together in Vienna. So hopefully we'll be able to meet in person soon with a bit of luck. So what I thought I'd do was I'd start off with just some reflections from the day very briefly on this. And I wanted to preface the talk by saying that I don't think we should give GDPR too much of a hard time. I think it's been a landmark piece of legislation that put into practice a lot of basic things that information governance experts like myself have been saying for years, but hadn't got any real basis to enforce or to engage. One thing's for sure is that GDPR has made us all think very carefully about how we handle data, but it's made it a topical discussion that has hit the mainstream on an epic scale, not just within Europe, but all around the world. I've been involved with work at the European Institute at UCL on looking at the impacts of GDPR, the implications of Brexit, and the implications around Privacy Shield. And one thing's for certain is that the international perspective that we've gained demonstrates that there is a great deal of attention on this, whereas before this was more of a kind of nuanced point that legal and information governance professionals would engage with computer scientists over at a smaller scale. And before I proceed, just to say, I wear several hats. I work with UCL, of course, and the Institute of Health Informatics. I'm also the information governance lead for UCLH, NHS Foundation Trust on research and innovation. So I will be peppering my talk with some anecdotes from the real world in terms of those areas. But today I'm here as the information governance lead for IHD, the European Institute for Innovation Through Healthcare Data, and I work very closely with Deepak, whom we heard earlier. So whilst I don't think we should be too hard on GDPR, I do think we should be quite hard on what I would call abject stupidity. Unfortunately, we've had a few examples across the UK of how not to do things, which I'm hoping everyone can learn a few lessons from. But I felt this case was particularly pertinent for our talk today, especially within the context of what we're discussing, which I'll come to shortly. Our Prime Minister referred to the recent fiasco about managing A-level grading as being the fault of mutant algorithms. But what we saw here was the deployment of mass profiling across our A-level and our GCSE students to be able to account for the fact that we just couldn't have them sit exams. Now, where they'd already sat exams and done mocks, their teachers have graded them and they've made recommendations and provided a recommended grade. But our quality inspector for education decided that in case of a bias kind of towards a more positive view on the results from the teachers, they deploy this algorithm. Unfortunately, the algorithm would actually result in a lot of grades being dropped to the point that many thousands or tens of thousands of students weren't going to get their first choice at university, would have to rethink their futures and so forth. But then it emerged that the algorithm was using all kinds of metrics and biases, particularly around where the students were going to school, where they lived, and very often there are individual circumstances where these were known. And in many ways, it's applied a very, shall we say, Victorian prejudice that was rife in England about 200 years ago about judging people on where they went to school and where they were from. So in many ways, what was achieved with this algorithm was to computerize that prejudice. And as you can see from the photos, which came from the Financial Times, The Guardian, two things are clear here. First of all, I think we have a bright future because our young clearly nail complex issues. They've actually highlighted all the issues with misapplied artificial intelligence in their placards. And so I think they seem to be able to understand these issues very well, probably better than me. And second of all, as a brief aside, most of them are actually wearing face masks, which is something of an amazement at the moment, given the situation. But ultimately, the decision was reversed, but the damage was done. People had already made different choices about university or whether they're going to university or not. Things had already been set in stone. This is a very complex area. And when we think about these kinds of applications in the healthcare space, especially in the NDD and Alzheimer's and dementia space, we have to be very, very careful as to what we're actually dealing with. So I want us to think about context and wider context when we talk about these algorithms and take lessons from where things have gone wrong. So entirely about context, we've looked at regulation in great detail today. It's been a very rich discussion about what's available, what's in play, and where the challenges lie. But I've always viewed regulation as the foundation on how you proceed. Laws are passed, regulations are passed, good practice guidelines are passed, and professional standards are developed, standards are developed. And certainly in the UK with a common law tradition, our legal system will look to statutes, it'll look to common law, it'll look to professional standards, and it will look to wider international standards for best practice, where answers may not be clear in a particular case. But thinking about this, to my mind, there are two broad areas, both interrelated, where we have to get this right. First of all, is in care provision. When it comes down to it, very much of our data comes from the therapeutic relationship under a duty of confidence between patients and their practitioners. As we know, within the neurological area, we have particular challenges there, particularly around capacity to consent, which I'll come into shortly. So the doctor and the patient and their care team have to be within this trusting relationship to get anything done, especially around making sure that information is shared. But we also have a vibrant community doing research that involves not only the healthcare service and the patients, but also industry in terms of pharma, but also in terms of tech companies looking to enhance care. But we have to make sure that it's not only safe, but also effective in terms of what we're doing. And when you start to think about algorithms and machine learning in this space, we start to have a very different lens as to what we're trying to regulate. So moving forward, for neurological degenerative disorders and dementia in particular, these are fraught with complexities. Certainly across Europe, the concerns around capacity to consent are clear. So whether it's individuals who are the patient or their families or carers or proxies who are involved, the actual ability to consent to research, for data use, for any of these kinds of areas is already within a complex area. And when it boils down to it, we don't know very much about these conditions and their progress. We know some, but we've all recognized that we don't know enough and we need to find out more. But ultimately, the management will very much be about the observation and measurement of physiological factors, where interaction with individuals will be less revealing, particularly if individuals sadly don't have anyone else who is actually their proxy or is caring for them. But when it comes down to it, in terms of thinking about the transparency discussions we were having earlier, how do we get this right, particularly in this area? How do we gauge feeling about this? And what can we actually do with this to make sure we're actually being much more detailed about how data is used? And when it boils down to it, how can we be meaningfully transparent? These are some of the challenges that we're posing. I'm hoping I can go some way to providing a basis to answer moving forward. But the other elements that apply to all applications of health are around how can we assure that data is not biased and lead to flawed decisions and diagnostics, and how do we know the damn thing works when it comes down to it? These are all very difficult to consider. So I won't spend too long on this slide. I'll just cherry pick a few points, because like I said, we've already had a rich discussion about the regulations. But to my mind, GDPR, I've never seen as a single tool. It's part of, it's one tool in a very large and complex toolbox. I prefer the analogy of a tapestry in terms of regulatory compliance. A tapestry of different laws, different case histories, different precedents, and different standards and considerations, where GDPR is most certainly not the only game in town, but it has emphasized the importance of protecting data, whether you're within Europe or beyond in terms of other countries and jurisdictions. But when it comes down to the automated processing, I think it's fair to say that the primary concerns when the European Commission drafted the first draft of GDPR were around the savings and loan sector, where increasingly data was being used to determine whether you got a mortgage or not. Nowadays, we're talking about whether a machine decides to dose someone with a different amount of oxygen when they're recovering from operations, or indeed offering diagnoses to people. So this notion of the closed loop decision making, where people have a right to ask a human to make that decision in broad terms, suddenly takes on a new perspective. When it comes down to it, if you were to deploy an algorithm, let's assume that it's passed all its EMA and CE marking requirements and so forth, the decision's already been made. The patient can't very well go back and say, actually, if you reverse that decision and can a human decide? So we need to bear that in mind. We have to make sure that there's a process by which we offer people the choice, or we're clear about where the algorithms need to work within the relationship and the intervention. So I think those kinds of smaller points or very focused points, I haven't heard of any encounters of that regard yet, but we can foresee that there are issues that are moving forward for that. So with GDPR 2, if there is a 2 or a GDPR 2.0, whatever you want to call it, we might want to address these in a little bit more detail with deference to rights and clinical practice. But as for other regulations and so forth, of course, we know about the CE marking and EMA and so forth. But also the big push there was, especially with the focus, if not obsession, with ethics in broad terms that we heard about earlier, in terms of looking at whether the use of AI was ethical and the kinds of concerns that raised. And that's where we saw various tech companies putting in ethics committees and ethics oversight boards and so forth. And between the various items of work on this, be it American, be it Chinese, be it European, be it Middle Eastern, broadly speaking, when I did a brief review of this last year, I counted about 75 different principles that had no real practice in terms of implementation. And then I thought, being generous, there are probably about 30 distinct different ones when it comes down to it. But if I'm being unkind, there are probably about 5 when it boils down to it. But what's useful about this exercise is how we might put it into practice. But then, of course, we have the regulations around traditional medical and scientific research that we've also talked about, between duties of confidence and research governance requiring ethics. But in a lot of cases, when you're looking to deploy a new algorithm, will an ethical review have been conducted? If you're able to justify the use of the tool within a particular context, it may be the case it's exempt from ethical review. This is certainly the case in England, and more widely across the other UK jurisdictions, and more widely across Europe, where in America in particular, there have been concerns around being able to find people who are competent and available to be able to do any kind of ethical review with any kind of heuristic. So we do have issues there, absolutely. But we know that there are challenges for AI already, partly through this ethical consideration that's been ongoing for a few years, but partly through putting things into practice. So we know that the data may be not representative of everyone. It may favor a particular group. And is it representative in the context of use? So if you've done your machine learning algorithm training on a predominantly white male population, how can this apply to a Middle Eastern female population? It obviously can't. There are issues there. Is it accurate? So is the machine learning that's been performed accurate to begin with, but also decision-making, is that fair and reasonable? And how do we judge that? And where's the equity here for everyone concerned? It's patients' health after all. It's their medical professionals' logging of data and considerations there. So if we are going to feed this data into these machine learning algorithms, what are they getting back individually? There is still a balance there to be struck. And it's great to be altruistic and say this is for the good of society and so forth, but at the same time, if you hadn't been asked permission and you found that this had been used to save other people, how would you really and honestly feel about it? Certainly where you're either caring for someone with Alzheimer's dementia or have it yourself. Is it safe? So are we going to be able to make clinical decisions upon this? And can you explain what on earth is going on under the bonnet, so to speak? So the black box nature of these algorithms mean that it's very difficult to explain in certain circumstances and certain cases, but should we even try? So there's something to table just for a moment. And how can we be transparent here? And is this for societal good or is this purely for profiteering? So these are all important challenges for AI. How do we start to look at these issues? So by no means is this a shameless plug. I was interviewed on ITV Tonight back in February, and the show actually aired about a couple of weeks ago. And my feeling was that even though I'm only in it for about a minute, if that, but the other speakers and interviewees, I think, frame this area really well. When it boils down to it, in healthcare, we have real challenges and critical game-ending challenges. We have real capacity problems in terms of professionals who are able to deal with the workload that is before them. We have cases of human error where clinical error has come into play and disastrous results have happened. There's an absolutely heartbreaking story about this within the report. There are concerns about clinical safety and the efficacy of traditional approaches to medicine and treatments that we have to contend with. But there's also a developing area which I think gives us some hope, where in England in particular, our national data guardian, Dame Fiona Caldicott, has launched a consultation about how we might embed reasonable expectation within law. So what might an individual reasonably expect in terms of data use? This is often something that English courts will go back to and data controllers will go back to in terms of what might be reasonably expected in terms of data use when other answers aren't so forthcoming. So just to put a frame on this, I think this would be, if you've got a spare 30 minutes, I would see if you can access this and have a look. So I think this framed the entire area really well. And I had no idea what the other interviewees had said. So I think this is important to bear in mind in terms of how the public are actually viewing this kind of area in terms of AI in health. So I talked an awful lot more generally. I think within the area of virtual brain cloud and in terms of the work that's being done, it's absolutely heartening to see the level of detail that people have worked with in terms of applying GDPR and its principles, as well as being mindful of the context within which the algorithms are being scanned and which are being used for research. And this is a shining example of the way things need to go. It's an awful lot of hard work, but other initiatives like this can learn a lot from us. But here's something I would like to propose in terms of moving forward. When it comes down to it, artificial intelligence cannot replace natural people professionals. So you will always need a doctor, a human doctor, in position to be able to interpret things and ultimately make decisions in partnership with the patients as to what's best. But AI can certainly support them, particularly when they might miss something, particularly when the research being undertaken within the virtual brain cloud can provide new insight that a human simply could not have retrieved by thinking about it. But when it comes down to it, in order to train things up, I've looked at this area by thinking that AI and algorithms are autonomous agents when it comes down to it. We can't very well explain why it reached a decision any more than we could do a scan of a human doctor to determine how they managed to reach a diagnosis. We rely on their training, rely on their experience, and their ability to justify themselves. So if you are going to train algorithms, let's train them, let's educate them, and let's examine them. Let's make them sit an exam. Let's see how they perform in different contexts. Much like a trainee doctor will be put on wards, only we can do this in simulated environments. And much like a human doctor will sit an exam and actually answer questions about this. So why don't we think about that as a possibility to be able to assure the technology and the approaches, particularly if we are having trouble explaining how it works. So, but otherwise, the CE marking process, as it stands, will really struggle to assess these complex heuristics. And you'll spend months, if not years, looking through each process, trying to test things out in that regard. Now, it's not impossible, but should this not be part of the ability to say, well, the whole is more than the sum of its parts. So let's look at it in that basis. Let's make it do an actual test in context without making it too singleton or piecemeal. But on that note, I'm going to end. So why don't we have a school and exams for algorithms? Why don't we have the educational approach? But for heaven's sake, thinking about the UK's recent experience, let humans judge them and mark them. Let them make the final decision. This will guide the transparency and the understanding that we can purvey to data subjects and the public more widely, but it will also assure codes of practice as well, which we've identified as important tools in this space. So on that note, I've got to start my stopwatch, so I hope I'm not too late. I'm going to say thank you, and I shall look forward to questions.
Yeah, thank you very much for your challenging and thought-provoking presentation. I think we should just continue with André Gemünd. I guess you can share your screen now, if you're ready.
Okay, thank you. Let's see. Now, hopefully sharing the right screen. So, do you see the presenter view or the full screen presentation now?
We see the presenter view at the moment.
Okay. That's better now?
Yeah, it's now perfect. Thank you.
Okay. So first, thank you very much for giving me the opportunity of presenting our work here that we do in TVB-Cloud. My name is André Gemünd, and a little bit of background. So as was introduced already, I'm working for the Fraunhofer Scientific Computing and Algorithms Institute, and our department focuses on distributed infrastructure projects, mostly HPC, high performance computing, cloud, and big data infrastructure, for example. And we usually deal with cross-cutting topics like scale out, authentication and authorization infrastructure, automation, issues of information security, and so on. We are also active in research projects on European and national level, and there are some examples on this. Notably, for example, Cloud for Health, one prior project in the medical area. So what is TVB-Cloud? That has already been introduced just shortly. The project is developing a cloud-based platform for personalized prevention and treatment of neurodegenerative medicine and the integration of multimodal data. And when we're talking about the concept of TVB-Cloud, we're talking about a platform that integrates a lot of components into a collaboration portal accessible by end users and an underlying cloud-based, secure, and trusted IT infrastructure. We from Sky, we are leading the work package that is about implementing the secure cloud-based infrastructure. So how does that look like? Well, it ensures information security and data protection based on principles like confidentiality, integrity, availability, transparency, intervenability, and unlinkability. And to make those principles tangible, it's required to have organizational and technical security measures, which are usually embedded in a concept, in an information security management system. And the sole implementation of one of these is hopeless and not effective. you need to deal on all of these levels at the same time. And there are many well-known approaches on how to implement such systems. For example, the ISO standard on information security management systems. In TVB-Cloud, we compose a set of technical security measures on different levels that are involved. And we primarily drew upon experience we gained in prior projects, guidelines that were proposed by the German Federal Office for Information Security, BSI, and the fantastic support by our colleagues from the University of Vienna. So considering that we are already at an advanced point in time on Friday afternoon, we thought we'd approach this in a little bit of a different manner, hopefully also with a little bit of entertainment. And we want to present challenges putting data protection into practice, and especially 10 gaps between theory and practice. A little bit how we, well, the things we met when implementing in TVB-Cloud until now. So in theory, we should be easily able to decide if data is personal, right? Well, that's what we thought. That's not clear at all. I mean, there have been multiple examples today already. And for example, we had this, I think, derived data from machine learning models. Do they count as personal data or not? It's not always clear. Often it's completely unclear. And there are even differing opinions among scientists about this. And there's also the factor of changing state of science and technology. So what's known today is not necessarily true tomorrow. What's the consequence of that? Well, there's a lack of a decision basis. We don't know how we need to act based on that. And changing requirements obviously complicates the development of the platform and the infrastructure in the project. And the worst case being that the changing requirements lead to a uselessness of the infrastructure solutions. They are not fit to what we need anymore. A second one, data protection officers are easily able to assess if data is appropriately protected while it's being transferred, processed, and stored on external infrastructure, right? That's the theory in GDPR at least. Well, in practice, only few DPOs are really also IT infrastructure and cloud experts. And this is not in any way meant negatively on DPOs. It's just if you have ever tried explaining your parents that you're working on a microservice architecture hosted on a Kubernetes cluster running in the cloud, then you should know how hard it is to have this kind of cross-disciplinary communication. And because of that, DPOs often rely on existing evaluations, let's say levels of security that have been set by other evaluators, or approval by third parties. And that also favors well-established technologies because it takes time to get these evaluations. So the consequence is that DPOs may be reluctant in making available data or signing some of these things, sharing data. I think we've heard this point already today as well. And it might hinder the introduction of new innovative technologies that are not yet well known, not widely known. The next theory is, well, we simply apply data protection measures, as Article 6 GDPR says, for example, appropriate safeguards, and all is fine. No need to worry. Well, in practice, protection always leads to trade-offs. The security leads to trade-offs. I've shown this triangle on the right-hand side. You can choose two: performance, reliability, security. It may lead to uneconomical data processing, performance problems because of the introduced additional security measures. And there might even be conflicts between security and applications. So there's a compromise required here. It might be that accessibility, generality of the solutions, performance, etc., will suffer. For example, you might not be able to share all the data. You might not be able to share algorithms. You might not be able to have workflows where you reuse results of prior processing and so on and so forth. And obviously, yes, it might happen that security measures completely prohibit applications or make it impossible to process in the way that you want to. The next one is, okay, we solve these security issues once for our platform, and then the scientific data management and stewardship for whole communities solved. So will be once we implement these security measures, all is well. That's not the case in practice. This it always needs case-by-case evaluations. And one example is, I think we've heard this also today multiple times, that you need to set the purpose of processing. And simply changing the purpose of processing might influence the lawfulness of the processing. There's also the case of having different regulations per country, even per state in Germany, and so on and so forth. So it's impossible to solve it once and just have it for all use cases all over Europe. So that's what I call here no free lunch. There's no technical one-off solution to deal with all of these issues. And yeah, there will be bilateral contracts required between the involved parties. And then once we have these bilateral contracts, we can of course track them automatically. Well, unfortunately, that's not as easy either. There is a lack of machine readable and processable standards for contracts. This is a very hot research topic. You've probably heard smart contracts and so on. So at the moment, there's no, let's say, widespread, easy to use solution that we can apply in TVB-Cloud. And the implementation of such a mechanism is extremely complex in itself and matter of research, as I've said. Obviously, the development from scratch would be out of scope for TVB-Cloud itself. Well then, cloud providers, commercial cloud providers like Amazon, they should have all of this solved, right? We can just use them. Well, no, not at all. They face the same challenges, the gaps between law and technical implementations. There are no technical blueprints that they are just applying. And I mean, they do a lot of marketing, but that doesn't mean that they have everything solved. They actually also have commercial interest in data of all kinds. So it's questionable if you should trust them more. And there's also the cross-border challenges, very famously now the end of privacy shield. So you don't know where data is processed with a lot of commercial cloud providers. And only because it's commercial doesn't mean that they solved everything. Well, then let's use certified cloud providers because they should be sufficiently secure. In practice, that's unfortunately not the truth either, because certificates usually, well, there are different ones, but the most famous ones usually don't give you information on how secure the infrastructure itself is. They're most of the time rather about how security is measured and managed security processes. For example, the ISO standards, I've mentioned before, they're about managing security in repeated processes, always doing self-auditing, visiting your rules once per year and so on and so forth. So solely making use of those providers doesn't guarantee data protection either. It might be required that the providers have these certificates, but not sufficient. What about scientific cloud providers then, like the European Open Science Cloud? They don't have a commercial background. Well, in fact, there's no difference at the moment in law between commercial or public providers, even the European Open Science Cloud. Most of the providers that are in European Open Science Cloud at the moment are not in general prepared for processing personal data. Some of them excluded in their terms of use. And very few of them offer certification. So what's the consequence for TVB-Cloud? The consequence is that we do a best effort security implementation to be as secure as possible, to implement as many security measures as possible. And we offer transparency. We document it transparently and implement these technical security measures following best practices and European or national standards. We also offer to, for example, to inspect premises through auditing. So this is to build trust from the users. And as said before, we're introducing these bilateral SLAs or contracts. Another theory, supercomputers are inherently secure enough for data processing because, I mean, they're supercomputers, very expensive, very special hardware. Well, unfortunately, that's not the truth either. Supercomputing centers, for example, from the PRAISE initiative, are not generally prepared for data processing personal data. So it's often excluded in terms of use that you can't use personal processing, and they've simply not met this requirement very often until now. So there is a lot of initiative here, as was also presented by Professor Ritter, but it's not generally there yet. One of the challenges is that public supercomputers are shared resources. They are shared between a lot of different researchers at the same time. If we want to get a little bit technical, for example, the files on such supercomputers are usually stored in very high performance shared parallel file systems. And that means your data will basically reside next to the other researchers' data. So it's a multi-user shared resource. So exclusive resources would be possible, but obviously very expensive. So what's the consequence? As has been shown before, there is the possibility of using supercomputing, but it is mostly for anonymous data or adding adding a lot of additional security measures like the secure containers that have been shown before. And yes, the exclusive usage is possible, of course, if you have dedicated hardware. One other theory is that you can simply move computation to where the data resides instead. So instead of moving data, simply move the computations. That's a good idea in principle, but usually you don't have the necessary infrastructure where you need to do these computations. So there's, again, initiatives to change that, as has been shown. There are new infrastructures are being introduced at the clinic sites, for example, so you can do this. But at the moment, it's not available everywhere, and it also needs a lot of investments into hardware and also into personnel maintaining these resources. And the results of such computations that you do might still be personal data. As said before, it's not trivial to judge about that. So there's still limited further use of these result data, and it will be hard to share. The consequence being, this is not a generic solution for all use cases either. It might be implemented in TVB-Cloud for specific cases, but it's not the one-off solution for all challenges. So that's the last one we wanted to show. Obviously, there are more. What are our conclusions? Well, one of the conclusions is the abstract terms in GDPR really complicated practical implementation. One famous example is the appropriate in appropriate safeguards. I mean, what is appropriate? Interdisciplinary knowledge and collaboration is obligatory in this. And there are neither technical nor regulatory one-off solutions. So it's much more complex than that. And in TVB-Cloud, we're building up experience. We are trying out approaches. We are implementing different approaches. We're implementing frameworks, and we're also giving examples to realize these scenarios. So thank you very much.
Yeah, thank you, Andre, for your very interesting presentation and the challenging comparison between theory and practice. If you could stop sharing your screen, then we can hand over to Angela for the final presentation of this session. So Angela, whenever you're ready, you can start. Thank you.
Great. So I hope you can see my screen now. Oops, sorry. Apologies. Let me just try and get rid of the Q&A window. There we go. Right. So thank you for the opportunity to speak, and to Professor Forgo and his team for organising and running an excellent meeting. And thanks to all the attendees for hanging on to the bitter end for the final presentation of the day. So my name's Angela Bradshaw. I work at Alzheimer Europe as a project officer, and I am responsible for the work that we're doing, or partly responsible for the work that we're doing on the Virtual Brain Cloud project. I thought I would, apologies. There we go. I thought I would start my presentation by setting the scene for the project from a demographic perspective. So as you probably all know, dementia is a multifactorial, complex and chronic condition, which is characterized by progressive memory loss and cognitive impairment. Crucially, there is no currently available disease-modifying therapy. And in the EU, a report that we published last year indicated that there are currently almost 7.8 million people who are living with dementia. The cost of that was estimated in 2008 at over 160 billion euro. And of this rather vast sum of money, about 56% of that is estimated to come from the costs of informal care. So women remain disproportionately more affected by dementia than men, and there are almost double the number of women relative to the number of men with dementia. And this, we believe, is in part linked to the greater life expectancy for women. So you can see from the table to the right, table 6, from that report, that the prevalence rates increased dramatically from the age of 75 upwards. In more positive news, however, several recent studies along with our survey indicate that there's been a reduction in prevalence compared to what was thought would happen in 2008. And in fact, we had indicated then that around 9 million people would have dementia by 2018. So you can see that there is a reduction. And this is believed to be linked in part to improved management of lifestyle habits, such as smoking, and better treatment of conditions such as type 2 diabetes and hypertension, as well as improved diagnostic methodologies. And these three things combined have made us a little bit better at identifying people at risk of dementia, but also at potentially preventing dementia from developing or reducing the impact of dementia in the people who are living with this condition. However, despite the reduction in prevalence, the number of people with dementia is still set to double by 2050, at which point it will have increased to about 14.3 million people. So I mentioned just then that there are now established modifiable risk factors for dementia. There was a recent update to the 2017 Lancet Commission on Dementia Prevention and Care, and they estimated that about 40% of the cases of dementia worldwide may be due to modifiable risk factors, such as lifestyle habits and treatable diseases. So this really reinforces the importance of early diagnosis for dementia prevention. So, and this brings me on to the project. So Petra gave a fantastic introduction to the project and described how it is set up and what it's aiming to do. But essentially, just to reiterate, the objective of the Virtual Brain Cloud is to develop and validate a decision support system. And it will do so by providing access to high quality multidisciplinary data for clinical practice, resulting in a cloud-based brain simulation platform with the aim of supporting personalized diagnostics and treatments for people living with neurodegenerative conditions such as Alzheimer's disease and Parkinson's disease. So as shown in this schematic, the Virtual Brain Cloud project will use data from research participants with neurodegenerative conditions with the goal in turn of benefiting those individuals. So we are involved in the ethics activities for the project, and I thought I'd start at the beginning. So trying to establish what we mean by ethics in the context of research projects such as the Virtual Brain Cloud. So on a fundamental level, clinical research generally should be robust, it should be meaningful, it should be valuable, and it should ultimately provide society with accurate answers to questions that are worth asking. So how can we make sure that clinical research is ethical? So several ethical criteria for clinical research have been identified to ensure that, as I mentioned, research should be robust, meaningful, and valuable. And these requirements are closely related to the medical ethics principles that were first described by Beauchamp and Childress in 1979, the principles of autonomy, non-maleficence, justice, and beneficence. So autonomy being the capacity to make an informed decision, non-maleficence being about avoiding harm, justice being about the distribution of giving everyone what they are due, so fairness, and then beneficence being about balancing benefits so that they are greater than the risks and the costs of research. And in a 2000 publication, Ezekiel Emanuel and his colleagues laid out 7 fundamental ethical requirements for clinical research, which are listed here. And I won't read through the slide in the interest of time, but generally, they all speak to meeting those 4 fundamental medical ethics principles. So either at a level of providing social or scientific value using robust methods, so in a valid way, making sure that participants who bear the risk of participation should be able to enjoy the benefits. And this means that individuals who participate should be able to directly enjoy the benefits. It's not all about societal benefit. From a more organizational perspective, studies should be independently reviewed, and obviously informed consent plays a really important part in these ethical requirements. So that's respect for autonomy and personhood. And individuals have to be provided with the information required to decide whether or not to participate. And this actually has specific implications when it comes to people with neurodegenerative diseases or dementia, because it means that we need to ensure that we as researchers adapt our consent methodologies and mechanisms to enable them to participate in research. We also have to make sure that clinical research respects those subjects, and again, that the risk-benefit ratio is favourable. So the topic of this meeting was the GDPR, so I thought I'd put in a slide about ethics and the GDPR. I'm not a lawyer, I'm not an expert in data protection, but it seems to me that when it comes to data protection, or at least when it comes to the patient privacy, data protection and ethics are somewhat linked. So I guess you could say that the GDPR applies a human rights-based approach to data protection. And actually, these rights are referenced in a few of the articles and recitals of the GDPR. Notably, Article 4 is listed here. So the processing of personal data should be designed to serve mankind, referencing the Charter of Human Rights and also the treaties, the foundational treaties of the EU, but also in Recital 33, illustrating the consent principle, and also importantly stating that ethical standards for research must be recognized and adhered to. And this really reinforces the fact that not all ethical principles are codified or depicted in the GDPR. So compliance with ethical requirements, as we all know, is pivotal to achieve real excellence in health research. And both the GDPR and also the EU and the funding bodies place a great deal of importance on ethics. So what does this mean in the context of the virtual brain cloud? So in creating the legal and ethical framework for the virtual brain cloud, we wanted to make sure that the people who bear the risks of research, in this case, the people whose data is being used to create these systems, are also those who will ultimately benefit from the research. And this is along in respect to the regulations and guidelines laid out in the Horizon 2020 manual for applicants, which says that there has to be a fair distribution of the benefits and burdens of research, and means that we need to perform a really balanced risk assessment about likely harm to the individual or his or her community versus our right to perform research for scientific or societal benefit on the other hand. So for those of you who are still around, I thought I'd put in a bit of live participation here. So if you have a phone, or if you're happy to do this on your computer or laptop, could you please go to www.menti.com, and when that window opens, pop in the code that you see there, and hopefully I should be able to. Here we go. Yeah, so I've switched the screen, right? So if you could answer that question in as few words as possible. So I'd like you to answer the question from the perspective, of an individual. So for an individual person at risk of dementia, what are the benefits and also what are the risks of AI in healthcare? And I'll leave this going for about a minute, and we'll see what this very expert and learned and intelligent audience comes up with. So you can submit multiple answers. So once you've submitted a few words, you can put more input in. Great. So here we have lack of explainability of the system, so that's a risk. Faster diagnosis, a diagnosis, which would be a benefit. Tailored solutions for specific patients, so personalized medicine. Improved and earlier diagnosis, balanced by the risk of false positives. Harm and stigma, yep. Constant monitoring, that's true. Having non-invasive tests is something that is of great value to people, especially older people who have often multiple comorbidities. But yes, over-reliance on AI outputs and under-reliance on human decisions is a risk. And actually, a good point, this may affect human knowledge and training in the future. So it's not just a risk when it comes to the individual who is being diagnosed with dementia via the AI system, it's also at risk to the system. So the healthcare training system and the healthcare system ultimately as a whole. Great. So thank you very much for your engagement. Oh, yeah, one last thing that's important. Knowing a potential decline earlier could be limiting life quality in the years before. So I guess that speaks to stigma. It speaks to the fact that dementia currently has no disease-modifying treatment. What are the real benefits of diagnosis when there's not a huge amount that you can do? So I'm just going to go back to the presentation now. There we go. So thank you very much for your engagement with that. So we took the approach of identifying the harms and the risks, or the ethical risks, in light of what we understand about what people with dementia would like to see in terms of benefit. So on one level, in the framework, we worked to identify general ethical risks for clinical research participants. So imagined on the one hand as ethical risks for the original participants who are contributing their data, but on another level as the eventual clinical research participants who might be testing and maybe even using the system as patients in a normal healthcare system. So some of these risks involved loss of privacy and confidentiality. We also felt that there are risks of physical and social harm as a result of participating in some of this research. So people may become fearful or distressed, particularly if they don't really fully grasp the implications of the research. And there may be problems also, there may be risks with inequity. So there may be unequal representation of a group of very heterogeneous individuals in research. On a second level, we identified some broader ethical risks of AI in healthcare. So very prominently, and something that was picked up by a number of you using the Menti system, the potential bias of the data chosen, the physical harms that might arise from erroneous decisions, so treating someone or not treating someone if they have been misdiagnosed. Loss of personhood was another risk, so seeing individuals as numbers, who also do we allocate responsibility to? So where an AI system is used to make a decision about healthcare, is there a different perception of who is responsible for making the ultimate decision? Is it the doctor? Is it the system? Is it a combination of both? And where does a person sitting in a clinician's office understand that responsibility to lie? And finally, there is also an issue with risk disclosure, potentially. So again, as I mentioned a few minutes ago, in the absence of disease-modifying treatment, what is the value? What is the benefit of risk disclosure? What can we provide? What is the benefit ultimately for risk disclosure for people who are at risk of developing dementia? And is it really justified from an ethical perspective? And based on these identified ethical risks, and this is an ongoing process, so this is a dynamic document that is still being shaped as the project progresses, we then identified some key ethical considerations for the project. So first of all, fairness and equity. So for example, we need to ensure that there's no bias in the data used to train the systems being developed. We need to ensure there's non-discrimination. This is also linked to bias. So people living with dementia or at risk of dementia have the right to be free from discrimination based on any grounds, including age, disability, gender, sexual orientation, health status. And then the two other principles or considerations, informed consent and privacy, are linked. So we need to respect their autonomy and personhood. So individuals should be provided with the information required to decide whether to participate or, in this case, contribute their data or not. And all measures possible have to be taken to ensure their privacy and confidentiality so that we can avoid discrimination and potential harms. And as I mentioned earlier, for people with dementia and other neurodegenerative diseases that are characterized by cognitive impairment, we've got to consider adapted measures for informed and ongoing consent, and whether the instruments for collecting this consent are really appropriate for specific groups. And going forwards, this framework will be further refined and adapted. So just to close off this presentation, I wanted to briefly introduce a topic that's closely related to ethics, the topic of public involvement, which is also known as patient and public involvement in some circles. So the strategic aims of Alzheimer Europe as an organization are to provide a voice to people with dementia and their carers. We want to promote a rights-based approach to dementia, and we also want to support dementia research among those aims. So public involvement, or PPI, is fully aligned with these aims, as it's defined as the involvement of people with dementia in research. And it's part of a more global aim to make sure that research per se is ethically sound. And this is based on an argument that by involving end users in research and in determining the way in which the research is carried out and the important questions to address, we will be able to more accurately identify the harms of research, as well as be more effective at guaranteeing the benefits of research for individuals. So public involvement ensures that research is done with or by the public, not to, about, or for them. So it takes them from a passive role to a much more engaged and involved role. It means that people with dementia actively and meaningfully contribute to the whole process rather than being a passive participant. And it means that we have to create a real partnership between people with dementia, researchers, and other members of society that are involved in research. And ultimately, the goal of public involvement is to enhance the transparency, validity, and legitimacy of dementia research. So on this slide, I won't read them out in the interest of time, but you can see some quotes from people with dementia speaking about public involvement and why they want to get engaged in it. So Angela, who is from Austria and is living with dementia, says that she is not ashamed of her condition. She'd like to speak out about it. And she feels that she's in a much better position to tell you or tell researchers about her needs, her demands and wishes. Juan from Spain would like to do something constructive. Doing public involvement was completely new to me. Now I feel like I'm doing something useful, and I'm pleased to be contributing in this way. And finally, Geert is actually highlighting one of the issues that sometimes crops up when planning public involvement in research. So I would normally agree to take part in lots of studies, but some state that you need to have a study partner. And even if they don't, I would need support. It's a shame, but that's the way it is. So it really emphasizes how we need to take people's needs, individual needs, wants, and desires into account to meaningfully involve them in research. So each of the quotes on the previous slide came from members of our European working group of people with dementia. And we founded, or Alzheimer Europe founded, the European Working Group in 2012, and it's coordinated by Diane Gove, who is involved also with the Virtual Brain Cloud, and Anna Diaz, who will be contributing to the work on public involvement in the project. So the working group is composed of up to 15 people with dementia, and each of these is nominated by a national Alzheimer's association. We make sure that they're fully involved in all our work. So for example, the chair of the working group sits on our board. Prior to COVID, the group would have 3 to 4 face-to-face meetings a year. Now they happen virtually by Zoom, and they happen much more frequently because that's what works best for them and for meaningful input. And as I said, they're involved in all our work and also contribute to many projects in which we're a partner. And the pictures show how the working group has evolved from 2012 to 2017. And the picture in 2019 was at a session that they ran at our annual conference. So if you'd like to read more about public involvement generally, so in the public involvement work that Alzheimer Europe has been involved in, but also in the words of the people who are members of the European Working Group, here are a few of the publications that have recently addressed this topic. And as I mentioned, that we are looking to do some public involvement work as part of Virtual Brain Cloud. So we look forward to updating you on this work in the near future. So with that, I'd like to thank you for holding on to the end of this presentation. I'd like to thank all the organisers again for inviting me and for hosting such an interesting and engaging discussion. And I would also like to credit the other people who are working as part of Work Package 2 on the Virtual Brain Cloud, including the team at Vienna, led by Nicolas, and at Alzheimer Europe, so our Executive Director, Jean, Diane, who's our Director of Projects and is our ethics expert, and I'm also doing some of the work. Thank you very much, and I'd be happy to take any questions.
Thank you, Angela, for your interactive presentation and the ethical input. I think we can now start with the discussion. I saw that there was one question from my colleague Paul that has been answered already. But maybe, Andre, if you want, because in lack of other questions, if you want, you can elaborate more, and maybe from the experience, before you start answering, if the experience we also get in the project is that sometimes it would be helpful to have sort of a tick box approach where we have a list, right, of measures. We say that's checked, and then we're complying with the data protection. But I guess that's
yeah, that would be the ideal thing. Yeah. Yes. But I guess, yeah, as I've shown, that's hopeless.
So maybe you see the problem not on that the lawyers or the policymakers are you know, lacking IT knowledge, but on the other hand, I mean, do you see in the future a way to say, okay, these are measures you need to impose? And what do you think with the connection to self-made code of conduct or certification schemes? I think that puts the responsibility sort of from the policymaker to the group of people where the law applies, if they make their own code of conduct.
Yeah, I'm not really sure if that will solve all of the challenges. As we've seen in TVB-Cloud, you can't lift all of the responsibility from, let's say, the provider of the resources, for example. So even if a processor has the contract with the data provider to be allowed to process data, you can't really exclude the provider of the resources where the computations run on. It still plays a role in it. And as we've seen with processing even data from I think it was outside of European, the source of data, and it was allowed to process it. But even though the data center had to allow processing, and there needed to be even the clearance of the ethical council of the provider. So I'm not sure if you can solve everything by this self-constrained rules. Regarding your first point, as I've written, I think there's room for improvement. So you probably know much better of how generic a law text has to be. I'm no expert on that, so I can see that it's a challenge, obviously, to generalize these provisions. On the other hand, as I've suggested, there would be room for official guidelines. That's what I think, official best practices. So they don't need to be, let's say, they don't need to cover everything. But I think at the moment we don't have anything at all, right? So we are on our own, or we have been, at least in the beginning. And I think at the same time, the projects we've seen today are already working on improving that situation. And we are working on best practices, solution blueprints, and so on. So we are already working in that direction.
Yeah, thank you. Petra, you wanted to contribute?
Yes, so I think actually we all are aware that these are really complex matters and they need a lot of interaction between many different competent stakeholders with different types of expertise. And projects like the Virtual Brain Cloud exactly have the aim to foster this interaction, because only together we can solve these matters and we can develop these guidelines. I think there is not really a problem with the law. The law is pretty smart. The more I go into this, I'm really very much impressed, I have to say. One can live very well with the law, and the law is made to protect the rights of the individuals, and this is a very valuable purpose that I fully support. The pleasant experience in the course of the TVB-Cloud is that one can coexist with this law, and there are solutions in place. It just takes a lot of time and interaction and talking and trying to understand, learning together to come up with these solutions. This includes, for example, here at the Charité side, a lot of discussion with the DPO, with the legal people, but also, of course, with the scientists who have the understanding of the data, who know the needs, for example, for the algorithms that have to run on the infrastructure, which again opens up doors for attack vectors. And then the computer science expert comes into the game to know what is possible there. And so I think really the interaction between these different groups of people, stakeholders, experts, is this what we need to solve this together. And this is actually quite an exciting way, I find. And so it's a good experience, but it's also hard work.
Yeah, thank you very much. I'm just checking, there's another question from Catherine. To Angela, what is your overall perception of the synergy between ethics and law from the point of view of the patient? Are they, in your experience, or do they work together in an effective and efficient way?
Thanks, Catherine. That's a good question. Yeah, I guess on one level, what that question is asking is whether all the things that should be covered by ethics are codified in law. I don't know if that's part of it. And from that perspective, I would say no, but that is to be expected. So ethics is something that's a very individual process. It's very personal. It's very malleable in certain ways. Although I did mention, most of my talk was about principles and fundamental principles of ethics, but the application of ethics and how ethics works in practice is not as straightforward maybe as lawyers would believe it can be, or maybe ethics operates within a different spectrum to law. And I don't know whether you can draw direct links between ethics and law in all cases. So on the other hand, from a data protection perspective, I think the GDPR does a relatively good job. If anything, it is more interested in protecting the rights of individuals. And this might be criticized from a research perspective. So as a former researcher, you want data, you need data to deliver that societal benefit. And I think as researchers, we can get away from seeing the individual because of the need for data. And what the data protection legislation does fairly effectively is protect the individual. So I think it depends on what aspect of law you're talking about and what specific ethical principles you're trying to address. Okay. So I think hopefully that's a woolly enough but precise enough answer to an interesting question.
Thank you very much.
Nathan maybe could also provide some insight there.
Yeah.
I was desperately looking for my raise hand button on my iPad, and I couldn't find it, so I didn't look too panicky. I was going to jump in, if I may, just to build upon what Angela's provided in terms of answer. So it reminds me of in late 2017, I attended a meeting at the EMA about anonymization and the forthcoming GDPR arrival in terms of implementation. And the European Commission gave a view on ethics with regards to GDPR. And I think they set it out for us perfectly. GDPR is a common sense law about data protection. It does not codify ethics, as we've been discussing. Member state law does, in effect. There are all various procedures across the member states with regards to ethics. But the balance always has to be struck here. GDPR does codify the requirement for ethics. Certainly, we've seen in the citations that Angela gave. But at the same time, no law should be explicitly codifying specifics around ethics. The whole nature of the endeavor with regards to ethics is to have an organic, independent view of what's being proposed. And if you start to skew that with legislative oversight, then you completely undermine the entire purpose of it. So I think the frustration is that on the one hand, with data protection by design default, the other speakers are quite right in saying that's a useful tool for actually building things that work. But ethics must share the journey all the way throughout. And as I was alluding to in my talk, the kind of consideration around whether independent ethics review is required or not, I think it wastes a lot of energy, because ultimately when it boils down to it, that organic human consideration actually advises us on how to build things effectively and usefully. So I think it's got to be at the forefront. It always has to be at the forefront. And if you're in the middle of building something, you should appreciate that, though not necessarily be able to take a view on that at the expense of the independent ethical review.
Yep. Yeah, and I would also maybe draw attention to the fact that there are different levels of ethical discussions that happen in research. So you have sort of more structural, technical ethical discussions, such as institutional review boards, you know, some of the more, maybe some of the data protection requirements, for example, which are very, I suppose, technical is the word that I would apply to them. But then on the other hand, there are these larger, more meta-ethical concerns, which are really about discussing morals, our own personal views, and the sort of fundamental ethical rights, the fundamental human rights that we have as individuals. So they are slightly separate, but they are interrelated, and law should give effect to both of those spaces.
Well, thank you very much. If you have any closing remarks, or if you want to give any, otherwise I would close this session and hand over to my colleague Emily and Nicholas for the closing remarks and farewell. So thank you very much for your presentation. It was a pleasure. Thank you.
Thank you very much, everyone.
Hi, Emily, the stage is
Okay, so I guess I will start then with the closing remarks. I would just like to start by thanking all of our speakers for their time and such fascinating and thought-provoking presentations and discussions today. I'd also like to thank our attendees for their support and in sparking such interesting discussions through their contributions. I think today, in bringing together such a range of experts and in emphasizing the interdisciplinary nature of data protection in the field of health and medical research, today's conference has certainly highlighted some of the key areas of growing research and technological development. I think, as well as emphasizing many areas which require more attention and research, and as we've seen today, possibly even further regulation. I would also like to thank everyone for coming together today remotely. I think while the initial plan was to have the conference in Vienna and to invite you all to our lovely city, and it is very lovely today, I think though through the use of technology, even in a time of a global pandemic and the adversity that comes with that, we've been able to adapt and continue to share ideas, which I think is really a credit to everyone here and everyone participating and contributing. So thank you. And as a last point, I would also like to take this opportunity to invite you to another conference which we'll be holding, which is the first conference on innovation and digitization in law 2020, which will be held on the 22nd of October of this year, which will also be held remotely. The focus of this conference will be on anonymization and pseudonymization and kind of general de-identification requirements that come with the GDPR. This will be a one-day event in which we'll have keynote speakers, a panel discussion, and an interactive session with young academics and experienced academics based on papers the young academics have submitted. So I'm sure there'll be some really great discussion there. So please see the events tab on our department webpage. And also my colleague, Catherine, I think will post the link and details to the conference here on Zoom. So please register and we look forward to seeing you all again. Yeah, so thank you again for all of your attendance and participation. I wish you all a lovely evening and weekend. And I'd just like to hand over to Professor Nicholas Forger. Thank you.
Emily, that's so kind of you. But the last words that I just want to make are the same ones that I had in the morning. Thank you so much to all our participants on all the panels, to all members of our audience, and to you, meaning you particular, Emily, you particular, Michael, and also very much Mariana, who is not present today, but who also did a lot of work. And last not least, also to Petra and all the other colleagues from the project with whom it's such a pleasure to work with. Thank you to all of you and have a wonderful weekend also from my side. Thank you. It's my role now to close the session, I assume, right? That's what I'm doing. So the session is closed. Thank you. Have a good weekend. Bye-bye.
Bye.